Goes back to the wind farm days. Really, really awful. Yes, we're done.
Everyone, is the microphone working? Can you all hear me? Can you hear me in the public gallery? No.
Very well.
Sorry.
That's much better. So getting used to the technology.
Okay, good morning, everyone. It's 10 o'clock and the inquiry is now open. Can I ask if you have a mobile phone that you either switch it off or you put it onto its silent mode? Usually I wouldn't ask if everyone is warm enough, but how cold it is outside. I think the room is at a comfortable temperature. It may actually get too warm. If it does, let me know, and I'll ask housekeeping to lower the temperature. My name is Richard McCoy, and I'm a Chartered Town Planner and a member of the Institute of Historic Building Conservation and the inspector appointed by the Secretary of State to conduct this inquiry. And the inquiry is into an appeal made by Bramley Solar Limited under Section 78 of the Town and Country Planning Act 1990 against the decision of Basingstoke and Dean Borough Council to refuse an application for planning permission for the installation of renewable LED energy. Excuse me, I have a cold which has just come on in the past couple of days, so hopefully my voice will hold up. LED energy generating station comprising ground-mounted photovoltaic solar arrays and battery-based electricity storage containers together with substation, inverter transformer stations, site accesses, internal access tracks, security measures, access gates, other ancillary infrastructure landscaping, and biodiversity enhancements, including a proposed forest, school, associated car parking and nature area. Now, the description has been revised and the proposals have been revised, and I'll return to that later in my opening. Can I ask a member of the council to give us the housekeeping arrangements for the inquiry?
So in terms of fire evacuation, there are no fire alarms scheduled for the duration of the inquiry. So if you do hear an alarm, please make your way to the emergency exits. So fire exits are located to the side of this room, and then you head into the reception and then out the front doors into the War Memorial Park. And then also just to note that the meeting is being webcast. And then in terms of health and safety, there are some wires and speakers in the middle, so just be careful to not go in that area. And then also to keep this walkway reasonably clear of chairs, so around a metre gap, because it's evacuation. And then this room can also be locked overnight. If you want to leave their stuff here, we will lock it. And then also the toilets are located where the elevators are in the reception area and the seating area. Yeah, that was it. Thank you.
Thank you. Is everyone clear on that? Yep. Okay, I'd now like to take the names of those who wish to speak at the inquiry. First of all, who appears for the appellant?
Good morning, Sarah. It may be that.
Do I need to switch to okay?
There you go. Yes, that's how it works. Good morning, sir, and everyone else. My name is Thea Osman-Smith, and I'm a barrister appointed on behalf of the appellant. Sir, I've given you an appearances sheet so that you should be able to see who everyone is. For everyone else, I'm assisted by Adet Chalabi, who's my junior and sits at the end of the table. I'm instructed by Robert Asquith, who's a planning director at Savills. He sits to my right and will also be giving evidence on planning matters and the planning balance. So you should have a proof of evidence and rebuttal proof of evidence from him. He's assisted by Richard Mears, who's a planning associate at Savills. In respect of my other witnesses, Alistair Kratt is director at LDA Design, and he's going to be giving evidence on landscape matters. Again, so you should have a proof of evidence and rebuttal from him. Gail Stoughton is an executive director at Pegasus Group. She'll be giving evidence on heritage matters. She's also provided a proof of evidence. Robert Askew is director at Askew Land and Soil, and he'll be speaking to matters of agricultural land classification and soil. And finally, Frankie Whitaker, senior engineer at ITB Energised, and he's given some evidence on grid connection, sir, that's contained within his proof of evidence.
Thank you.
So just in respect of the proofs of evidence, we do have copies of the rebuttals if you don't have those now in a hard copy.
Okay, I've just been given a file which I think contains everything, is that correct? And the rebuttals? Yeah. Okay, thank you. And who appears on behalf of the council?
Good morning, sir. I'm afraid it's another one of those getting used to turning the microphones on and off.
My name is Ben Hufer. I'm a barrister at Cornerstone Barristers, and I'm instructed by the solicitor to the council. I'll be calling two witnesses who you should have proofs of evidence from. First, Nigel Wakefield on landscape matters, who is managing director at Node Urban Design Limited. And secondly, Karen Tipper, who is a senior associate at Bell Cornwall LLP on planning matters. You also have a proof of evidence from Dr. Massey, and as has been indicated, he won't be called to give evidence given progress made between the local planning authority and the appellant in respect of heritage matters.
Yes, thank you. And who appears on behalf of a Bramley Solar Farm Residents Group?
I'm Richard Anstis, appearing for the Rural Seas Party, and I will be bringing witnesses Paul Machin, landscape, Professor Michael Fulford on heritage, then Simon Bailey on energy infrastructure and alternative sites, and Steve Spillane on community engagement and consultation is not going to be giving evidence, but is here today. And then Dr. Ian Bridges on soil and agricultural land use, and finally myself as planning policy and footpaths.
Thank you. And are there any others who would like to speak at the inquiry? You could raise your hand. Excuse me. Okay, I'll come to each of you in turn, but just to let you know what I'll need from you is your name and address, whether you are representing anyone or any group, and if you have the authority to appear on their behalf, whether you support or object to the proposed development, any qualifications you wish me to record, and indicate whether or not you'd be happy to answer questions on the evidence you give. And just to let you know, it's likely that I will hear your evidence today rather than at a later stage in the inquiry. So first of all, who raised their hands? Your name, please.
Anthony Durran, Councillor Anthony Durran. I represent Bramley Parish Council as their chairman and as a ward councillor, Bramley Ward. And I also speak on behalf of Councillor Tomlin, who is sick today and cannot attend.
And are you speaking for or against?
Against.
Okay, thank you.
Yeah.
Okay, are you willing to answer any questions on your evidence that may be put to you?
Anything I can, yes.
Thank you. So, are you wishing to present evidence in written form to the inquiry?
I've submitted evidence or submitted comment earlier on in the process, so you have everything.
I do have a copy of that, yes.
And myself and our neighbourhood developer.
Okay, so there's nothing specific to what you're going to say this morning that you wish to submit?
To give you residents' views on this.
Okay, thank you. And who else? Andrews, I'll come to you first. Here, please.
Councillor Graham Wright, representing Silchester Parish Council.
And are you speaking for or against the proposal? Are you willing to answer questions on your evidence? you. And do you have any written evidence, excuse me, you wish to submit this morning?
The council put the submissions into the associated with the planning application, and my points will be basically a summary of those.
Okay, so you'll speak to the evidence you've already submitted to the inquiry. Okay, thank you. And yes, your name, please.
Good morning. My name's Simon Mahaffey, local resident.
Thank you. And are you for or against the proposal?
Against.
And are you willing to answer questions?
I am.
Are you submitting any written evidence to the inquiry this morning?
I've submitted letters previously, but I just intend to make a speech.
Okay, and do you wish to submit your speaking notes and evidence?
I can, yes, if that's advantageous, yes.
Okay, can we get that copied for the other parties? In due course. Okay, thank you. Thank you.
Inspector, forgive me, I'm trying to juggle my day job, so I will be in the foyer. So I need, if that's okay with you.
Okay, well, I'll come to the timetable later in my opening, but we can, yeah, let you know.
That's very kind.
Thank you. You're likely to appear. Okay, thank you. Was there anyone else? Yes.
Morning. My name is Marshall Hall. I'd like to propose the development.
Okay, so Marshall Hall, did you say?
BLL, yes.
And are you a local resident or are you representing a group?
I'm not representing a group. I'm a local resident.
Okay, thank you. And you oppose the proposal? Is that what you're against?
Yes.
Yeah, are you willing to answer questions on your evidence? Okay. Have you already submitted a representation?
I've made, yes, 3 submissions. Initial consultation.
Okay. Are you wanting to submit written evidence this morning?
I'm not in a position to do so, but depending on the timetable, I could provide you with a summary of what I've already submitted.
Okay, well, that might be helpful to all parties if you can, even if it's handwritten, if you summarise what you have to say, we'll make notes based on what you say, but it's helpful to have a summary. Okay, thank you. Was there anyone else? Now, as I understand it, there is an overspill room in the building. Is that correct?
I think we've used it. There is an overspill.
Is there anyone in the overspill room who might want to speak a thing?
Not as far as I know at the moment, but we'll double check. When Jess comes back, I'll ask her to. I'm not actually sure whether the overspill room is. Sorry.
Okay, thank you. To all those indicated they wish to speak, I'll come back to the timetabling later in my opening, give you an indication of likely timings. Thank you. There is an attendance list. It's either circulating or it's on that small table in front of Mr. Anstice. Can I ask you all, we'll ask everyone in the room to sign the attendance list and to record on there, particularly those who have indicated they wish to speak, any qualifications you might want me to record in my decision that you feel are of relevance. So if everyone could sign the attendance list, there'll be one circulating each day of the inquiry, and make sure it comes back to me at the end of each day. Is there anyone from the press present? Okay, not in this room. There might be someone from the press present in the overspill room. Because I understand that the person from the press has indicated they wish to record the proceedings. Is that correct?
I've just sent somebody to check. It's the council chamber is the overspill, and someone to keep it in there.
Okay, we'll just say that the person from the council wishes to record it for their own use, obviously for reporting on the inquiry. Would anyone have any objections to the proceedings being recorded? Okay, I'll make sure it doesn't become obtrusive, but since the person isn't even in the room, that's unlikely to be the case. As was explained, The event is being live streamed on the internet. That goes above my head. I don't understand how these things work. But if people are in a Liverpool room or even watching at home, they can follow the proceedings live. As far as I know, it's not an actual recording, although it may stay on the internet for a while after the inquiry is closed. I'm looking to see if there is a board in the room who understands how these things work.
So I'm not going to say that I understand how these things work. But Catherine Fitzherbert Green, who
Catherine Fitzherbert Green, who has been dealing with matters on behalf of the council, has unfortunately come down with COVID overnight, so she's not here. But she will know the answer, and I'm sure will tell me shortly by email, because I know she's following online. It may just be that we're a bit slower at providing you those sorts of details, because we're getting instructions over email. Jeff Sullivan has stepped into her shoes very ably, but obviously then had to come up to speed with things overnight. But we'll check that.
Okay, thank you for that. And sorry, what was the document I've just been handed?
Copies of the speakers' data, public speakers.
Can I prevail upon you to give each of the parties a copy?
Yeah, sorry.
I'll keep one.
Oh, sorry, can I have that one as well? They're different people. Thank you.
And so just to confirm, there's no one in the overspill room at the moment.
Okay, thank you. Okay, can I have a copy of the council's letter of notification of the appeal?
So, yes, sir. Forgive me.
So Jeff Sullivan has just stepped out of the room with those copies. So as soon as she's back, we'll get them to you. Forgive me.
Thank you. I'll make a note to ask for those. I have copies of the representations that were made in response to both the original planning application consultation and to the appeal notification. And I rest assured I'll take these into account in reaching my decision. But can I check with all of the parties that you've all seen these representations?
Yes, sir.
I believe we have, sir. Thank you.
Yes, sir.
I'm back on the 26th of October this year. I held a case management video conference call with representatives of the appellant, the council, and the Bramley Solar Farm Residents Group. The purpose of that meeting was to discuss the procedure for the inquiry, and the merits of the appeal were not discussed. What we did cover was confirmation of the advocates, the likely main issues that we would cover at the inquiry, how they would be dealt with, conditions, any likelihood of a planning obligation, the core documents, the inquiry venue, the timetabling and running order, and any likely cost application. And there was a summary note produced, and I believe that appeared on the council's website. And can I confirm that I now have the full proofs of evidence, including the rebuttals from each of the parties, and I presume you've each seen each other's proofs and rebuttals, and you all have a copy. If it's helpful, I'm happy that since we've all read these documents, they can be dealt with in summary or conclusion when we come to deal with them at the inquiry. Are there spare copies that we can make available for members of the public to consult?
So I believe up there is one set of core documents, which I think are the public copy, which I think have kindly been provided by the appellant. So have I got that right? So that is the copy available for the public. They're also available online electronically, both on the council's website and a website hosted by the appellant. And I'm sure we can provide the details of those websites for anyone who wants those.
Thank you. So the hard copies of the documents are on the window ledge, so feel free to consult those during the inquiry. Sorry, I seem to have a comedy chair. Lower and lower. I'll flip this. It's quite high. I'm not almost on the floor, which will look good on the live stream. So I'll sort that out in due course. Can I turn now to the procedure for the inquiry? I will follow the 2000 inquiry procedure rules. They are the Town and Country Planning Appeals Determination by Inspectors Inquiry Procedure, England Rules of 2000. So when I've completed my opening remarks, I will invite the appellant, the council, and then the Bramley Solar Farm Residents Group, each to make a brief opening statement, and that will help everyone to understand the main arguments at the inquiry. I think at that point, it's been agreed to hear from the interested parties, that is, those who've indicated this morning that they wish to speak at the inquiry. Does that pose anyone who raised their arm to speak any particular problems? Is everyone able to speak? That will be coming up, I would imagine, before we break for lunch today. Okay, everyone seems content with that. Thank you. And as I pointed out earlier, those who give evidence will normally be expected to answer questions on their evidence from the appellant's advocate, and I may also have some questions. Now, as agreed during the aforementioned case conference video call, we discussed the main issues, and arising from that, the main issues were identified as the effect of the proposal on the character and appearance of the surrounding area. So that's looking at the landscape issues. We still have the second main issue, which I'll come back to given what's just been said, but that is the effect of the development on the significance of nearby heritage assets, including below ground archaeology. And any Latin scholars in the room, forgive me, but I'm going to strangulate the Latin language. The scheduled late Iron Age oppidum and the Roman town of Caliva Atribatum, if I've got that correct, and associated features. The grade 2 listed Minchens farmhouse and buildings at Lower Farm and Old Meadows and the Silchester Conservation Area. It may be helpful just to briefly deal with that second main issue, because obviously the residents group have raised concerns in terms of the heritage, but from what Mr. Defoe said, the appellant and the council have reached an agreement on that. Can I turn to you first, Mr. Defoe, just to give the background to that?
So yes, of course.
So yes, there have been discussions between Ms. Stoughton and Dr. Massey ahead of proofs of evidence being prepared and a statement of common ground agreed around the same time. I'll deal with this more fully in my opening, but that statement of common ground sets out an agreed position between the appellant and the local planning authority in respect of each of the assets that you mention. In the main issue, I understand that main issue remains between the appellant and the Rule 6 party. So I don't suggest that it goes away as the main issue, but it's not one that the local planning authority maintain. If that helps, I've dealt with it more fully in opening, so perhaps I can just, when we come to my opening, we can deal with it in more detail then.
Okay, thank you. And Mr. Anstis, did you want to say anything at this point on that second main issue? Oh, sorry.
Only that my understanding is that the local planning authority still have remaining issues on heritage. It's just that Mr. Massey is not appearing.
Thank you. And Ms. Osmond-Smith? Oh.
Quite all right, sir. Well, I leave it to the council to characterise their position. It's not that there's still a remaining point between the main parties on this, and the council is simply choosing not to call their witnesses because essentially the parties are agreed that subject to condition there won't be any harm to below ground archaeology. And insofar as the listed buildings are concerned, the harm falls at the lower end of the less than substantial harm spectrum, such that it's outweighed by the public benefits of the scheme. So that's the position reached between us. I have no difficulty with it remaining a main issue, and certainly there's going to be discussion as between us and the Rule 6 party as to heritage matters.
Okay, thank you. And that can be further clarified in openings. Can I just check, am I pronouncing your name correctly? Is it Mr. Foe or Mr. Foe?
Defer.
Okay,
But Defoe, whatever comes.
I beg your pardon,
I don't mind.
mispronouncing.
Sometimes I give up on knowing how to pronounce my own name, so it doesn't matter.
In terms of dealing with the main issues, we're going to deal with them on a topic-based approach, which means dealing with each one at a time. The council witness will go first for each issue. The appellant's advocate will then have the opportunity to cross-examine each of the council's witnesses. And the council's advocate may then put some further questions to their witness in what's known as re-examination if they feel that's necessary. The witnesses for Bramley Solar Farm Residence Group will give their evidence next, following the same procedure. And then I'll ask the appellant to present their evidence in the same way, that is what's known as evidence in chief, cross-examination by the council and the residence group, and then if necessary, re-examination. Those who've indicated they wish to speak, you would also, if you wished, be able to ask questions of the opposition's witnesses, if I can put it in that way. Will you all be able to attend for the duration of the inquiry? Anyone have particular time constraints?
I can't definitely do every day. I have a couple of hospital appointments coming up. Do my best to be here as much.
Okay, well, it might be helpful if you spoke to Mr. Anstis in that case. If you did have questions you wish to ask, please. Okay, and start. Okay, and
I have some work commitments, I'm afraid, so I can't attend throughout the inquiry, but I'd like to make a contribution on selected topics, so it's possible to discuss when they're going to address. I will make sure I'm here.
okay, we'll come on to the timetable in a few months. Thank you for that. Okay, now on the additional issues raised by the residents group, I'll hear from the group first. Those matters giving evidence in chief, followed by cross-examination by the appellant's advocate. And well, to cut a long story short, we will follow the same procedure for that. Now, once we've dealt with all of the issues, I will hear a discussion on conditions. Now, that's standard procedure. It doesn't indicate that I've made up my mind on this case. It doesn't weaken the council's opposition or anyone else's opposition to the proposal. It doesn't mean that the appellant's case should be granted. None of that is a foregone conclusion. It's just that we have the opportunity within the room by way of a roundtable session to discuss any conditions. Can I check with the parties? We have what's known as a statement of common ground, and I'm looking at the statement of common ground between the council and the appellant. And there is a list of conditions within that document. If I come to the council first, is that list reasonably up to date?
So I think matters have moved on somewhat. We had an updated set of conditions, but I think there is agreement between the local planning authority and the appellant as to conditions. My understanding is that the Rule 6 party has some comments on those, and so having discussed with Ms. Osborne-Smith, what we propose to do is to prepare a table which has the agreed conditions as between the local authority and the appellant, and separately alongside it the conditions as suggested by the Rule 6 party, so that you can see where the differences lie. I think that's hopefully been done today, and we can provide you with an updated version. Matters have moved on. I wouldn't like to try and tell you precisely where they've moved on at this stage, but that we can sort out for you today.
Thank you. Mr. Anstice, is that your understanding?
I've not seen anything different other than the previously submitted set of conditions which had the Rule 6 party comments against it, which I think has already been sent to you. I haven't seen anything else beyond that.
Thank you. And Ms. Osborne-Smith?
The conditions. So as I understand it, you were sent 2 lists of conditions, and some of those had been track changed by Mr. Anstice, and they also had red comments underneath them as to what the appellant's position was on those proposed amendments. There's 2 sets because one relates to the original scheme and one relates to the amended scheme. But it struck me that actually that's potentially not the most helpful way presentationally for you to receive and understand those conditions, which is why in discussion with my learned friend this morning, we're going to provide you with a table so that you have sort of a clean version of the conditions agreed. Then you have what the Rule 6 party are proposing alongside it, and then we'll provide our comment in a separate cell alongside that. So at least it's very clear where the differences are between the parties.
Okay, thank you. That's helpful. Mr. Anstice, were you wanting to comment on that?
As long as it's clear, we have no objection to that.
Okay, thank you. On that point, in terms of dealing with the statement of common ground, has there been an update to the statement of common ground between the residents group and the appellant? Because I found the one that had been submitted quite hard to follow. Again, because it's kind of track changes and lots of comments in the margin. Can I come to you first, Mr. Anstice, and I'll come to you, Osborne-Smith, and just get views on that?
So the latest version that's been that was suggested by the Rule 6 party is with the appellant, has been with them for a few days now. We haven't had any response to that.
So yes, work ceased on that effectively because it was clear that we weren't making headway on the common ground between us, and it became a fruitless exercise, and attention needed to be diverted towards preparation for the inquiry. So that, unfortunately, is the position that we've ended up in.
Is there any chance of a document emerging during the course of the inquiry, or are we at an impasse as far as that's concerned? Shall I come to you first, Mr. Anstice?
So the version that went back to the appellant, we haven't been told that is not, that's stopped. That's the first we've heard of it. So I think that document will be the latest version, and we propose that that's put before you as at least the starting point, so you know where we have got to.
Sounds good.
I don't think it's necessarily helpful to put draft versions of anything before you that's not agreed, sir. It's too confusing to show what the parties agreed. I'll speak to my team, but of course inquiries are intense processes, and attention has to be put into this process rather than a peripheral process that might not yield anything useful. So perhaps I can have a word with Mr. Anstice, and we'll see throughout the course of the inquiry if we can reach any common ground, but I'm not terribly hopeful, if I can put it that way.
Thank you. In terms of further applications, while I'm not inviting applications for costs, if anyone does intend to make an application, it shouldn't be done before I close the inquiry within this room. That will then bring us to closing submissions, which will obviously be done in writing. First of all, begin with the council, then the residents group, then the appellant, I'll come back to the timetable. I keep promising to return to the timetable. I will do it in a few minutes, but I will allow time for the advocates to write up their closings, so you're not missing the World Cup final and to furiously scribble that weekend. I have, if I could turn now to the site visit. I visited the site unaccompanied, so I'm reasonably familiar with it and its surroundings. However, I will make a site visit after I close the inquiry. So I'll be flexible on that in terms of where we are with the closing remarks. Maybe we do the site visit before I hear closing remarks, but I'll come back to that in a moment. Can I just give some background details to how I will conduct the site visit? First of all, the parties have been helpfully working on an itinerary, which has recently again been updated. So I have had a look at that. Can I ask, is there someone appointed either from the council or the appellant's team that's looking after the site visit itinerary that I can call upon during the course of the inquiry?
So that would have been Catherine Fitzherbert Green, but we'll endeavour to have that covered. I do have a slight update to the itinerary, if it's helpful, and that is I understand that PINs have been notified that certain residents want their properties visited. What we've done is to draw on what was the agreed itinerary or just mark where those properties are. Mr. Anstis has indicated to me that there was one further that he's aware of. So it may be that more come out of the woodwork and we can update it. But if it's helpful, I can provide this to you now, or you may want it at a later date, don't know.
Well, to come forward after we've had our mid-morning adjournment. Yes.
I've got copies now. I've got copies now, but I can hang on to them until later if that's helpful.
Okay. Well, I was just going to check one further thing because yes, another request came through yesterday. And in terms of the requests that I've had so far, can I just check that you have a request from Mr. Lee Harrison?
One of those things that Miss Fitzherbert Green will know off the top of her head, but I'll have to check.
Oh, sorry, I thought it was perhaps written on a document you have in front of you.
I've got the names of the properties. So I've got Pound House, Old Meadows, Park, Farm, Brookhill Grange, and I think that the one that Mr. Anstis mentioned to me was Minchens Farmhouse as well.
Okay, yes, they are the addresses I have as well. So that would seem to be up to date, Mr. Anstis. Can you confirm that?
Yes, what Mr. Defoe said is correct. Just don't want to let you forget, sir, that the Royal Six Party put forward their own route as an alternative for you. And obviously those house visits could be incorporated onto that route. The other route is agreed between the other two parties, not with us.
Okay, well, it would be helpful to me.
Apologies, Brookside Grange, is Brookside Grange is the other property as opposed to what was said.
What I'll ask the parties to do, and I would like all of the parties to be involved in the process rather than two parties agreeing and another party coming back saying we don't agree. Can I ask that you use your best endeavours to come up with an agreed site visit itinerary? I'm happy to take the day after we close to do the site visits. I'm conscious of the time of year, and we're up against the clock in terms of daylight hours. So I would be happy to do that on Thursday. Although if it assists the inquiry, I'm happy to do the accompanied aspects of the site visit before the closings. It gives the advocates more time to write up the closings. And then on Thursday, to do an agreed, unaccompanied site visit itinerary where I can go off and at my own speed, walk along footpaths and take in viewpoints, etc. So it would be helpful to me if the parties could get together and agree that itinerary. the nature of the site visit is that I won't hear further discussion on the merits or otherwise of the proposal on site. There are some aspects of the site visit which will have to be accompanied, and what that means is I'm accompanied by representatives of the main parties, and other people have expressed an interest on specific parts of the site visit. That's usually where I would enter private land, because I can't do that on my own. The unaccompanied part of the site visit, as I see it, helps me because I walk at a fairly brisk pace and I don't want a long crocodile of people behind me. Frantically trying to keep up. So if I can be allowed to go off on my own with a list agreed between the parties, I'll take in the various viewpoints that have been drawn to my attention. And I'm quite sure as we have our discussion during the course of the inquiry in this room, that other suggestions will come forward for the site visit itinerary. So it'll be a live document which we will update. In terms of the accompanied site visit, is there anyone who particularly would want to come along on the accompanied site visit? Okay, there's one person. What would be helpful would be for each group to nominate perhaps one person, because if I'm going to look from private properties, the fewer people, in my experience, the better. But one person from each group would need to come along to accompany me. Can I ask, perhaps Mr. Ansis, you could do this, those who've indicated that they wish me to view from their property, could you liaise with them and explain that it needs to be an accompanied site visit at that point, and if they have any particular issues in terms of who they would invite onto their property? And if there are, we'll address that in due course. Okay, is everyone at the moment clear on the site visit? Okay, thank you. Okay, can we come to another matter that's been exercising me, certainly, if not others, and that is the actual timetable for the inquiry. There's, I would describe it as a double whammy, but there are several whammies that we're faced with. We're up against the clock in terms of Christmas looming large. Transport arrangements can be quite fraught, certainly this week. So I think we need to be very flexible with the timetable, but I would like to get it finalised, certainly by close of play today. For my part, I would prefer to have the conditions session towards the end of the inquiry, because I would imagine, given just how that the conditions schedule will be further amended based on the evidence that I will hear. And it's better from my point of view to hear the discussion on the conditions, certainly sometime next week, if not at the end of the inquiry. Does that pose any particular problems for anyone? Can I come to each of you and turn, Mr. Anstis? Oh, sorry.
We had a brief session at the beginning of this inquiry before the inquiry opened, and I think we have a solution now. So I think the scheduling can be agreed.
Okay, can I take that as the case for each of you? And move on to my next point in time too.
So we're very comfortable with whatever works for you in terms of timetabling. We haven't tried to stand in the way of anything on that, and we're happy to agree something. I think that the stumbling block has been between, no question either way, but the appellant and the rule 6 on that. But we'll happily agree conditions towards the end is absolutely fine with us.
Okay, and the next, sorry, you want to come in, Ms.
So yes, conditions towards the end is absolutely fine. We would of course welcome any preliminary observations that you have sooner rather than later in case any changes need to be made on that document. But subject to that, at the end suits us absolutely fine. In respect of the programme and running order, Mr. Asquith has continued to work hard on trying to figure out a way in which everyone might be accommodated at a suitable time. And we have a further draft programme having regard to the decision now not to call Dr. Massey, and in some respects that makes things work out a little easier. And that's the programme that I've discussed both with Mr. Anstis and Mr. Duffer.
That's the one that was sent through to the planning inspector yesterday?
Yes,
Just let me
correct.
pull that up again. What I don't have is a hard copy of that because I obviously came down yesterday. If it's possible to get a hard copy, that would be.
Of course.
Thank you.
Sorry about that. Just waiting for the shadow being to stop walking over.
You okay?
Yes, I'm fine.
Damage anything?
We'll see.
So this looks very similar to one that you would have seen last week already. And happily, we're on the first item, your opening. And that's sort of this morning's business together with the interested parties. We think that will take us up until about lunchtime. And then we're going to be dealing with landscape, and we think that can be completed by the end of the day tomorrow. That is all three witnesses who are giving landscape evidence. Then on Thursday, there was a slight issue about whether or not we were going to be able to start.
On that point, in terms of Friday afternoon, sorry, I've just got control of the microphone again, so can you hear me okay?
Yeah.
Yeah, sorry. Friday afternoon, I have a bit of a journey to make to get home. So it would be help me a great deal if we get up, start certainly before 5 o'clock. I know Friday's probably going to be quite chaotic on the roads, given what's happening with transport arrangements. Is there a chance of finishing early on the Friday?
So I think yes, probably with the timetable. Heritage will likely take the morning, but we've only got 2 witnesses now, and I think my time estimate for Professor Fulford was probably pessimistic, so I'll be able to bring that down a little bit. And then we thought if we could get through Miss Tipper probably in evidence in chief, and then draw up stumps for the weekend, and come back and recommence with cross-examination on Tuesday. So I think that absolutely is very doable to finish earlier on Friday.
Okay, thank you. So does that mean to expect a finalised version of the timetable sometime today?
I think that everything that has been said is the appellant's proposal, isn't it? So it may just be that we can agree that as the appellant put forward and not have to burden you with yet another version.
Okay. So if I put an asterisk against the middle column, this should appear on the council's website. Does everyone have access to the council's website? Most people are nodding. For those who don't, could I ask for further hard copies to be made available so people could take it away with them, just to see the timetable. And for those who indicated they wish to come along to ask questions of the appellant's witnesses, you'll be able to judge the timings from what's set out in the timetable. So make sure you take either a hard copy with you or details of how to get onto the council's website. Mr. Duffer, are you going to?
We'll make sure that happens. So yes. So can I just, is the site visit accompanied version going to be, we're sticking with the Thursday so far as we're aware at the moment. Obviously that may change, but just my witnesses travelling
travelling to attend that, but I just want to make sure that he knows when he's travelling, make appropriate arrangements.
Okay, well, in terms of that, I'm happy to be flexible. So it just struck me that it might be, if it helped with the writing up of closing for each of you, I'd be happy to do the accompanied part of the site visit on the morning of, whether it's the Wednesday or whatever, whilst you're finishing or putting finishing touches. And if there's no need for that, then I'm happy to do the full site visit on Thursday, including the accompanied aspects of it. And we can make that. I imagine we should be able to be definitive about that by tomorrow. If the parties can get their heads together on that. Oh, can I also then just take in your point, Mr. Smith, that you want a heads up from me on the conditions. That's a document that is very live at the moment, still being worked on. Could that come forward by tomorrow and the end of the day tomorrow?
Yes.
Mr. Anstis, would that be possible? Yes. Okay, thank you. So that leaves what's happening with Mr. Lowe. Mr. Anstis, can I come to you first of all to get your update on the Rule 6 position on that?
It remains the same in that we've requested him. He's not here. We'll do our best with the witnesses we do have. I think it probably goes more towards a cost award application in terms of how we treat it. I'll judge that as we go forward. If the other witnesses for the appellant are able to answer the questions that we would have looked to Mr. Lowe, then we may be able to avoid that.
So, Mr. Smith, are you going to make Mr. Lowe available to answer questions?
So the position is this. We approached Mr. Lowe to provide evidence on battery storage when it seemed that it might form part of the Rule 6 parties case. Now, you'll recall, and I think I made the point at the CMC, that the Rule 6 statement of case was pretty brief. So we were doing the best that we could with the material that we had. A coherent argument on batteries hasn't materialised in the proofs of evidence. So as far as we're concerned, you've got initial representations on batteries, you've got Mr. Lowe's response, and then nothing further since then. So we're content for you, sir, to take those matters in writing on the basis of the evidence that you've got. Straightforward point is Mr. Lowe lives a very long way away. There's not really room in the timetable if we're going to finish next Wednesday for him to be called, and some uncertainty as to when that might be, or at least until now there's been a great deal of uncertainty. So it's a pragmatic approach, I think, by the appellant to say, so you've got everything that you need in writing. I'm not sure what's to be gained by inviting Mr. Lowe to come along to the inquiry and give further evidence on those matters when we consider that you have everything that you need. I think, Sarah, as I wrote in my email to you, we've got a keen eye, first of all, on making the best use of inquiry time and assisting you in making your decision on those relevant matters that still remain outstanding between the parties. So on that basis, no, we don't see what is to be gained by calling Mr. Lowe. We're not proposing to do so.
So as it stands, Mr. Lowe is not physically, you're going to be physically present at the inquiry, but we will have his written proof of evidence before. And what you're suggesting is that it's taken as read, but Mr. Anstis does have particular concerns with it that they are addressed to me in closing. Is that how you see it?
So yes, that's how we see it essentially. You'll be aware there are a number of witnesses now who aren't giving evidence at this inquiry and have put proofs of evidence in. The simple reason being that it's not necessary to cross-examine every piece of evidence for you to make a decision based upon it. Unless you tell me that you want to hear from Mr. Lowe because there's some query or question that you have that he can assist you with, then it remains our position that he doesn't need to come along.
Okay, Mr. Anstis?
I don't think I have anything new to add. You see my submissions on this. I think we just agreed to disagree.
And you will put your concerns to me on the evidence in your closing?
Yes, and we will hope to be able to interview other witnesses who relate to that aspect to see if we can get the answers from them.
Okay. Just so I understand that point, in terms of the evidence of Mr. Lowe, is the case, Ms. Osmond Smith and others can deal with that?
Straightforwardly, no, because he's the expert on batteries. If there's broader questions about policy, so for example, Mr. Asquith has touched on policy relating to batteries. He's included some appeal decisions for sole battery facilities within his evidence, so you have those in the core document. If it's about those broader considerations to do with the policy around battery storage, then fine, because it appears in Mr. Asquith's evidence. But Mr. Asquith isn't going to start answering questions on Mr. Lowe's evidence.
Okay, so that I mean, then interrupt your questions at certain points, but I feel that it's going beyond the scope of the expertise of the particular witnesses on the stand. So you may need to deal with that in closing. So if you have concerns, and Mr. Lowe isn't coming forward to give evidence, and you have concerns with that, and you wish to contest that evidence, then you can address me in closing. I will take that into consideration as much as I take the written evidence of Mr. Lowe.
So we have no choice, so that's what we will do.
Were there any other points arising from the timetabling that I haven't touched on, Mr. Francis?
Yes, sir.
Mr. Liffer?
So no, only that I've got the notification letters now, if that assists you. I may not try and get through there and we come round. And I've got an update on the webcasting as well. The update on the webcasting is that it will remain as a recording on the council's website unless you tell us that you don't want that to happen, in which case we can make sure it doesn't happen, but it will remain available for viewing after the live stream.
Does anyone have any particular problems with that? Objections to remaining on the Ms. Osmond Smith, did I miss anything timetable from your point of view?
So I don't think so, no.
And that brings me to a housekeeping matter. Can I ask for a volunteer from one of the parties to keep a running total of the documents handed up at the inquiry? And if we can give them the reference ID for inquiry document and then just number them 1 to whatever. I would say 1 to 5, but that's being optimistic. Can we call this ID 1, which is the notification letters? Okay, let me turn then, I'm almost at the end of my opening remarks, to the plans and the revised details. First of all, looking at the plans, returning again to the statement of common ground between the council and the appellant. Can I take it that the list of plans in section 3 is up to date and correct? Mr. Firth?
So far as I'm aware, sir, yes.
Francis?
We were handed some plans earlier that would need some amendment. I don't know if they are included in that list, but I think the appellant is proposing to amend some plans.
Mrs. Smith?
So yes, we're not proposing to amend any plans that are going to be conditioned as part of the appeal. Those are the figures in Mr. Pratt's appendices that we've sought. I'll go through them in due course when we get to that point, but there are just some mislabelings and things like that, but they're not application plans and they're not going to be conditioned. So I think these are right, although I did spot there was an issue with one of the revision numbers in the conditions yesterday. So I'm going to ask my team to go through these and we'll come back to you in due course if there's any errors. But certainly the conditions set out those which are sensitive if permission going to be granted.
Thank you. I'm going to turn then to the description as revised. which is the installation of renewable LED energy generating station comprising ground-mounted photovoltaic solar arrays, battery-based electricity storage containers, together with substation, inverter transformer stations, site accesses, internal access tracks, security measures, access gates, other ancillary infrastructure, and landscaping, biodiversity enhancements in nature area. Can I turn to you first, Ms. Osmond-Smith, just to outline the differences between what was applied for and what's been revised?
Yes, so I don't know if probably the best way to do that is by looking at the evidence of Mr. Kratt. So yes, on page 31 is table 7.1, which sets out the amendments essentially in respect of landscape, or the landscaping. And at the point of appeal, what was changed in respect of...
Can you point out the core document number, please?
It's a proof of evidence. It doesn't have a core document number. It's Mr. Kratt's proof of evidence on page 31.
You got that? You got the document, Mr. Francis? Okay.
So yes, first of all, in respect of the substantive amendments to the scheme design, what we have is on the western edge of the solar array within field 1, that's the field over to the far northwest, there's been an increased setback of solar panels to the east of the public right-of-way. So they're pulled back away from that. And then there's an enhancement of landscape screening between field 1, southern edge, and field 2, the northern edge. So there's going to be hedgerow planting essentially between the two on the other side of the brook. And that's shown on the section drawings that I'll come to in due course. An enhancement of landscape screening between Brenda Parkway and the rectangular area left free of solar panels in the southwest of field 2, and between Brenda Parkway and the central western edge of field 6. So again, so that's just a bolstering of the planting that's shown on the landscape plans with both hedgerow and also trees. And an extension of the nature area over the area previously indicated as a forest school. And that's because the forest school has been deleted from the description of development in the revised proposals. The reason for that, so I think, is set out fully in the evidence, and particularly in Mr. Asquith's evidence. It's not something that the council put any weight on in their determination of the appeal. It wasn't something that was regarded as still compliant. And it was listed as or the council certainly regarded it as the potential for a forest school, but it wasn't one for which there was a demonstrated need. Essentially, no one wanted to take it on. So that's why that's been deleted. And the effect of that is essentially that area can now be used as an additional biodiversity enhancement area, which brings about better biodiversity net gain for the scheme. And so set out there, so what that means is that the documents have been updated accordingly, the landscape ecology management plan, the landscaping plans that accompanied the application to demonstrate those. And so I can give you the document references for those there at different places throughout. But essentially it would be core documents 78 is a landscape mitigation plan. And the landscape and ecology enhancement plan is core document got 70 or 78 there, but I think it's 77 to 78 are the two relevant documents in respect of the landscape amendments. None of the other plans change. That's essentially core documents 1 to 16, which deal with the various elements of the scheme, the elevation, substations, panels, etc.
Mr. Defoe, is that your understanding?
Yes, I know, Joe.
And Mr. Anstice, did you want to come in at this stage and give your view on that?
I don't think at this stage, no. I think in terms of the description, it is an accurate description. We obviously have opinions on implications.
Which we will deal with during the course of the inquiry. So as things stand, there are the two descriptions, the description of development as originally submitted and the revised proposal. We will look at those during the course of the inquiry. And can I just check that I have all relevant documents from the parties and that no one's intending to submit further documents? Mr. Anstice?
No, there are no further documents from here.
Mr. Defoe?
I think this is going to get. We might see if there's one for you that's a master one. Often there is that can just be kept on, but I'll see if anyone in IT knows the answer to that. And there is one document there which was sent into PINS last week, but I've got hard copies, and that's the methodology to Mr. Wakefield's proof of evidence, his Appendix 7. I can either hand that in now or hand it in when Mr. Wakefield gives his evidence, and he'll obviously talk you through it at that stage. That's the only document that I'm aware of coming in from us.
Would be useful to have it document now. We can give it an ID number for the library.
If you've got the ID too, so I can keep up so far.
Indeed. If you can distribute that. Well, just before you do that, Ms. Osmond Smith, did you have a view on this document coming forward?
The methodology, sir. I've received that and looked at that. That's no problem.
And just while that's been distributed, also last week, I think there was an up-to-date decision, inspector decision came forward. Has that also been handed up to the inquiry?
There have been updated decisions, I think, coming both from the appellant and the Rule 6 party. If there aren't copies in the room, I can make sure we can, in the break, work out what they are and get you hard copies. Do you know what, perhaps we'll check in the break, but your core document numbers that you've got in hard copy go up to? Because I think we've been adding core docs and we can just make sure that you've got the up-to-date ones.
I think the highest number I've got is 218.
Yes. So if I can. Yes, 218, that's right. So you have the most up-to-date list of core documents. So the decisions that came in last week, there was the Alfreton decision that the Rule 6 party put in, and the Secretary of State decision at Langford Mill that we put in, and Little Horwood as well. Those are all now in as core documents because they came in before the inquiry. So you should have hard copies within your folders.
Mr. Francis, that's your understanding?
It is, yeah.
Okay, thank you.
Thank you.
Okay, and in terms of how each day will run, I'm about to conclude my opening remarks and give you all the time. Is there something else?
Sorry, sir. Yes. Yes, I have some documents that I need to give you. The first is the document, the Silchester Trail. So you'll have seen this referred to in the evidence, and there's also extracts of the particular plan. But what you don't have is the full glossy coloured guide to the route, which I think would be helpful for the inquiry to have sight of. So I propose to put that in. The other points are in relation to Mr. Pratt's appendices, and it's figures 10 and 11. And the indicative sections, which I think you have in large scale. I can see it hiding underneath your desk. So in respect of those plans, there is, first of all, figure 2, which is the landscape strategy plan. Unless you have this on a digital screen and you blow it up, what you don't see is the definition in colour, which corresponds with the key elements, which are supposed to be represented by different things. So I've asked if that can be provided to make more clear what's proposed in which particular place. And it was particularly noticeable to me, and I can see it now if I look very closely, to the south of Field 1, where there's a new planting belt proposed. That's not exactly clear unless you get your face really in or you have a computer screen. So I've asked for that to be made clear. The other point on that is that the labelling was a little bit unclear, in that the removal of the panels from the western side in Field 1, Field 2, and also over sort of the Bramley side, as it were, in Field 5, that's marked on here as being removed in the alternative scheme, but they were in fact removed in the schemes determined by the local planning authority as a result of amendments made through the application process. So just to make sure that that's accurate, I've asked for that to be amended. So a new insert essentially will be coming along as soon as that's printed. We've had to obviously have them printed by specialists because they're large. So that's going to be arriving this morning. The other figure, figure 11, the landscape legacy plan. What you have there at the moment, that's figure 11, is you had sort of a double hedgerow in Field 1, and that's a hangover from where there were panels that were proposed on the western side of the footpath in Field 1, which is no longer, of course, proposed. They're removed from that area, and there's a single hedgerow. So again, to be consistent with the other plans, that needs to reflect the most up-to-date landscaping scheme. So I've asked for that to be provided. And the final document was the indicative section, and it's cross-section BB. There was a hedgerow missing. So you'll have, again, it's just a new version of that appendix, but with the right hedgerow.
Thank you. So in effect, these are clarification of existing documents and correcting earlier drafting errors.
So yes, exactly.
Mr. Francis, you contend that that's handed up?
Yes, we showed those earlier.
Mr. Lefebvre?
So yes, hopefully we can look at those over lunch when they're available for this way this is evidence. If that works in the timetable.
Okay, thank you. Any further documents? Okay. Just dealing with procedural matters, then I can outline how each day will proceed. I'll take adjournments each day, suitable times in the morning and the afternoon, normally around about 11 o'clock morning, 3 o'clock afternoon. In terms of a lunch adjournment, I sometimes think 60 minutes is overly generous, but sometimes things arise and people have to go off and do some extra bits of work during lunch adjournments. Can we play that one by ear, depending on if I do send you a task? I'm going to be content with a 45-minute lunch break most days, unless we need to extend it. So, Mr. Anstey. Oh, sorry.
No objection at all on this side.
Mr. Defoe?
That's fine, sir.
Councillor Smith, happy with that. Okay. We're also due to start the subsequent day at 9:30 in the morning. Does anyone have any problems with that in terms of delivering children to school or? Mr. Anstice?
No objection.
Mr. Defoe?
Yes.
Councillor Smith?
That's fine, thank you, sir.
So on each subsequent day, We will start again at 9:30. That will include coming back next week to resume the inquiry on the Tuesday. Start at 9:30. Okay. I try to avoid sitting beyond 5 o'clock in the afternoon if possible. But again, we'll be flexible with that because I do want to leave someone who's being perhaps cross-examined in limbo, as it were, overnight, where they can't speak to their respective teams because they're still being questioned. So we may run on beyond 5 o'clock just to get someone out of that situation. Does anyone feel that we have particular time constraints that we need to work beyond 5 o'clock, Mr. Anstice?
Not aware of any of from my perspective, no.
Mr. Defoe?
No, sir.
Councillor Smith? Okay, that being the case, we'll perhaps set that out in the revised timetable and just give a timing for each day. Okay, thank you. Okay, now there's no further housekeeping or procedural matters to raise. Mr. Anstice, do you have any further procedural matters?
No, sir.
Mr. Defoe?
No, sir.
Councillor Smith?
Not for this, thank you, sir.
Okay, now everyone's been very patient listening to me ramble on for quite a while. I would suggest we take a quick adjournment before we get into our openings. And one thing I should have asked during the lunch adjournment, is there anyone nearby to grab a coffee or a sandwich? Anyone with local knowledge?
Road, and then town is just there. So there's lots of different weather over the road.
Okay, so there is a camp, well, you probably realise you've local knowledge, and it might be a mad scramble, then come 1 o'clock if I get to the head of the queue. But there is somewhere nearby where we can get coffee and sandwiches. Okay, thank you. It's just coming up to 11:20. Let's adjourn and come back for the opening remarks at past. Thank you.
Skip around and dish up.
Yeah, that's 11, and the inquiry is resumed. The adjournment was approached by Mr. Hall, who's had to leave the inquiry for a prior engagement, and he said that he would have difficulties in getting his evidence today. And that the best time that suited him would be Thursday afternoon. And he suggested last thing on Thursday afternoon, well, we would be around during the afternoon session. Can I just check with the parties? Would you be content to fit Mr. Hall's evidence into Thursday afternoon? That means breaking from the advertised programme. Mr. Anstice?
And that would work well, so no problem at all.
Mr. Fair?
So I think that's fine, and then there may be a convenient slot anyway, because at the moment we've got complete, I'm looking at the last page, but yes, very happy.
And Ms. Osmond-Smith?
Sorry.
Oh.
So yes, I think that is probably okay. It's probably the most convenient day actually for it to be squeezed in.
Okay, so that brings us to the opening statements. And if I could turn to the appellant first of all, Ms. Osmond-Smith, you're in a position to make your opening comments and we have them in writing.
So they'll make their way to you now. The parties as well. So Mr. Asquith is going to bring you a copy of that, and he's also got the plans referred to and the photo montages that were sent digitally to the inspectorate, I think over the weekend.
Purposes of the library, and just to keep a check on things, the bundle of plans. Can we call them, well, there's several of them, but can we call them Plan 1? That's about the documents as part of document 1 to these come forward as plans, and there's several of them, but if we call them Plan 1, that we're referring to in the course of the inquiry.
Yes. Yes.
In terms of these, we just keep them as a separate bundle, or you want these to be substituted for what's already before the inquiry in those actual documents?
So, yes, to be clear about that. So what you have in the pack there is you've got the Silchester Trail document. I think was that probably inquiry document.
Was that
3?
Right, beg your pardon. Yes.
That's okay. So that's inquiry document 3. The plans from Mr. Kratt's appendices, they're straight swaps. That's Figure 10 Landscape Strategy Plan, the indicative sections, and Figure 11 Landscape Legacy Plan. So they're to be substituted. And then the winter viewpoints, which were alluded to in Mr. Kratt's rebuttal and sent over the weekend, they can be kept together as a pack rather than, I think, being individually numbered as winter photo montages.
Thank you.
I check everyone has a copy of my opening. I think it's on Mr. Anstice's desk. You have that? You have a copy?
I do.
I'll begin then. The UK faces a triple threat: a climate crisis, a biodiversity crisis, and an energy security crisis. In 2019, both the UK Parliament and Basingstoke Council declared a climate change emergency. In 2021, the world-leading Environment Act, which seeks to tackle internationally recognised decline of biodiversity, was passed into law. In 2022, the government published the British Energy Security Strategy, noting the impact of global political events on soaring energy prices. The proposed 45 megawatt Bramley solar farm would help to address all three urgent concerns. It would power 11,150 homes annually with clean and secure solar energy, and it would generate a striking biodiversity net gain of 100%, or 38% for the original proposals. Such large benefits can only be achieved by a large scheme, and with that comes some inevitable, albeit reversible, effects, particularly in landscape terms. However, on the whole, the impacts in this case are limited and capable of mitigation. The Council's case officer, who carefully weighed the public benefits against the adverse impacts, found that the proposal should be granted permission as it complies with the development plan. This opening addresses the two main issues identified at the CMC in turn, namely effects on character and appearance of the area and effects on the significance of heritage assets. However, in light of the Rule 6 parties' evidence, it is first necessary to clarify some points of principle regarding consultation, alternatives and agricultural land. Turning then to consultation, the Rule 6 parties' concerns, not echoed by the Council, are entirely misplaced. No unfairness has arisen, either from the initial consultation in 2020-21 or from the publication of the alternative proposals in 2022. The key provisions setting out what the original consultation required are in the Town and Country Planning, Development Management Procedure, England Order, the DMPO. The appeal scheme is an environmental impact assessment application and was accompanied by an environmental statement. As such, pursuant to Articles 15(1)(a) and 15(7), the original application needs to be publicised in the following way. Firstly, by giving requisite notice by slide display for not less than 30 days and by publication of the notice in a local newspaper. And B, by publication of the following information on a website maintained by the Council. And I won't read out 1 to 6 there, but they're there for you to read. In cases where amendments are proposed after submission but before determination, there is no statutory duty to reconsult. However, Annex M of the Planning Appeals Procedural Guidance states that inspectors will take account of the Wheatcroft principles. And set out at M.2.2, the High Court in Wheatcroft and Secretary of State for the Environment held that the main but not only criterion on which judgment should be exercised is whether the development is so changed that to grant it would be to deprive those who should have been consulted on the changed development of the opportunity of such consultation. Wheatcroft involved an application for permission for 420 dwellings on 35 acres, but before the inquiry opened, an alternative proposal for 250 dwellings on 25 acres was introduced. The High Court did not consider reconsultation was necessary. And at page 242, it held that I find it difficult to believe that where a proposed development has been the subject of such consultation and has produced a root and branch opposition to any development at all, whether larger or smaller, it should be necessary in all cases to go again through the process of consultation about the smaller development. It is clear that, in this case, the process of consultation had resulted in such root and branch opposition that further consultation could not have resulted in more opposition, but only if there was any change in public attitudes, unless. Pursuant to paragraph N234 of Annex M, the key question when deciding whether reconsultation is necessary is whether or not the suggested amendments could prejudice any interested parties. In light of this guidance, the Rule 6 parties' concerns about consultation are wholly unfounded. In summary, the consultation on the original application was carried out to the satisfaction of the Council, and the Rule 6 party does not allege this breached any legal requirement. Secondly, the alternative proposals comprised minor positive modifications that did not require further consultation under the Wheatcroft principles. But in any event, C, in the interest of community engagement, the appellant carried out a full consultation on the alternative proposals to the Council's satisfaction. First, the alternative proposals represent minor modifications which make no material difference to the substance of the application, improve the scheme and reduce its effects. The Council does not consider that the amendments are substantial. The changes comprise slight reductions in solar panels to increase distances from public rights of way, bolstering of planting to enhance screening, and the deletion of the potential forest school area with repurposing of the land to an enlarged nature area. Accordingly, fairness did not require further consultation. Someone who had not objected to the original application would not reasonably have decided they now want to object simply because due to those minor amendments. And it is clear from the root and branch opposition of the Rule 6 party that local opponents do not consider that minor modifications can resolve their objections. In short, nobody would have been materially prejudiced had no reconsultation occurred. However, in the interests of community engagement, the appellant carried out a consultation on the alternative proposals comprising letters, site notices put up on the 10th of August 2022, a notice in the Basingstoke Gazette on the 11th of August 2022, a website hosting the information and a copy in the Civic Centre. The consultation was carried out until the 30th of September 2022, a longer period than required under the DMPO. Pins also notified those who had previously commented, and while Pins and the appellant sought to facilitate the consultation, it is worth noting that the Rule 6 party asked its members not to respond. Having regard to the comprehensive publication and also to the existence of a Rule 6 party representing the local community, there was ample opportunity for people to find out about the amendments. The Council raises no objection, and correspondence from June and July 2022 shows that the Council reviewed and accepted the appellant's proposed approach to reconsultation. In short, no material prejudice has possibly arisen. No reconsultation was required given the slight positive modifications, and yet a full consultation was carried out. Moving then to alternatives and agricultural land. A second misconceived argument repeated by several of the Rule 6 witnesses is that the proposals should not be permitted because they could be located on an alternative site. Again, this argument is misplaced in both law and in reality. Alternatives in respect of the legal requirements. The appeal proposals constitute EIA development, but as set out in the PPG, the 2017 regulations do not require an applicant to consider alternatives. However, where alternatives have been considered, paragraph 2 of Schedule 4 requires the applicant to include in their environmental statement a description of the reasonable alternatives studied, for example, in terms of development design, technology, location, size and scale, and an indication of the main reasons for selecting the chosen option, including a comparison of the environmental effects. Accordingly, pursuant to Regulation 18.3 and Schedule 4 of the Town and Country Planning Regulations, Environmental Impact Assessment Regulations, the ES included a description of the reasonable alternatives studied by the developer and an indication of the main reasons for the option chosen, taking into account the effects on the environment. The case law on when alternatives are exceptionally considered or indeed required to be taken into account was recently revisited by the High Court in the Save Stonehenge case. From the cases cited, the following propositions can be derived. First, in general, land may be developed in any way that is acceptable for planning purposes, and the fact that other land exists upon which the development proposed would be yet more acceptable would not justify refusal. Second, in exceptional circumstances where the development is bound to have significant adverse effects and where the major argument in support is that the need outweighs the harm, for example, nationally important airports or nuclear stations, it may be relevant or even necessary to consider alternatives. Third, a distinction should be drawn between exceptional circumstances where it is permissible to take alternatives into account and those where it is necessary, i.e. where there is a legal or policy requirement, or such alternatives are obviously material such that it is irrational not to consider them. In those exceptional circumstances where alternatives are relevant, alternatives that are vague or incoherent, or which have no real possibility of coming about, are either irrelevant or, where relevant, should be given little or no weight. In the end, the court in Stonehenge did find the circumstances, including the legislative and policy context, the status of the World Heritage Site and the availability of an alternative within the same development site, to be wholly exceptional, requiring consideration of the alternative tunnel option proposed. And this was for 9 reasons set out within the judgment. Most importantly, that the significantly adverse, permanent and irreversible impact to a World Heritage Site, Stonehenge as an asset of the highest heritage significance with outstanding universal value. The alternative tunnels proposed were located within the application site itself. And finally, it was never suggested that the alternative tunnel options were too vague or incoherent to be considered. Those wholly exceptional circumstances are a far cry from the position of this appeal. It is also worth noting that in the Derbyshire Dales case, which was affirmed by the High Court in Stonehenge, and it's a case concerning the erection of wind turbines where the main issues were landscape and heritage impacts, the High Court held that, returning to the present case, it seems to me impossible to say that there is anything in the statute or the relevant policies which expressly or impliedly require the inspector to consider alternatives, particularly as none had been identified. The emphasis of the Section 78 is on consideration of the particular application in question. The statutory provisions and policies relating to the national park and conservation areas required special regard to be paid to their protection, but they fell short of imposing a positive obligation to consider alternatives, which might not have had the same effects. That is left as a matter of planning judgment on the facts of the case. In short, the case law is clear that alternatives are only relevant in exceptional circumstances. The more serious the harm and the more realistic the alternative options, the more importance can be placed on them. But there is no coherent alternative that has been provided here that would meet the same urgent need as this scheme. Alternative sites for the Bramley scheme. In the present case, say you can give no weight to any alternative sites for the following summary reasons. First, there are no genuine alternatives before you. Secondly, there is nothing in policy that expressly or impliedly requires a sequential approach in these circumstances. And finally, alternatives have been considered and no appropriate options have been found. First and critically, there is simply no alternative site option before you with lesser impacts. The Council have not allocated any such sites and no alternative planning applications are for consideration before the inquiry. Secondly, the harm here is not substantial, show-stopping harm that renders the development unacceptable, and it is common ground with the Council that there is no requirement in policy to consider alternatives in light of the harms alleged. As such, the situation is far different to, for example, a need to demonstrate very special circumstances in the Greenbelt or the significant harm to a World Heritage asset in Stonehenge. Accordingly, consideration of alternatives is not necessary. In particular, there is no policy requirement to avoid use of best and most versatile agricultural land for renewable energy, keeping in mind the following. 1, the solar farm would sit on rather than in the land and would be removed in 40 years. As such, no best and most versatile agricultural land would be permanently lost. 2, conversion of arable to grassland under solar panels can improve soil health and biodiversity. 3, land accommodating panels can still be used while a solar farm is operational for agricultural sheep grazing. 4, the NPPF at paragraph 174 simply requires that planning decisions recognise the benefits of best and most versatile land. It does not require avoiding use of that land. 5, the draft National Policy Statement, EN3, provides that while solar should avoid BMV where possible, land type should not be a predominating factor in determining the suitability of the site location. Policy EM8 provides that BMV impacts would only be a reason for refusal if they caused adverse environmental, economic or social impacts not outweighed by the benefits. And finally, Natural England, the statutory consultee on BMV, did not object. The Council agrees that the less than substantial heritage harm at the lowest end of the spectrum is not of itself a reason to refuse planning permission. And as to landscape impacts, any large-scale solar farm will inevitably result in some landscape harm. It is recognised in the Derbyshire Dales case. That does not generate a policy requirement to consider alternatives. As made clear by Inspector Baird in the Halorton appeal and addressed in more detail below, given their nature and scale, it is inevitable that large-scale solar farms may result in landscape harm. In this context, National and Development Plan policies adopts a positive approach, indicating that development will be approved where the harm will be outweighed by the benefits for the scheme. Thirdly, alternative sites have been considered and no adequate alternative found. Key criteria for the site selection process included deliverability, existing development, topography and protected designations. Land ownership is also critical. A scheme like this cannot go ahead without a willing landowner. Policy EM8 of the local plan further requires proposals to demonstrate links to the existing infrastructure such as the national grid. And here the adjacent Bramley substation connecting directly to the national grid has capacity, and the appellant has secured a connection agreement, which is a scarce resource. Mr. Whitaker will explain that the transmission grid connection opportunity is essential because the distribution grid in the area is constrained, meaning a connection to that is not going to be feasible without significant upgrades. Proximity to the substation minimises distance, the power flows, and likely reduces electricity losses, power outages, costs, and resources. Within 5 kilometres of the connection point of Bramley, there is no land to accommodate a solar scheme of this size that would use any less BMV. Smaller projects do not represent an alternative because the grid connection requires the scale of generation proposed, and because both small and large solar, including large ground-mounted solar with battery storage, are needed to achieve the government's ambition to deploy 70 gigawatts of solar energy by 2035 to reach net zero. In all, there is no plausible argument that the scheme should be refused because an alternative option should be preferred. Turning then to landscape, none of the parties claim that the site comprises a valued landscape for the purpose of the framework, nor that it is designated for its landscape beauties. Indeed, Mr. Pratt is clear that the appealed site is wholly suitable for the development proposed, given the well-wooded and hedgerow nature of the landscape and the flat, gently undulating topography. The Council acknowledges that some reversible landscape and visual impact is unavoidable for a solar scheme of this size, and it is important to acknowledge that the Secretary of State and planning inspectors have repeatedly held that such inevitable impacts do not mean an unacceptability in planning terms. The emphasis in local and national policy is to mitigate impacts to an acceptable level. In this case, the Council's landscape officer did not object to the proposals when determined, and the post-submission and post-determination amendments have further reduced predicted effects as assessed in the LVIA addendum. Effects on landscape character primarily relate to the appeal site itself and not the wider area. Even within the site, the nature of solar development lying on rather than in the land means that key existing features, including trees, hedgerows and watercourses, would be retained and all impacts would be reversible. During the lifetime of the solar farm, the site would continue in some agricultural use as pasture land for sheep grazing. A series of landscape enhancements are also proposed in the form of a comprehensive green infrastructure network, which includes a 1.1 kilometre tree belt, reinstatement of historic hedgerows and a wildflower meadow corridor, and a 519 stretch of permissive right-of-way, allowing an alternative off-road route which would increase recreational opportunities. It is agreed with the Council that the planting proposed accords with the Basingstoke Landscape Character Assessment 2021. The visibility of the proposed development would be very limited and localised by reason of the characteristics of the low-lying panels and receiving landscape. Any adverse effects on the public right-of-way users would be contained within the site and would reduce from the medium term onwards. It is common ground that the Council that the visual envelope would be relatively limited to approximately 500 metres maximum. The scope and approach of the original LVIA was agreed with the Council's landscape officer, including the number and location of viewpoints and photo montages. Mr. Pratt considers that these are proportionate and suitable to make an informed judgment on likely effects, and that Mr. Wakefield's and Mr. Minchens' new viewpoints change nothing, noting that new photographs taken at particularly gappy points in the hedgerow present a skewed judgment. In short, the proposal can be delivered without significant landscape or visual impacts, and all effects are ultimately time limited. As acknowledged in the Officer report, new landscaping secured through planting conditions would mitigate the effects to an acceptable level. Accordingly, the scheme complies with policy EM1 and EM8 of the local plan, as well as policy D1 of the Bramley neighbourhood plan. In terms of heritage, the Council now accepts that any harm to heritage assets is at the lowest end of the scale and would be outweighed by the public benefits of the scheme. In light of that concession and the fair proof of Dr. Massey, with whom it is agreed common ground that there will be no archaeological impacts, it is unclear how the Council can continue to maintain a heritage objection. Withdrawal of the heritage reason for refusal would accord with the position taken by, first of all, the archaeological and built heritage advisors to the Council, who made no objections, Historic England, who made no objection and identified no harm, the officers' report to committee, which concluded that any heritage harm would be outweighed by the benefits, and Mr. Stoton, who finds no heritage reason to withhold permission. In terms of archaeology, it is common ground between Dr. Massey and Mr. Stoton that the remains within the site are not of a significance commensurate with a scheduled monument. Physical preservation of those remains in situ can be secured by condition, and the landscape character of the site does not contribute to the heritage significance of the scheduled late Iron Age oppidum and Roman town of Cabella Atrovatum through setting. Two minor issues are still in dispute: whether inaccessibility of the remains during the lifetime of the solar farm would limit future archaeological research, and the adequacy of the assessment of archaeological potential. However, the critical point is that no harm is alleged by the council subject to appropriate conditions. In Ms. Stoughton's view, not only will harm be avoided, but the situation of the remains would be improved by cessation of damaging ploughing and cultivation. As to other assets, Dr. Massey and Ms. Stoughton agree that the scheme would result in negligible, very low, most less than substantial harm to the Grade 2 listed buildings at Minchens Farmhouse, Lower Farm and Old Meadows and the Silchester Conservation Area. The officer report found this to be outweighed by the considerable public benefits of the proposals, and this too is a conclusion of Mr. Asquith. Turning then to the planning balance, Mr. Asquith is clear that the scheme complies with the development plan read as a whole, including with the most important policy EM8, which is worded permissively. This is also a scheme where powerful material considerations weigh in favour of granting permission. Most importantly, given the climate and energy security crisis, renewable energy has authoritative support at national level. Under Section 1 of the Climate Change Act 2008, the UK faces an ambitious and legally binding target to achieve net zero carbon emissions by 2050. The government's Net Zero Strategy 2021 expects the UK to be entirely powered by low carbon electricity by 2035. There is a presumption in favour of renewable energy at paragraph 158 of the framework. Draft NPS EN1 states that wind and solar are the lowest cost way of generating energy, and that a secure, reliable, affordable net zero system in 2050 is likely to be composed predominantly of wind and solar. Draft NPS EN3 describes electricity generation from renewables as an essential element of the transition to net zero. And finally, the British Energy Security Strategy of this year expects a five-fold increase in solar capacity by 2035 and supports co-location with storage. Together, these reflect a broad consensus that climate change is a serious threat to humankind and that urgent action is needed to address it. Yet, as regards the actual decarbonisation of society, much remains to be done, and most of the heavy lifting is ahead of us. Hence the imperative of large schemes such as this providing electricity from an inherently clean and renewable source, the sun. In the context of the climate, energy and biodiversity crisis identified, Mr. Asquith affords the following fair weightings to the wide-ranging benefits of the scheme. First, the generation of renewable low-carbon energy he gives substantial weight to, which is the highest grade. On low-cost and secure energy, Mr. Asquith gives that a significant weight. 100% biodiversity net gain for the alternative proposals also gets significant weight. Other environmental benefits to landscape runoff and soil, moderate. Footpath improvements, limited. Economic benefits via employment, construction and operation spend and business rates, limited. And the grid connection opportunity is significant. Against that powerful set of benefits is the reversible harm to landscape character and visual amenity, which Mr. Asquith gives limited negative weight, and the less than substantial harm to heritage assets at the lowest end of the scale, which Mr. Asquith gives moderate weight, affording the requisite great weight to the conservation of the heritage assets. Even if conflict with the development plan were to be found, Mr. Asquith concludes that the time-limited adverse effects would be demonstrably outweighed by the substantial public benefits, such that the material considerations would indicate that permission should still be granted, a conclusion that accords with the recent findings of Inspector Ware at the called-in Langford 49.9 megawatt solar appeal and endorsed by the Secretary of State. Accordingly, in due course, sir, we will invite you to grant planning permission for this proposal, subject to appropriate conditions. Unless I can assist you further, those are my opening remarks.
Thank you. Mr. Firth, would you like to give your opening remarks, please?
Thank you, sir. The site area for the proposed solar farm covers 85 hectares of agricultural land in the countryside. The area containing the approximately 100,000 solar panels, battery storage containers, substation, inverters, transformers, and associated infrastructure with a total sum of 49.2 hectares, the equivalent with the World Cup in mind of 69 football pitches. The panels would be arranged in rows running east to west across the site, on which face southwards. The solar panels and their mountings would be circa 3 metres in height, and they would be ground mounted onto metal framework with a piled substructure or on concrete supports in the areas of archaeological mitigation. The solar panels would be enclosed by 6.8 kilometres of high security deer-type fencing with security and monitoring CCTV and infrared cameras mounted on fence posts along the perimeter of the site. There would be 14 inverter or transformer stations spread across the site and housed within metal shipping containers, each measuring 12 metres by 2.4 metres by 2.9 metres. 20 of the same containers would be used to house the battery storage, which would be positioned in the southwestern part of Field 6. Next to that would be a substation measuring 12.5 metres by 5.5 metres by 4.2 metres. There would be other associated infrastructure such as cabling and internal vehicular access roads through each of the fields. There would also be significant areas of landscape and biodiversity mitigation. The council acknowledges that there is a clear need to increase renewable energy generating capacity in this country, and that solar farms bring important benefits in terms of reducing carbon emissions and assisting with security of supply. In that regard, the NPPF is clear at paragraph 158A that there is no requirement to demonstrate the overall need for renewable or low carbon energy. That need is uncontroversial. The council acknowledges that due to the scale of the solar farm being proposed here initially at 49.9 megawatts, which is just below the threshold of a nationally significant infrastructure project, and now around 45 megawatts, although I note in my footnote that Mr. Asquith explains that it's a little bit difficult to say precisely what the amount would be because it depends on how technology improves. And I think it would be limited to 49.9 megawatts in any event. And that is capable of generating a large amount of energy from renewable sources. These are accepted as important benefits of the scheme, which should be weighed against the harm. There is also strong local and national support for green renewable energy generation, including solar power. However, in planning policy, that support is not unqualified. Instead, perhaps unsurprisingly, policy requires a balance to be undertaken. The NPPF, which is most clearly stated in paragraph 158, which provides that an application should be approved if the impacts are or can be made acceptable. And this is also reflected in the development plan where EM8, which the council would agree is the most important policy in terms of your determination of the appeal, provides that development proposals for the commercial generation of energy from renewable and low carbon resources will be permitted unless there are adverse environmental, economic or social impacts which are not outweighed by the benefits. In each instance, a balance is to be struck by the decision maker, and thus the PPG makes reference to the need for renewables or low carbon energy doesn't automatically override environmental protections, and protecting local immunity is an important consideration which should be given proper weight in planning decisions. So I just deal with the two schemes before you. The CMC indicated that the most recent amendments to the proposed development, which I refer to as the appeal scheme, and the scheme refused by the planning committee, which I refer to as the refused scheme, will be considered during the inquiry. And the key differences were explained to you by a friend earlier and are summarised in the proof of evidence of Mr. Asquith, which I've quoted from there, although no doubt there are more comprehensive explanations of the differences. The council did not and does not resist the consideration of the appeal scheme at the inquiry.
And given that the appeal scheme is put forward by the appellant as an improvement both in landscape and biodiversity terms, so if you're satisfied that you can consider the appeal scheme, we would invite primary consideration of that scheme in your decision. Given that the purpose of the appeal scheme is to reduce some of the effects of the development that would have been felt in the review scheme, particularly in landscape terms, it's the appeal scheme which the landscape evidence of Mr. Wakefield assessment focuses on. So in terms of the two main issues, they've been set out several times, and I don't read those. I deal with them in turn, noting paragraph 15 that other matters, including those raised by the representations of interested parties, will be considered. In terms of character and appearance, then, so the council considers that the determinative issue in this appeal is the harm to the character and appearance of the area and the visual harms caused by the proposed development. The site and the surrounding context are representative of several of the key characteristics as highlighted in national, regional and local character area assessments, and is agreed to be of local or district value, although not considered to be a value landscape in NPPF terms. There are 7 public rights of way which either pass through or within the vicinity of the site, with about 1.4 kilometres of public rights of way through the site and 2.5 kilometres of public rights of way in close proximity to the site boundary. No doubt walked and speed by you in due course and on your unaccompanied site visit beforehand. These are important as they represent highly sensitive visual receptors. The considerable distance of these routes is also, we say, an important factor. The LBIA identifies adverse large-scale landscape and visual effects on the site and its immediate vicinity, which would reduce as you get further from the site. How these effects are then translated into significance depends on the judgments reached at various stages within the assessment process, and that's an issue we'll explore in evidence. It's recognised also that these effects would be mitigated to some degree as the mitigation planting matures, and again, it's something to be explored in evidence. The overall adverse effects of the proposed development in landscape and visual terms are such as are considered to be important, poor phrasing, and indeed decisive, we say, in the overall planning balance. Turning then to heritage matters, the appellants and the council have reached agreement on all heritage issues which are likely to be determinative to the appeal. It's agreed that less than substantial harm would be caused to the significance of the greater list of buildings at Minchens farmhouse, Lower Farm and Old Meadow, and to the Silchester conservation area. This harm is agreed to be at the lowermost level of less than substantial harm, and the evidence of Ms. Tipper is that this harm would be outweighed by the benefits of the proposed development. It is further agreed that the landscape character of the site, as experienced today, does not contribute to the heritage significance of the scheduled late Iron Age Opinium. My turn to have a go. Roman town of Caliber Atrabatum and associated features through setting, and no harm to the significance of those assets would be caused by the proposed development. As set out in the main statement of common ground, the second reason for refusal had a particular regard to the potential archaeological interests of the site. It is agreed that the known remains are not demonstrably of equivalent significance to a scheduled monument, and as such are to be treated as non-designated heritage assets by the NPPF. Following constructive discussions between Gail Stoughton on behalf of the appellant and Dr. Massey on behalf of the council, it is now agreed that the concerns the council had with regard to the potential harm to the significance of the archaeological remains on the site can be mitigated to an acceptable level. In particular, it is agreed that the physical preservation of the archaeological remains within the site can be secured through conditions attached to any planning permission granted, making provision for further investigations to define areas where particular preservation measures will be required. The Heritage Statement of Common Ground therefore sets out two matters that remain at issue between the council and the appellant on heritage issues. Firstly, whether the inaccessibility of below ground archaeologically archaeological remains within the site during the life of the solar farm will limit opportunities for future archaeological research of those remains, and as such be a negative factor accounting against the scheme. And secondly, whether the appellant's initial assessment of the archaeological potential of the site was informed by sufficient evidence. However, so neither of these matters appear to us to be considered to be determinative of the outcome of the appeal, and as such, it is not considered to be an effective use of inquiry time to explore those issues. In consequence, the local authority will not call Dr. Massey to give evidence that I've already indicated. That's a position that was discussed with the appellant before we reached that conclusion. But it seemed, I think, to both parties it was a sensible use of inquiry time given the progress that had been made. Given the agreement reached as to further archaeological mitigation measures via condition, breach of local plan policy EM11 is no longer obtained. Benefits then. The two main benefits relied on by the appellant are the generation of renewable energy and its associated benefits of providing low cost and secure energy, and ecological enhancements through substantial biodiversity net gains, 100% in respect of the appeal scheme, and I think it's 38% in respect of the original scheme. There is little, if anything, between the main parties on the weight to be attached to those benefits. Council accepts that the grid connection opportunity is also a benefit to the site. However, it does not consider that benefit of the grid connection to be such as to justify a solar farm in this location on the scale proposed. The other benefits relied upon, i.e. those I've not already mentioned in that paragraph, are unlikely to attract more than limited weight in the balance and appear unlikely to affect the overall outcome of the appeal. Turning then to the planning balance, the evidence of Ms. Tipper is that the adverse impacts of the proposed development outweigh the benefits. This conclusion leads to the following implications for the proposed development: non-compliance with EM1 and D1 of the Bramley Neighbourhood Plan related landscape character and appearance and visual harm associated with the development, and non-compliance with EM8 of the local plan, which provides support for renewable energy generation subject to adverse impacts outweighing the benefits. These breaches, in particular the breach of EM8, are such as to mean the proposed development is not in accordance with the development plan read as a whole. There are no material considerations which mean the appeal should be determined otherwise in accordance with the development plan, and accordingly the council will invite you to dismiss the appeal and refuse plan permission in due course. Less I can say, so those are sufficient on that for council.
Okay, thank you. Mr. Anseth, going to make your remarks, please.
Copies is on the later. It is common ground between all the parties that there is a climate emergency, that there is an urgent national need to meet net zero. Green energy is an important part of that plan. The question for this inquiry, however, is whether the appeal scheme, in either form, is necessary or appropriate on this site. We will hear that the proposal is massive, over 100,000 panels, 3 to 3.5 metres high, 16 transformer stations, compounds, tracks, CCTV, and 7 kilometres of geofencing. This is a very large-scale, ground-mounted solar photovoltaic farm application with a second separate element incorporated, being 20 battery storage containers and the associated works. We will show that the impact of this proposal will significantly harm heritage assets, including important archaeology beneath the site and harming the surrounding historic area. We will show that the impact will significantly harm this highly valued landscape within and surrounding the site. We will show that the 4 kilometres of public rights of way, both in the site and adjacent, will be significantly harmed by the proposal. We will show that, contrary to national and local policies, the proposal seeks to needlessly develop only the best and most versatile, productive arable land, which makes up the majority of the entirely greenfield site. We will show the proposal is not necessary and that the appellant has failed to follow national guidance by failing to even attempt a search for land in the wider area, which would have identified many thousands of hectares within the Bramley Grid supply point area that includes brownfield, previously developed land, and greenfield land that would not remove BMV land from production or be within flood zone 2. For the battery storage element of the proposal, we will show that the search should have been wider still. And for the whole twin scheme, we will show that far from supporting the important plan for net zero, this proposal is nationally irresponsible, fixating on the transmission grid network connection point of the Bramley substation and therefore artificially limiting the search area to 5 kilometres from it, and therefore choosing an entirely inappropriate site near the substation, which will be significantly harmed by the unnecessary imposition of this alien industrial development, presenting it in an unconvincing attempt to tip the planning balance in its favour as a temporary scheme of 40 years. The climate crisis is too important for this. The opponents have a responsibility to search properly, sequentially, and to identify sites from the whole wider criteria that would still deliver the same or even greater amounts of green energy into the grid, but from sites that are appropriate and upon which a permanent scheme could have been designed. Had the opponents behaved responsibly in this way, they would not have had to resort to inadequate and confusing public consultation. They would not have had to attempt to amend the scheme after the application process was already completed, further compounding the inadequacy of the community involvement. And they would not have had to include a catastrophic decommissioning element of the scheme with its own heavy environmental impact. The proposed amendments to the scheme would have required reconsultation at application stage, and because of that, and the inadequate attempt at consultation carried out by the appellant during this appeal, not allowing that has deprived those who should have been consulted of the opportunity to respond. So to allow that scheme would now not accord with Annex M or the Wheatcroft principles. The original scheme included the forest school, and by the appellant's own evidence, we will show that the original scheme is therefore undeliverable. For all the reasons above, and from the evidence we will provide at this inquiry, both schemes fail the planning balance and the appeal should be dismissed.
For that. It's just gone 12:15 and agreed we would stop around about 1:00 for lunch. So what I propose to do now is to hear the evidence from those who indicated they'd like to speak at the inquiry, obviously with the exception of Mr. Hall, who will come back on Thursday. So Mr. Mahaffey, would you like to come forward?
Me. I've been handed copies, I think, of Mr. Mahaffey's statement, and also, I think, of speak on behalf of the parish council if you ask for. So shall I hand those around?
So am I right there?
Yes.
So I'll just make a request for Chris Tomlins, if he wants to read out. Because he can't be here, I'm proposing that another of the community users.
Okay, Mr. Durant was going to do that. Is that not the case?
If I may, Councillor Tomlin is a committee member of the proposal involved in the application. I think therefore he has personal involvement in his role, but his evidence is probably best heard from himself. And I would brief conversation with him. I think it would be better if he could be allowed to speak before it's on Thursday. In his own voice, as he will.
Okay, so this is a recent development. When you've spoken to Mr. Solomon, who is ill today and not able to come along, do you think that he will be able to come along Thursday?
I think so, yeah. He's had a bit of a sore throat. It's not a COVID situation. We do have a copy here to read out, but I think his insight as a development control committee member, I yield to whatever you.
Okay, and Mr. Anstice, you were going to read out his evidence today, is that correct?
If he prefers to read that himself, then I would want that prerogative to be exercised, but then if it fits in the schedule and with your views.
Okay, well, let me just check with others. So we've agreed that there was time to accommodate Mr. Hall. It seems Mr. Tomlin might be able to come along on Thursday afternoon as well. Mr. Lister, have you a view on that?
No objection from me, sir. I have limited involvement in Thursday in terms of the witnesses, so I'll leave it to others. So I don't get out of time.
And is it Osmond Smith, any view on that?
So no, not particularly. Trying to accommodate people where we can.
So, sorry, who would liaise with Mr. Tomlin then? Would that be yours? Sorry.
I'm happy to liaise with him. And
okay, in that case, we should be able to fit both Mr. Hall and Mr. Tomlin into the schedule on Thursday afternoon. I think Mr. Tomlin could be told to make himself available then.
thank you very much.
Okay, thank you. And we've just been given two documents. So, Mr. Mahaffey, sorry, who was the other person?
So it's the representation from Silchester Parish Council.
Right.
Graham Wright.
Yes, right. Michelle and I try to keep track of the ID numbers.
I was going to ask you for those.
We've got the appellants opening as ID 4. Sorry, Sarah, I should have written them on the top of those. The council opening as ID 5. Rule 6 parties opening as ID 6. And then Mr. Mahaffey is ID 7. And to the right says ID 8.
Yep. Okay, Mr. Mahaffey.
Excellent. Inspector, thank you for allowing me time to speak. My name is Simon Mahaffey. I've lived in the same address in Silchester for the last 43 years. I served for 10 years on Silchester Parish Council and 3 years as chairman. At the time of the original application, I was the Basingstoke and Dean Borough Councillor for the ward, and I was in constant contact with the case officer, the applicant, and the 2 parish councils. I hold a master's degree from Oxford University in Environmental Change and Management, and in 1995, I established the UK's first carbon offsetting firm. We are all aware of the climate emergency declared by the council. I know particularly because I was the one that proposed it, and I've played a central role helping to develop the council's climate strategy. I'm also a member of the Silchester Roman Site Panel. Clearly, we must support the government's drive to decarbonise the grid, but please do not let us fall into the trap of this is solar, so it must be good. Just as when we consider housing, there are good proposals and there are bad ones. Unfortunately, this application is the latter. This application is neither a solar park nor a solar farm. Instead, it is a 200-acre industrial installation, comparable in size to the whole of Bramley at 264 acres, and over twice the size of the 94-acre village of Silchester. It will permanently change the nature of this area and do lasting harm to the nature and character of 2 rural communities. I've submitted numerous papers to the planning team and to this inquiry, but there are some key areas which I would like to highlight here. These are the permanent nature of this proposal, the misleading public consultation, the lasting harm to the local community of the changing landscape, the added harm to the community resulting from the loss of archaeology, and the dangerous impact on highways. In addressing the first of these, please let us not pretend that this development is temporary. In the consultation process, the community was first told that the applicant would put in place an insurance policy to guarantee decommissioning. I work in the insurance industry, as do others in the local community. And when we pointed out to the applicant that there is no such policy that will indemnify a policyholder against a guaranteed or legally required outcome, they changed their tune. The next thing the community was told was that there would be some form of bond put in place. I wrote to the applicant and inquired about the structure of this bond, and I have it in writing that what they actually meant was they expected the planning authority to put in place a planning condition. How on earth is the LPA expected to enforce a planning condition to spend the millions of pounds required to decommission this site in 35 years' time, when it is already stretched to breaking point? The structure of the company is a holding company with 32 operating companies. Whilst this is a perfectly normal corporate governance structure, it is designed to flow money away from the site and enables the applicant to walk away from its long-term liabilities by dissolving local operating companies. This leaves a multi-million-pound liability of decommissioning and provides no long-term security for the local community. Of the hundreds of pages that have been submitted to the LPA, only a couple of paragraphs refer to the decommissioning of the site. The application is asking the community to accept that somehow the site will be returned to agriculture. However, the only realistic economic outcome for this site is for it to continue permanently as an industrial installation or to be sold off for housing. Basingstoke and Dean Council is already living with the legacy of bad decisions made by previous administrations that have not been given sufficient thought to the local community consequences of their decisions. Please, Inspector, do not let this be another one. So what will this permanent industrial installation mean for the local community? First, the landscape. I'm pleased to see that after 2 years, the applicant has finally provided winter photographs, something I asked for at the beginning. However, like the landscape report, the photos are highly selective and wholly misleading. In the original landscape report, many photos are close-ups of single bushes amongst areas of sparse or patchy vegetation, and in some cases, even facing the opposite direction from the site. At least one of the photos in the winter views taken along Bramley Road repeats the shot of a single bush facing away from the site, whilst failing to demonstrate that the road on either side of the bush is completely devoid of cover for 200 to 300 yards. The winter photos do not match the original photos taken and completely fail to show the several hundred yards of road immediately adjacent to Field 2, where once again there is currently zero screening. Other views shown in the summer photos have now been completely omitted from the winter photos. These include views from Minchens house, any reference to Fields 1 and 4, and the views at the end of Field 2 from Latchmere Green and Ash Lane. I have serious concerns about the accuracy of the photoshopped images of solar panels. I'd be grateful, Inspector, if you would look at these in greater detail during a deliberation later in this case, as from what I see, there appear to be no panels in Field 2 shown in these photos. By their own words, ENSO's planting scheme will take 10 to 15 years before it becomes effective in this area. But the undulating nature of the views along Brownlee Road mean that the screening can never be effective in winter or summer. The applicant has provided new wide-angle views taken from within Field 2, looking outwards. Presumably, this is done to reflect the experience from the Brenda Parker Way. However, these photos are once again misleading, and I note that they have carefully avoided the inclusion of nearby properties such as Brookside Grange. They show dull panels in the far distance interspersed amongst the tree line, with large areas of open farmland around them. This will not be the experience of people using these footpaths, as they completely fail to show that the majority of the foreground of these photos is in Field 2, which will also be covered by solar panels and not the green fields shown in the site. Walkers will in fact find themselves standing in a forest of 3-metre high solar panels that are almost twice the height of the average person, rather than catching glimpses in the far distance. Policy EM1 refers to landscape and states that development must respect, enhance, and not be detrimental to the character or visual amenity of the landscape. They must also respect the sense of place, sense of tranquility or remoteness, and quiet enjoyment of the landscape from public rights of way. This policy is key to understanding the impact of the changing landscape with regard to the communities of Bramley and Silchester, as the lasting harm is far more than simply the impact on pretty views. It is about the experience of local people and how they interact with the land around them. These two communities are ancient rural settlements, and this is key to understanding how these communities view themselves. The application states that the gap between the two communities will be narrowed by 40% as the crow flies. Unfortunately, people do not fly like crows. They travel by foot, bicycle, and motor car. When tracing the routes by road between Silchester and Bramley, 72% of the traveller's journey will be an experience dominated by an industrialised landscape. This is completely counter to policy EM1, which states that developments must respect the sense of place, sense of tranquility or remoteness. It would also conflict with the guidelines around policy EM2, which state the council's desire to maintain a clear gap between settlements and to prevent their coalescence to help maintain their sense of place for both residents and visitors. On the 28th of March this year, the council passed a resolution to give additional protection to protect the nature and character of rural communities close to Basingstoke. The wording of this motion was as follows. The council resolves to ensure the character of rural communities in the borough, and in particular those villages closest to Basingstoke, is not materially impacted by development, as growth should be constrained to ensure that Basingstoke does not subsume its closest villages. To ensure villages closest to Basingstoke are afforded stronger protection from development through policy mechanisms that protect the character and integrity of the village. To refer this motion to the Economic Planning and Housing Committee to make recommendations to the portfolio to, when preparing the spatial strategy for the local plan updates, ensure policy mechanisms are included to give certainty that the character and integrity of those villages closest to Basingstoke are protected. This resolution was passed with only 2 objections and is now the formal and accepted stance of the council to areas such as this, and is awaiting updates for the new revised local plan. Not only would this proposal be counter to the wishes of the residents, but it would also be counter to the conclusions of the Development Committee and all but 2 of the council's 56 elected representatives. Surely this must count in our consideration of this proposal, as this proposal will cause irreparable harm to the nature and character of this rural area. Secondly, I would like to point out the impact on highways. I've written extensive letters about my concerns over the inaccurate nature of the swept path analysis at the junction of Minchens Lane and the Street, and as an ex-lorry driver, my concerns remain for the safety of children, parents with prams, and the elderly when they visit the doctor's surgery. However, as I've documented my concerns, I will not dwell on them now. However, there are other highways issues that have not been explored. These include the fact that the entrance and egress points for the HGVs onto Oliver's Lane is directly onto National Cycle Route 23, which is heavily used by cyclists and walkers. Given the linear nature of Bramley and the fact that access to the countryside to the south of Bramley is completely prohibited by the presence of the army camp, Minchens Lane and Oliver's Lane are the only direct access to the countryside for walkers, runners, cyclists and families with children. The access point by the Hunchback Bridge near Park Farm has received no mention of visibility displays, and I believe there is insufficient distance to adequately site these displays. The fact that 2 recent accidents on this bridge have destroyed the safety barriers clearly demonstrates that this is a hazardous area, and I would be grateful, Inspector, if you would look at this area carefully. The speed survey was timed to coincide with the first week of the second pandemic lockdown, giving residents no confidence that their safety is being properly considered. Finally, and very importantly, several herds of roe deer and muntjac freely migrate across these fields on a daily basis. The proposal will erect in the region of 7 kilometres of deer fencing, which will inevitably channel these wild animals along narrow country lanes, threatening both their safety and that of road users. The archaeology that lies under the site is also central to the permanent harm that will be done to the community and its sense of self. In 2015, Professor Michael Fulford identified Silchester or Caliva Atrebatum as being the oldest formal settlement in the whole of the UK. The Roman town is nationally important and its influence stretches far beyond the limits of the Roman wall itself. It is key to the nature of the parish, with its residents identifying intimately with their Roman past. The Silchester pub is known as the Caliva Arms. The village playground is funded by the Caliva Foundation. The village residents group is known as the Caliva Society, and even the village signs show images of a Roman horse found on the site. This proposal will permanently lose the huge villa complex that is located below Field 1. And I must draw your attention to the letter from Michael Fulford, which conducted Reading University's dig across all parish areas, across the parish for the last 25 years. Professor Fulford literally wrote the book on the subject. The loss of this archaeology directly conflicts with policy EM8, EM10, EP4, and most importantly, EM11. Others at this inquiry will talk about the loss of agricultural land, but we must recognise its importance in the context of this site. We have an increasing global demand for food, and the food deficit through the loss of this land must be made up elsewhere. We cannot manufacture agricultural land except by chopping down rainforest elsewhere in the world. We would have to import the lost grain production, meaning increased carbon miles and reduced national food security. Let us not forget that 10% of the world's grain is currently produced by the Ukraine. Finally, I must draw your attention to the truly woeful level of community engagement, which has been contradictory and misleading, and was typified by the changing position that the applicant took towards the promises over decommissioning. This has led to residents having little or no faith that their interests will be considered by the applicant. Key features of the consultation include the following. Despite the fact that almost 50% of the site falls within the parish of Silchester, I've yet to find anyone in the village itself that has received a leaflet. The growth of virtual meetings during the pandemic has made it easier than ever to convene large public meetings at virtually no cost. But to my knowledge, the applicant made only one public Zoom call over the 2-year duration of this application. Silchester Parish Council has never been approached. The applicant advertised that Silchester School would be provided with solar panels, despite never having spoken with the school, let alone conducting a survey. Allotments were promised that were located over a mile outside the settlement boundary. The forest school was promised in a field that does not yet have a forest, and without any consideration of the fact that Brownley already has a forest school. All of these sweeteners, which were promised to the community, have disappeared over the course of this application. Policy EM8 states that proposals for the commercial generation of energy will be permitted unless there are adverse environmental, economic or social impacts. Impacts include agricultural land, heritage assets, the landscape and visual appearance. I believe that this proposal fails on all of these issues. The residents of Brownley have suffered unfairly from poorly thought out development for many years, and this proposal would signal the death knell for both this village and the village of Silchester as rural communities. I humbly request to decline this proposal.
To speak there for a few minutes because there may be some questions for you. Can I clarify a few points and ask that you mentioned there was a site visit itinerary being produced. Now you've raised a few points in your evidence that I think would suggest you're asking me to go and look at specific things as part of my site visit. Can you liaise with the person who's currently itinerary?
If Mr. Mahaffey lets me know, I'll make sure that those points are passed on.
Thanks, and we'll add that to the itinerary. Can I clarify a few points with you, and then I'll see if Ms. Osmond Smith has any questions for you. It's really just to quote from what you said. The application is neither a solar park nor a solar farm, but you don't really clarify what you mean by that. Can you help me with that?
Well, it's how these things are marketed, sir. The question of a farm or a park has connotations that it's sort of beautiful and lovely and involves green stuff. This is metal and glass and toxic chemicals that will be around for many, many years after decommissioning. So, I believe that, certainly I believe, and the local residents believe, that this is industrialisation. We shouldn't describe it as a park or a farm. I think that's an inappropriate descriptor.
And I won't be able to find the direct quote, so forgive me if I paraphrase, but I think you said something like, because, as you said, it's an industrialised landscape, and in 40 years' time it's decommissioned, the land will be blighted to either be to continue industrial use or become a housing site. Is that your personal opinion, or because I don't think you substantiated that in your evidence? Can you just help me with that as well?
Yes, certainly. It is my personal opinion, but it's a personal opinion that has been developed over consultation with the appellant. Originally, we were told about this insurance policy because this was a concern of the community right from the start. Is this is advertised as a temporary installation? So we asked questions. We said, how are you going to guarantee that this is temporary? And we asked about I've been told anecdotally that this is going to be somewhere in the region of 13 million. I mean, certainly it's going to be a number of millions to commission it. And the applicant has said that the decommissioning process will be similar in scale and similar in process. So I'm guessing from that it's going to be similar in cost. Certainly we're talking about a number of millions. And unless those millions are put aside to guarantee it, I cannot see how this will ever return to agriculture. The yield from agriculture is not the same as industrialisation or from housing. My conclusion is that the inevitable consequence of this is that it will continue as industrialisation. I've been on the Borough Council, I've worked very closely with the enforcement team. To my knowledge, I think there are 3 of them. They are massively underfunded, under-resourced and overstretched. There is absolutely no way, in my opinion, sir, that I can see that they will be able to enforce the applicant to return this to agriculture. The only economic outcome, in my view, is continued industrialisation.
Two more points. The first one relates to what you said about the archaeology. So, if I understand your point, are you saying that because of the proximity of their own town to the site, that it's likely that there would be archaeology within the appeal site, or are you saying there has been work in the past within the appeal site that has definitely shown there to be archaeological interest within the site?
Sorry, forgive me, sir. I thought it was an agreed. Maybe the appellant can help me on this. I thought it was agreed and recognised that there is a large villa complex underneath Field 1. Is that not the case?
That's right.
The point being, and Professor Fulford is the expert on this, is we shouldn't be seeing the Roman site as being constrained within the walls of the Roman town. That's not the nature of how Roman settlements happened. There are a number of other sites, and I'm hoping to accompany you, sir, on the site visit. I can point to a few of them. There are a number of other sites that fall outside the Roman wall, and indeed one of the viewing points on the site visit, I'll show you. In one direction you can see the wall, and the other direction you can see the solar.
Well, I was just seeking to get a handle on, as it were, is what your view is in terms of the council and the appellant having come to a view on the heritage, whereas you're saying, well, as far as you're concerned, I take it you would not be happy with that combination. I just wanted to get behind that to understand your position on that.
I disagree with their accommodation wholeheartedly. I've lived on, as I say, I've lived here within shouting distance of the Roman site for 43 years. All of these people will support me on this. To say that there is no damage to the archaeology of Silchester is utterly wrong. Silchester, Reading University have conducted a LiDAR survey of the whole of the parish of Silchester, shown Iron Age and Roman remains across the parish. And there is a clearly identified Roman villa underneath Field 1. So how the council can come to the conclusion that there is no damage to the heritage or archaeology, I'm mystified. But certainly my argument is not just physical archaeology, it's the connection of the residents of Silchester with the archaeology that will also be damaged. If you look at any of the minutes of the Silchester Parish Council, it has a Roman horse on the top of it. If you look at the village entrance signs, the welcome signs, they have a Roman horse on it. Silchester is Roman, and to say that there's going to be no damage by this, I'm mystified.
One further question. What width would you suggest I give to the council resolution, which are the points in bullet form outlined in bold in type? I think you said that it may be carried forward into a new local plan.
The motion has been passed. It was passed in March the 28th, I think. That was recently discussed, I think it was the last EPH committee. I've proposed a set of wording about how the motion should be turned actually into policy. That's under debate at the moment. I had a meeting with the chairman of the council, the leader of the council last Thursday, I think it was. And I said, what's progress on this? And is it work in progress? The problem we face is that the current review of the local plan has been stalled for a few months, hopefully. But that is the position. The words there are the position of the council, and they're obligated, if they've passed a motion, to turn it into some form of policy or some sort of words that reflect the policy. I would ask you to put considerable weight on it, but no doubt the opponent will argue differently. Would it be helpful, sir, if I sent you the minutes of the meeting, of the council meeting?
Well, it's a matter for you in terms of what.
I'll send you the paperwork for the council meeting to start forward.
Can you wait there for a few more minutes, and I'll see if there are any further questions for you.
Just a few matters of clarification, and I make clear, sir, it's not my usual practice to ask questions or to cover topics that are going to be covered by other witnesses, but there's just a few questions that I have for the councillor. Good afternoon. You say as the Borough Council, you propose the cross-party climate emergency declaration. That's obviously something that you would expect this inspector to put substantial weight on, that declaration of the council. And you appreciate that a significant part of the government's policy, its ambitions in respect of climate change and its targets under the Climate Act. As part of that, solar forms an important role, solar energy development.
Yep.
Yeah. And yet you regard solar development as industrialisation. As a generality, you said it is metal and glass, toxic chemicals that will be around after decommissioning. It is industrialisation.
Can I respond to that one?
Yeah, please.
You need to turn your microphone on. First of all, yes, I did propose the cross-party. It was a cross-party agreement, but I proposed it from my party. But can I draw a parallel? There is a desperate need in this country for more housing. The government has mandated that we have certain targets to meet in housing, but that's not the same as saying that every housing development is desirable or right. And that's my argument here. Yes, we do need to decarbonise the grid. Other experts will talk in greater depth than I can about how that will be done. But my point is we mustn't grab at every solar park, solar, whatever you want to call it, solar site as being a good thing. And my concern about the industrialisation here is simply because of the scale. There are other solar installations in the parish or in the neighbouring parish of Little London, which are a few hectares. And nobody objects to those because they are part of an integrated landscape. They're part of diversification of farmland, and my community understands farmers and farmland and their needs to diversify. But at 200 acres, that is twice the size of my village. Surely that can only be industrialisation.
Okay, so can we agree this then, that you regard large-scale solar developments as industrialisation?
No, I regard this development as large-scale industrialisation.
Because when you gave your evidence, you said that solar farms, metal, glass, toxic chemical, we regard that as industrialisation. That was a general comment about solar. That wasn't a comment about this scheme specifically.
I'm not presenting to a committee about national policy. I'm presenting to an inquiry that's discussing this particular proposal. And I regard this proposal, because of the scale, because of the fact that it's on undulating land, because of the fact that it will close the gap between two villages in the experience of the individuals using the land by 72%, I believe this is industrialisation.
Do you recognise that as part of government policy that is to secure 70 gigawatts of solar energy by 2035, two schemes of this size need to be consented every week?
As I said, there are other people talk about the national framework. I can't comment on the national framework. I'm not involved in the national framework. What I am involved in is representing my community, representing the area that I lived. I started this deliberately with the fact that I've lived in the same house the last 43 years. I know this area intimately. I know the character of it. I know that it's rural. I know that its residents regard it as rural. This proposal will turn this away from a rural settlement into an industrialised semi-urban settlement.
Just to be clear, I asked you those questions because, as you set out in your statement, you proposed the cross-party climate emergency declaration. So I take it that you have an awareness and understanding of national policy and the scale of the challenge that's faced and the amount of renewables energy we need to meet the government targets.
Yes, it's difficult, but exactly as my point was at the beginning, is that if it was housing, we would not be asking the inspector to say there is a national housing crisis, therefore you must pass this application. There is a national need to decarbonise the grid, as I said, but that doesn't mean that every application is a good one. I believe this is a bad one for all the reasons that I've listed, and I believe it's industrialisation for all the reasons I've listed.
Thank you. Those are my questions.
Thank you.
Can we call a halt to the applause? Because it then becomes almost like a pantomime at times, and I want to be fair to everyone. So I appreciate you run quite strongly in the public gallery, but it would help me if each person gave their evidence without being applauded off the stage, as it were. Thanks. It's just coming up to 5 minutes to 1. Probably best that we don't start hearing from someone else at this stage. So we'll come back and hear the evidence of Mr. Wright on behalf of the Parish Council after lunch. Are you happy that we adjourn now and come back at 1:45? Does that give everyone a chance to go off and buy a sandwich and come for a break? Okay, let's do that. So just coming up 5 minutes to 1, we'll adjourn and we'll resume again after lunch.
Into the brief. Just okay. That's what I do. I go to the assessors.
Yeah, that's good.
think I might click the link, but like not.
Just for the framing. Yes, I've been to. When no, I'm do I produce? arrays, which are over 3 metres in height. It will be many years before the basic planting mix of 40 to 80 centimetre trees provide the intended landscape cover. The ES addendum suggests that 15 years will be required for full development of the hedgerow, which is almost half the expected life of the solar farm. The overall appearance of the boundary planting, with a few trees at 2.5 to 3 metres and the vast majority of trees at 40 to 80 centimetres, will be both unnatural and fail to meet the intended screening purpose. Northern half of the land, which is the subject of the application, is the highest grade of farmland and is greenfield land. Government policy discourages the use of greenfield sites and high-grade farmland for development such as this. Such land should be used for the production of foodstuffs, whether the direct production of food for consumption or feedstock for animals. Now, food security is a crucial social aspect, and the use of such land for solar panels when brownfield land is readily available is a highly inefficient use of key resources. The solar farm is expected to have a working life of the order of 40 years. There's no clear plan in place for decommissioning of the proposed facility at the end of life. There's no provision for funds to be available for the decommissioning of the proposed facility. Given the opaque chain of companies involved in the application, there's a valid concern that at the end of life of the proposed facility, the ultimate owner could simply walk away, leaving the decommissioning process and associated costs to Basingstoke and Dean Council, and ultimately to the residents of the area. The appellant has also completely failed to connect with Silchester Parish Council throughout the application process. We first came to hear of the proposal through Branley Parish Council, advising us there was to be a Zoom presentation on the proposal and inviting us to attend. Subsequent to that, the only contact the appellant has had with us has been to request a meeting with our chairman only. This was declined as it was inappropriate, and there has been no attempt whatsoever to consider the wishes of the Silchester residents. Silchester Parish Council support the development of sustainable energy facilities, but in the right place and at the right level. The proposed solar farm is not beneficial to the local community. It can be shown as being in contravention of several planning policies, Basingstoke and Dean, and also with government guidelines. We ask you to support the Basingstoke and Dean Council decision and reject the appeal. Thank you.
Thank you. Just stand there for a few moments and I'll see if there are any questions for you. Ms. Husband-Smith, any questions?
So, no, thank you. I mean, no disrespect to Mr. Wright by not asking any questions, but the issues I can take up with other witnesses. Thank you.
I have no questions because I've got your representations on this, which are before the inquiry as it is, so I'm quite content that you've covered the points.
Thank you.
Thank you. Okay, and as explained earlier, we're going to hear from Mr. Hall and Mr. Tomlin on Thursday. Actually, I got the right name.
Yes, Thursday afternoon.
Thursday afternoon for both.
Councillor Tom.
Okay, have you been able to get in touch with them over the lunch period?
Yes.
Okay, and
Said he would be there.
okay, thank you for that.
He also said he requested that he could join the site visit. I'm unable to because I've got knee problems. I can't go really fast. He would like to do that if that's everybody else.
Okay, well, I'll revisit the arrangements for the site visit at various points during the course of the week, and perhaps by Friday at the latest, we'll more or less have it finalised. But we will work on that and let you know. Okay, right, thank you. So we're going to move on.
Sorry, I get to speak.
Oh, beg your pardon then. Okay, Joe, I'm sorry, yes. Beg your pardon.
You can't miss me with stand up.
Do you have a copy of your note?
I don't, because most of what I have is contained within the representations already made by residents and parish council. So I didn't see the need to complicate things. Excuse me. Okay.
Yes.
Oh, you're still on, sorry.
Right.
Thank you. Thank you once again for giving me the opportunity to represent Bramley Parish. I've been a Bramley resident for 34 years. I've been parish council chairman for 8 years and a parish councillor for 12. And I was recently, in May, elected as the ward councillor. So, firstly, I'd like to state that Mr. Mahaffey's assessment is spot on, in my opinion, and the opinion of most of the residents of Bramley. And I fully concur with his objective statements. So there's no need for me to repeat what he has said so well. Councillor Tomlin will speak on Thursday on behalf of the ward councillors, which leaves me the opportunity to respect your time and give you a brief summary of the concerns from the Bramley Parish perspective. It's my role there to listen to what residents say and are concerned about and to represent them at occasions such as this. So I have summarised basically the key points and made them less emotional, I think, in some instances. Residents overwhelmingly oppose this plan, and this is a summary of their concerns that I will highlight. We're not experts, but I do believe that their voices need to be heard in such an occasion as this. So what is the real cost of the appellant's plan? It is detrimental to our environment in a number of significant ways. By our environment, I mean the local environment, not the national or global situation. It's a significant loss of open rural landscape, which defines Silchester and Bramley. It's loss of productive agricultural land when we need to look at the carbon footprint of our food chain and also ensure sufficient food supplies. The destruction and disruption to the existing wildlife habitats, being wildlife and other biodiversity assets, which have been established over considerable time, if not centuries. The loss of the open land tracts to our deer population alone is incalculable. And frankly, a flock of sheep do not mitigate those losses. Those deer will be forced onto the roads to follow their normal trail to get to where they wanted to go to. And that will be a danger to them, certainly, and a danger to walkers, cyclists, drivers, etc. It's interesting that Network Rail, who are currently working on the site to put a cable in between the Bramley Frith substation and the rail network, have experienced significant, that's what I would say, extra work to try and accommodate the wildlife in that area. And they're having to do quite a lot of structural changes to their plan, and they've extended their time frame to complete their work out to October next year. So a considerable number of months extra work just to respect wildlife in that area, which we don't believe that this plan respects the wildlife to anything like that degree. We will lose access to and potential damage to the context of our archaeological heritage, which perhaps is more within the Silchester area than Bramley, but they're all in the joint context of the area. The worst damage is to lose the benefits of the Brenda Parker Way and the footpath network. These will have a significant adverse impact on the recreational enjoyment of a truly varied outdoor open space and will result in a loss of the benefits to the mental health issues that people have. And they want to get out, they want to see open space, not corridors, however wide they may be, restricting views and open aspect. There is noise associated with the battery storage, and that again will have an adverse impact on people moving through the area and also wildlife. We've seen incidents of battery fires, and the last information we had when considering another application for a battery farm, that there isn't really a process or a plan that the fire brigade have for coping with battery fires in the countryside. So there is a real concern there for people. It will create a coalescence of two distinctly different communities, although they are both rural, by this industrial scale installation for commercial gain. It is totally out of place within the context of the two communities. And it's certainly not a temporary structure by any stretch of the imagination. Its legacy will be there, and it will not return, I don't believe. It's my personal opinion and the personal opinion of a lot of the residents. They don't see it being returned to agriculture and having the same benefits as we enjoy now. They're the facts. That's the cost to our communities. So in conclusion, the proposal seeks to have us believe solely in the applicant's narrow view of environmental benefits. I reinforce the fact that there was very poor, virtually non-existent community consultation. And this is the words of the residents. This demonstrates a contempt for the people of Silchester and Bramley. I sat in on the Zoom meeting. It wasn't very productive. It wasn't overly well presented. It was very much a box ticking, in our opinion. Again, our opinion, but that's the way it felt. We've done it. We've consulted with you. That's it, done. The change to the application was very poorly communicated. It may have met requirements, but to the individuals within the community, not everybody received a letter, not everybody received information on the change. And I think that was also true of the original consultation. Not everybody received something telling them what was going on. The mitigation offered by the mitigation offered to the significant adverse environmental impacts that I have highlighted and others have highlighted today is feeble, quite frankly, and disingenuous to the communities. And we believe that a flock of sheep, quite frankly, do not mitigate the losses that we will see in the biodiversity aspects of the environment. The appellant's plan is frankly unimaginative. It's destructive and disruptive to the communities and to the landscape. And it uses and it's a business, we appreciate that, but it uses a genuine concern of energy supply, quite frankly, for profit, with little regard to the communities that it will impact. Why do I say that? Why do the people say that? There's plenty of brownfield sites, and there's lots of illustrations in other countries of companies being imaginative, covering over open car parks, using roofs of commercial buildings, and so on. And also encouraging more use of solar on existing dwellings. Just to narrow it down, I tried to find a way just to put it in your mind. If I want solar panels for my home, I don't put them in my garden because that's where I grow vegetables, grow plants, relax and entertain. I put them on the roof. That's logical. I put them somewhere else. It may be more challenging, may be more expensive, but it achieves the best of both worlds, albeit possibly at more cost or less profit. And my garden, like many people's gardens, is a place where wildlife thrives, and that's what people want to enjoy and want to see happen. So the residents of Bramley ask you to refuse the appeal and uphold the council's justifiable grounds for the refusal of the application. Thank you.
So wait there for a few moments and I'll see if there are any questions for you.
No, thank you very much, sir.
I have no questions either, so thank you for
Right, thank you.
Okay, and we'll do a quick change if you want to introduce your first witness, Mr. Clifford.
So yes, I'll ask for the witness to get themselves set up. Whilst he's doing that, I can just give you a short list of documents that we might go to. out. So both sets of landscape proofs and the little figures have them. The location plan, which is document 1. To parts of the character area appraisal from 2021, which is document 127 for those who want to look at it in document itself.
I was just looking at my document set. Mine started 19.
The plans probably set the first set of the first few numbers are the application plans. You perhaps have them separately. I don't know.
I didn't get a hard copy of the 4 documents, so are they?
Yeah, the ones from the library if necessary.
Otherwise, I'm reliant on a small screen.
Yeah,
that's not really. Is there a spare set of them somewhere? So I'm not pinching.
Well, not sure how they've gone awry, sir.
Oh, pardon. Okay. False alarm.
That's good.
Sorry, I've sent my throats of evidence somewhere else. For safekeeping. Okay, yes.
So yeah, core document 1 was the location plan. Core document 127, which is the character area appraisal for 2021. The CLVIA document, which is called document 141. And then 2 documents that were handed in this morning, or 2 bundled documents that were handed in this morning. Just wait for methodology, which is ID 2. And then the photo montages and amendments to Mr. Grant's figures.
Okay, I think I'll just turn them up as we come to them rather than.
Legislature, yeah, absolutely. Hopefully not too many. Right, even Mr. Whitfield and have himself set up.
Yeah, just about.
Good. Now I'm going to fail to turn my microphone off at the moment, so just wait for me when I do that, please.
Have we not been able to source a master, Mike?
It's night. It's not done straight away now, because they'd have to so look at it overnight, and they might be.
Can we test your voice level without using the microphone?
So I'm sure that my voice will carry. The only issue.
Can't hear?
Sorry. I was going to say the only issue is for the webcast. I think it's going to be frustrating. I think, particularly for examination.
Yeah.
It's going to be impossible.
There is one here which I would quite like to see if it is a master, but I don't want to.
If this one isn't a master, we suspected this might have been, but.
The first one is the master.
This one here.
It doesn't reach.
Oh, well, if it reaches to that table, though, that's.
Maybe that it reaches to
I can
mine
get
and
to make sure it is the.
Sergeant Smith, and we could perhaps swap it.
Yes.
If you look careful, you're about. Yes.
Yes.
Shall we have a trial run and see if this is going to work?
I think this might be preferable.
Let's just test the system and see if it's going to work.
Yeah, we can see you on.
Yeah, that's let me on, so that's good.
Very good.
Okay, we might have a problem getting it down to you, Mr. Anstis.
Well, hopefully, Sarah, overnight we can make sure that it's sorted, and for Ms. Oswald Smith this afternoon, I'm just swap places or something to, we'll work out something if I can go into that. Good. All right. Well, without further ado, are you Mr. Nigel Wakefield?
Yeah, that's correct.
Mr. Wakefield, And I will take your introduction and qualifications from 1.1 to 1.3 of your proof of evidence. Managing Director of Node Urban Design Limited, which is an urban design, landscape and heritage practice. You're a qualified planner, landscape architect and urban designer. All that correct?
Yeah, that's correct.
And you have over 30 years experience of providing urban design, master planning and landscape services on an extensive range of developments, including solar farms across the UK.
Yeah, that's correct.
This has included production of master plans, design active statements, design codes, landscape visual, impact assessments, landscape and public realm design. And you own and run an accredited landscape institute practice, employing landscape architects, urban designers and heritage consultants. You're a built environment expert for the Design Council UK and from several design review panels, and you're an experienced design and landscape witness. Is that correct?
Yeah, that's correct.
And you act both as a consultant to public and private sector clients, including local authorities, developers, house builders, universities, and landowners.
Yeah, that's correct.
Thank you. I'm going to start. You've prepared a summary, and we'll try and use your summary so far as we can, but we'll need to dip into the main parts of your proof a little bit as well. You deal first with the site and context at 8.3 to 8.5 of your summary. And I think this is where we will want the existing location plan or document 1. And I'm just going to hand over to you at this stage to take us through a bit of an orientation, given that you're the first witness. And although many people in the room will be familiar, others won't be. So.
Okay, thank you. The application site extends across 85 hectares of agricultural land divided into 6 irregular shaped fields, positioned approximately 300 metres to the northwest of St James's Park, a residential estate which sits on the fringe of the village of Brown. Sighting approximately 290 metres north of field 1 is the hamlet of Three Ashes, and further afield to the northwest is Silchester, and to the west is Little London, approximately 1.5 kilometres away. The site is currently used as arable farmland. It's set within and provides improved species, poor semi-improved grassland, set with a predominantly rural landscape on the fringe of Bramley village. The landscape is intersected by areas of woodland, tree lines and watercourses, over which extends a single power line which extends in a northeasterly direction across field 2 from Bramley substation, and a double row of power lines across field 6 extending eastwards. Siting continues with various field boundaries to the site of Bramley Frith Wood, which is an ancient woodland, Davenage Copse, and apologies if I've pronounced that wrong, Withy Copse, again an ancient woodland, Little Holden Copse, which is also an ancient woodland, and the substation sits within Bramley Frith Wood itself.
Can I just pause you there? I don't know if everyone's got the plan in front of them, but just giving a moment just to make sure that people are catching up with where various things are. So you're familiar, I presume, at this stage with those matters that we've mentioned.
Yes, and about the plans.
I'm grateful. Carry on.
Okay, so Silchester Brook, also known formerly as the Foundry Brook, as a main river extends west to east, adjoining the northern part of the site, boundary to field 1. There are also a number of field drains crossing the site. These drains are classified as ordinary watercourses. A fishing lake is located outside of the site, but adjacent to fields 3 and 6. Pamber Forest Local Nature Reserve and Pamber Forest and Silchester Common Site of Special Scientific Interest are located approximately 1.5 kilometres west of the site.
Thank you very much. The next matter I was going to ask you to deal with are the landscape character assessments, not all of them, but we'll look at the local one in particular. So you may want figure 4 of Mr. Crack's proof of evidence in front of you. And if you could just deal with LCA 4 and LCA 6, just help us with those to start with the areas that they cover.
Yeah.
Just get figure 4.
So I think it's in the.
Sorry, I'm just taking a little time to get to there, but I'm getting there. Yeah.
So can you just start by explaining this document? And then we'll...
So figure 4 shows that the site sits within two local landscape character areas. So LCA 4, which is North Sherborne, sits to the northern part of the site. It's called green on the plan. And that effectively sits within field 1. And the majority of the rest of the site sits within Loddon and Lyde Valley local character area, and that includes the other fields identified for the solar farm. So the main difference is field 1 sits within a different character area to the rest of the site.
Thank you. And you pick up landscape character area assessments at 5.26 of your point. 5.23 is where you start. You tell us that the local level sits the basic and Dean landscape character assessment 2021 carried out by HDA Associates, that it replaces the 2001 version prepared by LPA, which was used by the appellants. LBIA carried out in 2020. You then deal with the LPA 4 at 5.26. So just to start with, can you deal with what you say the key characteristics are of LCA 4?
Yeah, so I've underlined my interpretation within there, the key characteristics. So I'll just pull out those points so the inspector can see the full text.
Yeah, of course.
So the character of LCA 4 is gently undulating. It's got a pattern of predominantly arable farmland. It's got moderate intervisibility across the site. It has a network of public rights of way that crosses the majority of the area, which I'll go into more detail later. And it also refers in the latest guidance to there are two solar farms towards the centre of the character area at Berry Court and Hill End, appearing as incongruous features, albeit that are low-lying where visible in the surrounding landscape. And it also references the remarkable preserved Roman town of Caleva Artabata, again, struggling to pronounce it, and its associated earthworks, together with many other scheduled ancient monuments, reinforcing the historic richness of the landscape.
Thank you. And then you deal, I think, with the key issues identified in the character assessment of paragraph 5.29. So just for your note, I don't think we need to turn up the character assessment in the core document, but if you want the page numbers for your note, LCA 4 is dealt with at page 52 to 57, and LCA 6, which we're about to come on to, is dealt with at page 62 to 67, and that's a core document 127.
Just on those key issues in 5.29, I think one of the interesting things that was identified in the key issues for that landscape character area was and it's my final bullet point in 5.29, was the prospect of further energy generation development, including solar farms. So particularly in this character area, it's been identified that solar could have impacts, or it's already been noted that there was a couple of locations where they're already seen as incongruous. And again, it's flagging as a key issue that needs to be taken into consideration when looking at proposals when considering landscape character.
Thank you. And then LCA 6, that's dealt with from 5.31.
Yeah.
And similar structure, if you will just.
Yeah, so just bring out the key characteristics. And I think these are really important when we're considering the impacts on landscape character. So generally unspoilt, quiet and rural character with a sense of remoteness. Relatively large-scale open arable fields with low, well-trimmed hedgerows and infrequent woodland. More extensive views possible in more open northern and southern parts of the landscape, which this site sits within the character area. And also the area is served by a network of public rights of way, including part of the Brenda Parker Way. The key characteristics. So there's some similarities between the two character areas, but there's certain subtle differences between the two that have been brought out in the character assessments.
Thank you. Unless there's anything else you want to say on, I suppose, just on character, finally, any final observations before we move on to value?
In terms of the, in terms of the landscape value overall that I come to.
Next topic is going to be about landscape value. I can move on to that, trying to make sure I've covered it.
Yeah, it's everything is done in character, yeah. But
so, common ground, I think, between the appellant and local planning authority that this is not a valued landscape in MPPF terms, and you make that same point, I think, at 8.6 of your proof. Nonetheless, you go on to assess value, and again, common ground, I think that it's a local district value. Can I ask you, please, how you've reached your conclusion on value? I think you deal with value starting at 6.19 as your proof of evidence.
So in terms of trying to establish landscape value, I refer to GLIVIA, which is the guidance for landscape from the Landscape Institute, and particularly consideration of box 5.1 table on page 84 of the guidance, which identifies as a number of factors that need to be taken into consideration. They include landscape quality, power 6.21, the intactness of the landscape and condition of individual elements, scenic quality, rarity, representativeness, where the landscape contains particular character or features which are considered important examples, conservation interests, and recreational value, where landscape is valued for recreational activity with a specific focus on the landscape, and finally perceptual aspects, notably wilderness and tranquility of the landscape.
Thank you. People will be pleased to know we're not going to go through all of them now. You've written about all of them, but I'm just going to pick up a few of them with you. Landscape quality first, which you deal with at 6.23.
Yes. So my conclusion on landscape quality, condition of the landscape is good. It's got a very the rural character between Bramley and Three Ashes, and the quality of the landscape is influenced by the Silchester Brook to the north of the site, the open undulating farmland, and the series of woodland copses, particularly things like Bramley Thriftwood, which are visible within the landscape.
Thank you. Scenic quality, please.
Again, overall, there's a good, clear pattern of characteristic elements when you consider the site in relation to the key character areas. So this idea of open views across the landscape, understanding the topography, views towards woodland blocks, views across the landscape, particularly in Field 1 when you're looking across the Silchester Brook. There's a lack of any industrial infrastructure in there, so it's a very much a rural scene, which is why I've identified good as part of the overall scene quality of the site.
Just maybe helpful to help us with where that is. Have you got the hard copy plans of
the different fields?
Yeah. Just whether it was worth to tell you that and pointing to where you mean.
So Field 1 is the field to the north, which is in the different character area. So it's the northern part of the site. There's no pylons going through that field. It's adjacent to the Silchester Brook, and it's attractive scenic quality of the landscape.
Thank you. We'll all get very familiar with which fields we're finding our way. And then I think finally, recreational value would the other topic you want us to pick up on.
Yeah, I think one of the key elements of this site is the amount of public rights of way that are passing either through the site or adjacent to the site. I think there's about 4 kilometres of public right of way, with 1.4 kilometres actually going through the site. And the proximity to the solar farm for a continuous distance of 1.4 kilometres is quite sustained through the landscape. And the recreational value attributed to the different public rights of way, whether it be the Brenda Parkway, which is a national trail, whether it be the Silchester Trail, which is a circular route, and also the St James's Way, which is a route which has been identified as part of de Santiago, the English version, which is going from Reading through to Southampton, and it passes through this site. It's not identified as a national trail, but it has been identified as a route of where pilgrims in the past would have travelled along the site, through the site, and have experienced landscaping for a long period of time.
Thank you.
And I just check something at this stage in terms of what you're saying is recreational value. Can you all hear me if I don't use the microphone? Are you basing that on the fact that, from your point of view, there is recreational infrastructure in place, so therefore it has recreational value? Or are you basing it on the fact that, whilst for MPPF purposes it's not a valued landscape for local residents, it's a valued landscape? And did you observe its use?
Yes, so when I was out on site, there were a number of dog walkers walking along the routes. There were cyclists, because not only is it a recreational value for walkers within the environment, there is also a cycle route. So I think I mention it here, don't I? Forget the name of the route.
Perhaps if we pick up Appendix 2 to your group evidence.
Yeah.
That's got the routes, I think, set out on there.
Let's go to that then. Appendix 2. Yeah, sorry, what I was grappling with was National Cycle Route 23. So if I just see how it forward.
It's page 9 of the appendices right now, if you're looking.
Two. I think it's prior to the visuals. So while we're on recreational value, I think it's worth talking about the routes and the people that are using the routes in a sort of high sensitive receptors. So if we start with the Brenda Parker Way, that is identified on the plan in white. And it's a long distance walking route, which is a national trail that is travelling north-south or south-north through the site. You can obviously walk it in both directions. It goes along the northern edge of Field 2. From that route, you can see into Field 1. It then diverts south across Field 2 over to Bramley Frith Wood. It then passes through the woodland, and then passes Field 6, and then finally travels along a track out down towards Bramley. So it's a kind of key route. So I think the point we're making there about the National Trail is that you're not only having local residents that are using that trail as a recreational value, there's other people from outside of the area that want to do a longer distance walk. I think it's approximately 65, 68 miles or something. So again, there's the importance of that as a recreational route. I think needs to be recognised. As well as that, there is also the Camino Ingles de Santiago St James's Way, which is the yellow route, which passes through Three Ashes to the north. It then passes over the Silchester Brook and into Field 1. It follows the topography, which is sort of rising, peaks in the middle of the site, and then dips back down to an additional watercourse. It then travels across Field 2 to Bramley Frith Wood, and then follows the Brenda Parker Way for a number of for a section, and then it diverts off further south, as you can see the yellow. Where it meets the track and Brenda Parker Way. So that layer. And then also on top of that is the Silchester Trail, which is a shorter route. Maybe I should just mention that the Santiago route starts in Reading and ends in Southampton. So again, it's a long distance route. So you might get people walking that route who aren't necessarily local that are doing that route and then passing through the site. And then the Silchester Way, which is Silchester Trail, which is the dashed line on the plan. And again, that generally follows the Brenda Parkway through the site. There's a number of series of other public rights of way which you can see on the plan. So 3A, 3B, 502. And finally, the one I haven't mentioned is or haven't explained where it is the National Cycle Route 23, which is a Sustrans route, which is, again, a connection of a series of different cycle routes that all connect together across the UK. So again, you might get people on this route that are not necessarily local, but locals will use it as well. When I was on site, I saw a couple of groups of cyclists cycling along that route, and that passes through Three Ashes, along Bramley Road, down Oliver Lane, and then Minchens Lane round the boundary of the site. So it intersects with Field 2, it intersects with Field 4, and also intersects with was on the edge of just beyond Field 5 on that. So yeah, I think in terms of recreational value, it's not just the recreational value is not just for locals. There's more of a recreational appreciation of people from further afield that are using and appreciating the landscape in the context of a wider landscape where they're passing through. So, for instance, a number of the routes are passing through the kind of historical landscape of the Roman town to the north before they pass through the site. So, having done lots of long distance routes myself, that appreciation of the landscape and how it changes is quite an important aspect. That sort of perceptual aspect as you walk through a route, you remember certain elements as you pass through that, whether it be an urban context, whether it be a rural context, and then other things that are on that route. So there will be a change to the appreciation of the landscape as you pass through, from one which is a kind of open rural landscape on these recreational routes to one which is either initially you'll see major adverse impacts from the solar farm itself, and then they will reduce with some of the mitigation. But again, it will change the perception of how you appreciate that landscape, because you're changing the condition, changing the view, you're changing the character of that.
Just on that point, so I understand what you're saying in terms of the longer distance routes.
Yeah.
Where the landscape does change. Are you saying that for this part of it, where these fields to be developed in the way proposed, that would degrade the overall experience of the person travelling the entire length of those longer distance routes?
Yes, I believe so, because the experience will change from and people appreciate the landscape and how it changes across a larger area. And the historical, again, I think we've got some up in my appendix. I've got some historical plans to show what the landscape and how that's changed over time. If somebody's walking, for instance, the Santiago and St James's Way, the appreciation of the landscape is quite an important aspect, because it's a sort of reference back to historically of how people appreciate the landscape over a longer period of time. And that any change to that with kind of modern industrial elements within the landscape you will remember that on that long distance route, because it's significantly different to what you've been experiencing elsewhere. It's not built form; it's a different character. So I think there's potential negative impacts on your appreciation of that route because of and because the routes are travelling for 1.4 kilometres. There's a lot long distances through the route. It's not just a short section you're passing through those trails. You're passing for long distances where you're adjacent to solar activity, and particularly in construction and in the year zero, when there's no mitigation, they can be very prominent within that.
Thank you. That deals with recreational value, and we've started to sort of headline some of the points that we'll look at in terms of the landscape effects and visual effects. Before we move on to consider those issues in more detail, can I just ask you to deal with your overall conclusions on value, which are at 6.39, 640 of your group?
Yeah, so overall, my assessment, considering all the factors within box 5.1 as I've already set out, is that the site has good landscape value.
Thank you. And Fine. Is there anything else to do with on value, or should we move on to effects on landscape?
I think the only point I would make in 6.440 is that the LVI identifies that the site has local and district value.
Yeah.
So there's a recognition that it hasn't just got local value, it's got wider value. And I think I'm identifying the sort of wider value of the appreciation from what we've just talked about in the recreation.
Thank you. Landscape effects then, and before we deal with your conclusions on landscape effects, we just need to introduce the new document ID2, which went in hard copy this morning and circulated at the end of last week. It's appendix 7. It intended to be appendix 7 to your proof to work behind it. And can you just help me with what this is?
So this is the landscape assessment methodology that we've used to come up with our conclusions on
Just going to pause a second. I don't know whether the inspectors is the document.
It hasn't gone in there yet.
It hasn't made its way in there yet. That way it's
yeah, that one.
ID2.
Yes, so this sets out our methodology for undertaking LBIAs and sets out the consideration of two things that we take into consideration. One is landscape effects and one is effect on views. So page 47 of that document, you can see it setting that out. It also sets out how we appraise landscape effects. And it then on page 48 identifies quality, landscape quality, and identifies 5 criteria: very poor, or good and exceptional. It then considers landscape value and again has a scoring matrix from very poor up to very exceptional. Susceptibility to change. So the susceptibility of change is the ability of the landscape receptor, the overall landscape or condition, a particular landscape area type, or individual element or feature or perceptual aspect to accommodate the proposed development with undue consequences for the maintenance of the baseline position. So susceptibility to change is on a 4-level assessment, so from low, medium, high, and very high. We then identify landscape sensitivity by correlating susceptibility to change against the identified landscape value. And we then look at the magnitude of effects, and they range from negligible, low, medium to high. As part of considering the magnitude of effects, we're considering the scale and extent of proposals, the permanency, the proximity to that development to come up with the overall conclusions in terms of determining landscape effects. And then effectively we've got a table which correlates sensitivity to magnitude of change, which then that effectively comes up with our whether it's a moderate, whether it's what the impact is in terms of landscape effects. And we have the same effectively for visual sensitivity. Similar tables, similar cross-referencing. I'm happy to, if there's further questions on that, but
I'm sure if there are questions, then I'll leave others to ask those in due course. People will have differing levels of familiarity with dealing with these sorts of tables. But if you could just help us with what you would say the key areas of agreement are first between you and Mr. Kratt in terms of the inputs.
Yeah. Let's get to my brief. Seem to have lost my own proof.
So I couldn't quite hear that.
Sorry, I've lost my own proof from I've got so many things open now. I don't know whether I've deleted it.
It's easily done.
Bear with me.
Maybe a hard copy just behind you.
I should be able to get to it relatively quickly. Yeah, just remind me which section I need to go to.
So we're looking at effects on landscape capture, and they're dealt with at 6.41 onwards. Perhaps if I take them in turn, 6.42, you identify that the LVIA accepts large scale effects on the character site due to the proposed development of a solar farm. Large scale effects on the character, given the fundamental change of existing landscape character from an agricultural landscape to a solar farm.
Yeah.
That's in terms of, I think, the site and its immediate vicinity that the LVIA says that. How does your assessment accord or disagree with the scale of effects?
So we agree with the LVI that there is large scale effects on the character due to the because of the proposed development. I think where we disagree is the so I say within 6.47 the LVI states, considering both value and susceptibility, taking into account North Sherborne LCA judged to be a medium to low sensitivity to proposed development. My view is that it has a medium to high sensitivity to proposed development based on a good local district value and a landscape value with a medium high susceptibility to change. So that's based on my table within the where we've just been in terms of the just refer you back to the table
in ID2.
ID2, yeah. So that's table 1.4. So we've got medium sustainability, medium to high susceptibility to change,
okay,
versus a good, which comes out with a medium high sensitivity.
And so susceptibility to change is one area that you and Mr. Kraft disagree.
Yes.
Okay. And if I've understood your table right, that then feeds in, does it, to landscape sensitivity?
Yeah. Right.
Fine. Okay. So that deals with the landscape sensitivity side of things. Scale landscape effects then of magnitude. Agreement or disagreement in terms of magnitude?
Our indications are that we see the magnitude being higher than in the LVIA, which means that our overall impact is of a moderate adverse impact rather than a moderate to slight adverse impact in relation to LCA 6.
So moderate slight adverse in terms of LCA 6. What about that's the LVIA's assessment?
And then in comparison to the LCA 4, my assessment is the site, and within 350 metres of the site, it would be moderate adverse, but agree with the LVIA that beyond that distance there would be minor adverse to negligible, but within the site the LVIA
is your 6.48?
Yeah, sorry, yeah. So the difference is against that character area. The LVI assesses it as moderate adverse, and I assess it as moderate to major adverse in terms of that character area.
Thank you. And can you help us all with the reasons why, professional judgment of the reasons why you differ with Mr. Kraft?
Yeah, I think because I think it's really important to consider the site in relation to the character areas, in relation to the site and the immediate locality, rather than assessing it against the whole of the character area. These character areas are very large. So if you look at the impact on the whole of the character area, then you can reduce your kind of impacts. But I think it makes a bit of a nonsense of the assessment of the impact on that character area if you don't consider the most important thing is what the impact of this proposal, this site, is on the character area, rather than considering it against the whole of the character area, which is hectares and hectares of land. That's probably why my assessment is higher than in the LBMA. One of the reasons, as well as my professional judgment in terms of the features in relation to the site, so Silchester Brook to the north of the site, and those landscape character elements that I think are important to be taken into consideration, is why I've come out with that conclusion.
Thank you. Anything else on effects on landscape character that you've wished to deal with before we move on to visual impact?
No, I think that the differences are within the site and within close proximity. I think there's agreement on the impact on the wider landscape. I don't think beyond 500 metres to kilometre away, the impacts are great. It's really on relation to the site and the immediate context.
The site and immediate context.
Yeah.
Okay. Visual effects then. And 7.1 of your proof, you deal with 4 key considerations, I think.
Yeah.
And I'm trying to take each of those in turn with you. Is the first 3. Size, scale, impact and orientation of development. Pick a plan that you want to explain this by reference to. By all means, if that helps. Certainly a visual learner.
Yeah, I mean the mitigation plan that we were given, figure 10, but that's probably as good as any.
So that's where that is. That's the old version is in figure 10 of Mr. Kraft's figures, and then the new version was handed in just before lunch as a separate document to replace.
I think it's that one actually as well. So yeah, so on that plan you can see the 6 fields where the solar panels are to be located on the kind of undulating topography of the site. I think the size and scale of this proposal is very large. I think we've already talked about a number of football pitches. I think in my proof I was referring to the whole area, whereas I think the other reference was to a smaller area. But also I think other considerations need to be the way the solar panels are actually orientated. Obviously, the solar panels need to be orientated in a southerly direction, so they can gain the most from the sunlight, or within a particular arc of the sun. So when you're walking adjacent to the panels, you'll see them from different aspects as you walk past them. So in some locations, you will see the panels en masse with the glass rising up across the topography. So if you, for instance, if you are looking from the bottom of field 1, looking north from the public right of way, you'll see the massive glass creating a kind of block, a mass basically, because they kind of interlock as you look at them. And we can come to that in terms of some of the photo montages that have been undertaken. But then in other locations, you're walking at the side of panels. So rather than seeing the panels flat on, you'll see underneath the panel. You'll see the side of the panel. You'll see the kind of the rake of the panel. And then in other locations, so for instance, in field 2, where you're walking along the Brenda Park Way either on a permissive path or along the road currently. You'll see underneath the panel. So basically the higher point of the panel will be, so if I just point on this plan, for instance, in this location along here, panels are facing that way. So you're basically looking at the back of the panel. So the panels is basically tilted that way. So the higher part of the panel will be in close proximity to the public right of way as you pass along that element there. So what I'm trying to say is that you don't see the panels the same way. You see them in different ways as you pass through the landscapes are sometimes flat on. And that has impact because ideally, when you're looking at the back of the panels, you're seeing something that is 3 metres in height. And if we're saying an average person is 1.5, 6 metres in height, the panel, the closest part of the panel will be double the height of you as you're walking on that path, particularly during construction and in year zero. What you won't be seeing is the glass. You'll be seeing the framework underneath. You'll be seeing the structure with the glass. So it does look more kind of industrial and doesn't flatten off as it would do, say, if you were looking from a different perspective. So I think just wanted to raise that as an issue for consideration, that it will impact on users of those public rights of way in different ways as you pass through the landscape, which I think is important because they can have a more dominant impact, particularly if the higher elements is closer to the public right of way, because particularly in that location in Field 2, Bramley Road at the moment slightly lower. So if you're walking along the road, it's about half a metre lower or metre lower than the field. And then you've got a 3 metre panel in the field, and that panel is only, somewhere between 5 and 10 metres, or 15 metres from where you're walking. Then that's going to appear very, very large within.
Are you saying that is a time-sensitive effect in terms of? Did I understand you to say that if you're walking along that in year one, taking that road in year one, it's going to be particularly visually jarring? Does that mean that when mitigation kicks in, it will be less jarring or not jarring at all?
It will have mitigation. I'm going to go on to mitigation in a bit more detail, but mitigation will have some benefits. But but it will also have some disbenefits in terms of, I'll come on to this field of view and distance of view across the landscape. So how you appreciate that
specific effect that you've mentioned.
What it will do is it will, depending on the height of the mitigation, it will, rather than providing a wall of solar panels, it will provide a structured landscape edge, but it still provides a barrier to sort of visual appreciation of the landscape in that location. And I think one of the reasons I wanted to raise this was because the photo montages don't really do justice to how people will appreciate the solar panels walking through the site. The impact of in locations like that hasn't been expressed, and you haven't been able to have the benefit of seeing that as an image to be able to appreciate that. So I think it's important that I try and create a sort of mental picture of what that will be like in that location, so you can take that into consideration when coming to your conclusions, because the proposed photomontages that have been provided have been located in locations which are either a long way away from the site or the one that is within the site. So for instance, on this plan, I think it's visual H, which we can go to in a minute if we need to, is not at the effectively every time a photo montage has been done, it's been done in a location which is tried to make it look at its best rather than the true impacts. And Glivia talks about looking at kind of maximum effects, maximum scenarios in terms of being able to visualize that, because it's no point looking at the places where it doesn't look so bad. You've got to look at the places where it does look worse and take that into consideration along with the other viewpoints around the site. So that mass and scale it is not fully appreciated within the appellant's photo montages. So in my view, it is a view of the impact of the scale and the mass of proposed development. And ideally, it would have been better if there was photo montages in field 1, for instance, in field 2, where we've got the Bramley Frith, where we've got the Brenda Parker route, where we've got the new permissive route, to demonstrate how the mitigation is working in relation to those impacts and to that scale, because otherwise you're not getting a full picture of impacts across the scheme. The photo montages have been done in a way to make it look as good as it can, but despite that, there's still post mitigation. You're still going to see solar farm along those public rights of way. I don't know whether do we want to go to the photo montage?
We'll take those up in a second. Let's just, if we can get through your key points. You dealt now with high mass and orientation.
Sure.
You dealt with what you want to say about that. Yeah. I think we've covered public rights of way a little bit earlier.
That's fine.
Just 7.20. Can you just help us with what you say the sensitivity of those rights of way is?
So that's 7.20.
Yeah.
Yes, I'm just saying there, the number of public rights of way through and within the vicinity of the site are important, as they represent highly sensitive visual landscape receptors on which to assess visual impacts. It goes without saying, the more routes and the longer the distance of those routes, the greater the potential visual impact on the users of those routes, particularly where the nature of the view is currently open. In total, 7 public rights of way either pass through or very close proximity to the site.
Thank you. I've looked at those. Then if you just go to page 7.26, is where you deal with 2 issues that you were just mentioning. So it's sensible to deal with those now. The issue of distance of view and field of view.
Yeah.
And you deal with those visually as well, Appendix 5 and Appendix 6 of your brief. So can you just take help the inspector with those?
Get to Appendix 5 first. Yes, after all the photo montages. So on that plan, and I think one of the key important ways you appreciate the landscape is not only what's in close proximity to you, but what you can see in the distance, and how the landscape currently is a kind of open landscape that you can visually see across. And one of my concerns is that the mitigation may well hide the solar panels or look to hide the solar panels. But what it will do is have unintended consequences of blocking these longer distance views and how you appreciate the landscape. So, for instance, if you're on in field 1, walking along the public right of way, which is, we've already talked about the amount of routes that are cutting across that and the importance of those routes. But for instance, you can see there a series of arrows, so 1 and 2. So when you're walking along the public right of the way, at the moment you get a view across the landscape, across the Silchester Brook to the other side towards Three Ashes, and you visually can see about 400 metres across the landscape. With the buffer planting and the mitigation and the continued sort of increase in mitigation planting that's being proposed, rather than being able to see 400 metres, you're going to be able to only see maybe 5 to 20 metres until you get to a block of effectively woodland planting on the edge of the proposal. So rather than being characteristic of this open landscape, which is we've already talked about as part of the two landscape character areas, you are effectively truncating these views. And this doesn't happen just in one location, it happens in virtually all of the fields as you walk around. So as you pass through the site, these views can range up to, I think the highest I've got is about 720 metres, which is view 5. So on the public right of way, being able to appreciate the landscape, the open landscape across the field, are going to be significantly reduced, and the same with views 6 and view 7. So the impact of mitigation, it achieves one aim, but it then has a detrimental impact in terms of the landscape character, because what it does is it stops you having that open character, which is a key element within the landscape, and starts to put in mitigation, which is uncharacteristic of the overall landscape character type. But not only does it affect your visibility across the landscape, if we move on to appendix let's move on to that further. It also affects your field of view. So there's two plans showing this. So the top one shows your kind of current field of view, and a typical current field of view is typically about 130 degrees as a human. When you're looking across the landscape, you've got a kind of very wide sort of appreciation of the landscape. What's going to happen, in my view, is when the mitigation goes in, because it needs to be of a certain denseness and a height, it won't allow that field of view to continue. What it will do is it will narrow that field of view, which will change your appreciation of the character of the landscape. So rather than having that kind of open field, which is typically characteristic of the landscape, it creates effectively a very narrow cone of vision. And I'm suggesting that cone of vision is likely to be reduced to an angle of approximately 30 degrees. So having enjoyed a 130 degree view, that gets very much narrowed because of the implication of having mitigation on kind of two sides, or there's already an existing woodland feature, for instance, on the other side of Bramley Road, which stops you having that wider view. So consequence of both shortening views and reducing field of views is kind of unintended consequence of the mitigation, effectively, but it does have landscape impacts. If we were to go to, well, we're going to go on to viewpoints, aren't we? I can probably mention that.
Yeah, we're going to press on to viewpoints shortly. Just before we do, you were going to highlight, I think, by reference to the fourth topic that you've raised, the approach to assessment findings, the LBIA, a few of the key differences in terms of approach.
Yeah. So if I just move on to that.
7.35 of your proof. Don't feel that you have to go through all of them.
No, I won't go through all of them. So the main difference is, I suppose, between us is the amount of viewpoints that we've taken and the amount of viewpoints that were taken within the site. So I think I identified, I can't remember the number now, but quite a lot more viewpoint, 26 or something. And the LBIA has only 15 locations. And the way the LBIA assessed it is taking effectively representative viewpoints, whereas I have taken a number of specific locations and then referred to the user of those routes, which is an appropriate way to do that in terms of assessing who's it impacting. So it's not the specific point; it's the user of that route and the impact on the sensitivity to that user. And when I went through the LVIA, there was no viewpoints within the public right of net, no viewpoints taken within the site itself. They were all taken on the edge or outside of the edge. So I think that is reduced the overall impacts in terms of the assessment across the site. And I set out in my 7.47 what I see as the overall impacts both in construction, year 0 and year 15, whereas I think the LVIA hasn't assessed the construction period phase separately as an impact. Have just gone to, I think, year 1 and then a sort of longer term impact. So that table there is useful for you to inspector to look at where I'm identifying greater impacts, particularly on the residual. I'm identifying more major adverse impacts because of the fact I've taken into consideration year 0 and construction into account, and obviously without mitigation, with the size and scale of there is going to be major adverse impacts from a lot of points, as you can see in that table. And I've also identified that those impacts will be helped by mitigation to a certain extent, but I don't go to the same level of reduction. So I'm, for a number of the key viewpoints, my assessment is that those impacts will still stay moderate adverse across a number of those points. What I don't do is I don't collate different representative viewpoints with different assessments and then downgrade the overall assessment. So, for instance, having 4 with a higher and then 2 with a lower, I would have those in different categories of assessment impacts. Whereas there appears from the LVIA that a generality of walkers along a certain public right of way have all been grouped, and then a general overall opinion of the impact. Whereas these are assessing each of the impacts on specific locations, which are all outlined within my appendix. If you've got each of the viewpoints in, which we can go to.
So just to be clear for my note,
sure.
Are you saying that the appellant's LVIA is deficient and not Glivia? Or are you saying that what you've done goes beyond what would be expected?
Yeah, so I'm not saying what the LVI is not Glivia compliant, because it does talk about representative viewpoints being a way of doing that. I think because the site is so large, I think there is a need to do additional viewpoints and actually definitely pick up viewpoints within the site. So I think I would say that was a missing component of the LVIA, that it didn't pick up the viewpoints from public rights of way within the site itself. So, for instance, through Field 1. And I think by having a large number of viewpoints from specific locations, you get a clearer idea of what kind of kinetic nature of the view is and how it changes across that route. Because it's quite hard to do a representative viewpoint, because as has already been raised by some of the residents, the idea of taking a view from a particular location, because there's a lot of existing intervening vegetation which hides the view, and they say, that's my representative view, so the impacts are less. So I think what I've tried to do is compare, and I think what Glivia does talk about is looking at maximum scenario, maximum effects. So picking those points where, what I was trying to make earlier, I think, where the impact is greatest, because those are the ones you need to demonstrate you've taken into consideration as part of your assessment. And I don't think the LVIA picked up all those maximum scenario cases, so that's where we would disagree. But I'm not in the use of representative viewpoints.
Thank you. I want to make some progress.
Yes, sure.
Because I'm conscious of the time. So just turning to the specific viewpoints that you want to deal with, and please just pick a couple of them that you want to deal with. So the inspector has your evidence on them, and obviously will form his own professional judgment on his walks.
So if I could just, for instance, refer you to viewpoint 13, which is page 25. So that's in field 1, viewpoint 13.
Give me the reference again. It's in your appendices?
It's my appendix, sorry, my appendix.
20, page 25. Might numbering is slightly gone for the page.
Yeah.
So I think this is one of the viewpoints that wasn't assessed for the LVIA. And I think what this image is showing is this kind of rural, open, undulating landscape, but also these longer distance views across the Silchester Brook. So you can read the landscape by looking at the trees along the Silchester Brook at the northern end of that field, and you can also appreciate that there's sort of open views going towards Three Ashes. You can see the public right of way, and also the distinctive elements of the kind of large oak tree within a kind of open landscape. And I think if you were, and again, ideally there would have been a photo montage of the construction year 0, year 15 for this location. What I would suggest is that the impact is going to be major adverse, definitely in construction in year 0. That may be reduced to sort of moderate adverse in the longer term, because for me the detrimental impacts is not just about hiding a solar farm. It's about the impact of your appreciation of the wider landscape, and particularly if you're walking along a national trail or a longer distance route. That appreciation of where you're heading to and whether you can see family thrift woodland, or where you use those features within the landscape. If anybody's gone out using a map, you look at where the blocks of woodland to work out where your route is, and you sort of use that as a way of. And I think what will happen is there's going to be a kind of wall of planting and mitigation, which again will reduce the sort of visual impact close to it, but it has these, I keep saying, these unintended consequences of your appreciation of that wider landscape will be lost. And that's the same for a number of the viewpoints. So I could point to, again, I'll just point to one more probably. Quickly. So, for instance, viewpoint 10, which is on page 22, there's going to be a point where you see both panels within field 1 and field 2. And particularly, I think, when you're walking along, so I'm going the wrong direction, Bramley Road, so viewpoint 6, again, viewpoint 5, I think from those, for instance, from those viewpoints, you can make out the different kind of landscape woodlands and blocks, which sort of are going to be lost post mitigation.
Thank you very much. Should we pick the photo montages up now? Just deal with. I think we're just going to deal with the latest batch of them.
And there's only one I really wanted to refer to.
These are plan 1 or plan 2. And I think the one that you want to look at is the one that was taken from, it used to be an illustrative viewpoint H.
Yes, the H one to refer to. So it's that one.
Thank you.
Viewpoint 11.
Yeah.
Okay, I've got several under viewpoint H.
Yeah. So if we can take them from this, the first one's year 1, then we should have year. Yeah, there's the left and right. So you get, so year 1 there's 2, year 15 there's 2. So there should be.
There's also existing.
Existing as well. I think what I wanted to say to you was year 1, year 15, because that one shows the mitigation. And so I think if I just talk to you, my first point, which is probably the point I made earlier, is again, it's been picked in a location where it's tried to minimise impact. So It's picked field 2, but it hasn't picked field 2 adjacent as close as possible to the solar. It's picked a point where there's the maximum distance between location and the edge of the solar farm. So again, cross-referencing with showing the viewpoint. And the point, I think the point I'm making is, even taking it from a position which isn't maximum scenario worst impact, my view is that's having definitely year 1 a major adverse impact. I think what it also emphasises is how the topography in field 1 impacts on the mass of the screens. So field 2, you're seeing very much a sort of 2-level panel in the skyline. But when you look directly down the public right of way, and this is what people are going to be appreciating as they walk along that public right of way, which we've already talked about, it's used by lots of different groups, you get the banking of the solar panels banking up the slope across the landscape, so the mass appears bigger than it would do if you're just seeing a single row on a flat field. Then a photo montage showing the year 15 impacts. I think what this is showing, and it's that one. You got that one. Yeah. So what that's showing year 15, and remember this is post mitigation. You're still seeing the bank of solar panels en masse in field 1 as you walk along the public right of way. What it is showing is that there's some reduced impact on field 2 due to the planting of a hedge and some trees. Again, it's difficult to know the accuracy of the photo montage image completely, because I'm not sure what that height is, the parameters have been put in terms of the hedge line along there, but it does appear that it is reducing the impact of solar panels in field 2 post mitigation. But again, I've made the points. It's trying to make this look best case scenario rather than worst case, which is what Glibia
is that from the north looking south?
That's from the that's from that arrow. That's from that arrow point, the orange that's marked on that plan.
Because if I'm on the Camino, presumably the predominant route of travel is from the north to the south.
It is on that route, but that route's also used by locals in both directions, and it's also part of a circular route, which is the Silchester Trail. So people are appreciating the landscape in both directions. So I think the point I'm making is that when I read the proof of evidence from the appellant, it appeared that the mitigation was having the impact of hiding the solar palm completely. And I think both from this photo montage, it's showing it's not possible, but also if you look at the plan, there's going to be numbers of locations where you've got gated access across tracks. Access to field 4, you've got rising topography in field 4, so there's going to be a number of locations that post mitigation there is going to be impacts on landscape because of the visual impact of the solar farm. So despite there being quite deep levels of planting and even subject to the points I've made about field of view and distance of view, I think it's important to identify that there is longer term impacts, not just impacts in year 0 construction.
Thank you. Does that deal with the photo montage?
I think so, otherwise we'll
Great, cool. We were going to deal with mitigation, but I think the points that you were going to make are either in your proof or we've covered as we were going field of view. So I think we can just move then to the final part of your summary and conclusions. You
begin at 8.41 by identifying what you see as the a way of minimising both landscape and visual harm. Ask you just to deal with the headline points that you make there, and then turn to your conclusions.
Yeah. So, from my perspective, it appears that the quantum of solar panels has been the leading element in terms of the proposal, whether the landscape can accommodate the amount of solar panels. And in my view, there are certain fields which are more sensitive than others. So, for instance, field 1, I think it's got a higher landscape quality and sensitivity, and shouldn't have any solar panels in. And there's also is devoid of any other kind of existing pylon infrastructure. I think there's certain parts of the site, such as field 6 and field 4, and field 5 to a certain extent, which are further away from public rights of way. And also, through appropriate additional mitigation, you could get a solar farm which wouldn't have as many landscape impacts as the proposed development as set out within the within this plan. So I'm not against solar. I think solar is appropriate, but I think if this appeal was to be refused, an alternative scheme could come forward with less landscape impacts, but still provide a certain level of solar provision within this locality. And I'm suggesting field 1 and field 2 are more sensitive than fields 4, 5, and 6, and a more landscape-led approach, in my opinion, would have identified these sensitivities and looked to maybe reduce the scale of it to reduce the landscape harms. And I think I set that out in my proof of how, particularly, I talk about creating a slightly deeper woodland edge to field 6, and where you could remove the solar development. And then finally, I conclude in 8.44. I think it's important to set the site is within a wider historic landscape context. There is some historic plans we haven't gone to, but appreciate time. But I just point the inspector to have a look at those historic plans. This open landscape character has been a characteristic of the area for a long time. The impact of that mitigation, changing that character, is significant. The impact of those undue consequences of the mitigation, field of view and distance of view, I think is important. And I think I haven't seen a site where I've worked on before where there's so many public rights of way within very close proximity to solar farms. I've seen lots of solar farms, but often they're away from public rights of way, and then they're accessible. So I think the difference here is the number and the significance and the proximity, which means that this isn't appropriate for this level and scale of solar farm.
Thank you very much. I'm afraid we're taking a little bit longer than we intended in chief. Apologies for that. So it probably saves Mr. Wade from having dinner with me this evening, because he'll be heard in cross-examination, but we should still be able to finish landscape tomorrow.
Okay. Do you want a quick comfort break before?
So I think so, not least to try and resolve the microphone issue.
Yeah. Can we come back at 3:30? Is that time enough? A bit more?
Bit more, please. Yes.
I'm prepared to stretch it to 25 minutes to 4.
Thank you.
Or do you need more than that?
No, that should be sufficient.
In that case, can we see where we are around about 5 o'clock with the witness?
Yes.
How much more we need to time we need to spend on. Okay, just coming up 25 past 3. Let's adjourn and resume at 25 to 4. 2, and we'll resume. But I'm just going to check a few things housekeeping wise. So, about a few minutes, Mr. Francis is here. Just while we're waiting on returning, can I check with the council in terms of leaving stuff in the room? We're fine tonight and tomorrow night and Thursday night to leave stuff. There's no demand on the room. But, okay. I presume most people will take stuff away with them over the weekend. Does anyone wish to leave anything at the council office over the weekend? So we don't need a storage room, that's good. And we're okay next week in terms of leaving stuff overnight as well?
Yeah.
Okay, thanks. What I'll also do then each day of the inquiry is just to check with everyone on where we are with the timetable and also where we are with conditions and our site visit itinerary. I think I'm slightly previous at the moment to chase those matters, but perhaps overnight you could have a quick think about timetable, especially, and we get a feel for how you think things are going. We will press on as best we can this evening, but it may well be that we'll have to lock your client away overnight.
I'm sure Mr. Wakefield will be grateful. I can watch the World Cup in peace.
I'm happy to continue as long as possible, but if we need to work, if we need to do a bit later, I'm happy to stay on.
Okay, well, on that one, may go a bit over our 5 o'clock deadline, but I wouldn't like to go too far over because other people might have to be awake actually. Also, your stamina to take into consideration. So we'll see how we get on.
Not too.
It also occurred to me that that's actually a better witness table in terms of the space for the witness. Also, the fact that they're facing towards the body of the Kirk, as it were. Does that throw up problems, however, with the live streaming?
My view certainly is that the live streaming can mainly, I think, see my boxes, which is probably designed for the room. So
Beauty screens.
there's probably not much being lost.
So should we keep that as a witness table?
I think we can just see Mr. Wakefield on there, can't we? Actually, yeah. So
Would the parties be happy if we kept that as the witness table?
yeah.
I think it avoids it avoids any significant microphone shuffling as well now, which is quite helpful.
It's not come back.
And the patience is in him.
I'm tempted to say the press out because obviously we've got no question. This is for this witness. It's like fair.
If it helps, sir, I don't think that the timetable is terribly constrained tomorrow. I think we'll get through quite comfortably. My initial time estimate of 2 hours, depending on how I get on Mr. Wakefield, I imagine that will be considerably less. These conferences, are they? This one is really.
You can thank.
It's not from there.
It's open. You're exactly.
It's, you can't find an answer where they are, so.
Press on.
Thank you, and hello, Mr. Waterfield.
Hello.
First place we're going to start is board document 41, please. As you've received when you turn that is the officer report to the planning committee. Can you just tell me when you have that?
Yeah.
Turn within that, please, to page 40. And we go here in the context that this was a proposal that was recommended for approval by the case officer, yes?
Yes, that's correct.
And if we turn to page 40, we can see it in bold about halfway down landscape officer. Do you see that?
Yes, I do.
And we have initial comments, objection on grounds of impacts on landscape character and visual amenity, and the mitigation proposal shadow would be offsetting harm.
Yeah.
Then we go to interim and we see objection on the grounds of impact on landscape character and visual amenity, the mitigation proposed not adequately offsetting the overall harm. And final comments, no objection subject to conditions.
Yes.
And if we turn to core document 48, unfortunately, the pages aren't numbered here, so you have to thumb through to find out if you're looking in hard copy. That's about a quarter of an inch in. It's core document 48, and we see there the full information that supports essentially the summary that was set out in the
Yep.
And what followed from the submission of the application was a process whereby the landscape team looked at the evidence that was provided, gave comments, there was back and forth discussion, which led to a position where the objection was removed.
Yeah, that's correct. I think I'll just clarify that by saying that was based on the evidence that was provided. And I think if the landscape officer had seen the additional evidence and the detailed work that I've now gone into, then he might not have taken that view, but I appreciate he took that view at the time of the evidence.
Well, there's a few things there. First of all, you can't give evidence on behalf of the council's landscape officer as to what they could have done.
That's fair, but I'm just making the point that he has considered what evidence was in front of him at the time.
Yeah, you're making the point, but I'm asking you to give evidence that the inspector can put weight on, and you don't know what's in the landscape officer's mind other than what we see set out in the consultation response.
That's fine, agreed. His comments are what is in this report.
Yeah, and as I said, that followed a process of dialogue whereby additional evidence was provided to the landscape officer to meet his concerns.
In this case, yes, I disagree with his conclusion, but yes.
Appreciate that, but he had dialogue with the appellant at this stage, information was provided.
Yeah.
And that arrived at a stage not whereby it was simply provided and the objection was removed. There was a process, and it was on the third and final go, if I can put it like that, that the objection was removed.
Yes,
Yeah.
that process happened. I think the only the difference is the coordination on that point is, he will be considering lots of applications with comments, whereas when you dive into the detail, when you writing a proof of evidence, you've got to go into a lot more detail. For instance, I had to go out and take my own photo montages. The applicant and the landscape officer wouldn't have gone to that level of detail. So I think there's a different level of detail of interrogation, I would suggest.
Well, that might be right in terms of the detail that you provided as proof of evidence for a planning inquiry where you're objecting to a scheme. But none of that prevented this officer from doing his job properly. That's not what you're saying.
I'm not disagreeing with what his conclusion was. I'm just making it clear to the inspector that he made that decision on the information in front of him.
Yeah, not all local authorities have landscape officers or teams, in fact, as they do in this case, do they?
I can't comment on the size of the team and level of experience because I don't work for the council. I assume he was qualified and he was appropriate to give advice on the application.
Yeah, listen to the question. Not all local authorities have landscape officers or landscape teams, do they?
That's correct.
Yeah. And so we can agree that this is an authority that had the benefit of specialist advice on landscape when determining this application.
Yes, that's not always the case.
And the landscape team for this council can be taken to have a good understanding both of the area and the policies which are relevant to consideration of the scheme.
Yes.
And we can see that because the consultation response on the first page of core document 48 engages with policy EM1 of the adopted local plan, which concerns landscape and visual matters and which you've addressed in your evidence.
Yes.
So we can agree they had knowledge of the area, knowledge of the plan, knowledge of the scheme, and this can be regarded as a thorough assessment of the scheme over a number of consultation responses.
I don't know whether I can agree with comprehensive. Everybody's under pressure within local authorities to provide advice, and a number of things, obviously, in my proof of evidence are maybe additional to what he considered as part of his overall assessment when he came to his conclusion. And everybody has individually to make a professional judgment, and he came to that professional judgment, and I'm not disputing that. But just because he came to that professional judgment doesn't mean that he considered all of the appropriate matters correctly.
Well, certainly the case officer thought he did, because his response was incorporated into the committee report and the application went forward on that basis.
The case officer relied on the information that was provided as part of the LVIA, and to a certain extent, the landscape officer would have relied to a certain extent on the information provided in terms of impacts. But he didn't do his own individual separate assessment. He looked at, and the majority of his comments were about how mitigation could reduce impacts, and went back and the to and fro. It seemed to me in relation to trying to increase the amount of mitigation to reduce the visual harm as part of that process.
The scope of works, the viewpoints, everything that was provided, that was agreed with the local authority in this case, wasn't it, in respect of landscape and visual matters?
It was. I agree with you there. I disagree that those were the appropriate viewpoints to have taken into consideration. I think there's additional viewpoints that needed to be considered, particularly within the site. And I'm surprised the landscape officer who was assessing it didn't pick up that there was no viewpoints within the site to assess.
Well, and you've provided those viewpoints now, so that this inspector has a whole complement of evidence that he can look at. But all of that, viewpoints, whether they are used as representative or whether they're to show an experience along the footpath, so taken at intervals along that, they are nonetheless only ever in an aid memoir for the decision taker when they go on site and actually have a look for themselves.
Yeah, that's one consideration, yes.
Yeah, but let's see if we can agree this, that competent landscape professionals acting on behalf of the council in that capacity took no issue with this scheme and advised the case officer as such.
That was the case with this report.
Yeah, and the recommendation was that the scheme together with mitigation was acceptable.
That was the case in this report.
Yeah, and not just acceptable, but what the officer says is it is a successful proposal.
I don't know how we qualify success.
But that was the view of the officer, wasn't it?
The case officer or the landscape?
The landscape officer.
You put me to which bit in the
Yeah, of course
it says that.
Sorry, forgive me, that might be the case officer. Sorry, I'll come back to you with that reference if I may in due course.
Can I just come back on one point? Because I've just read his comments. It is considered that once the proposed plan will remain looking to size and scale, and the latest amendments have reduced the overall area panels and from within locations which are previously considered home within landscape terms. So I think what he's saying is that there has been a reduction in impact. He's not saying there's been no impact.
No, but nonetheless, the officer thought this was an appropriate scheme, correct?
From these comments, yes.
Yeah. Document 41, please, if we can have a look at that. Let's go back there. That's to the committee report. And within that, please, if you can go to page 99. Yeah. Tell me when you have page 99.
Yeah, 99, yeah.
So what we see there is a paragraph beginning, the mitigation ensures.
Yeah.
Do you have that under the bullet points?
Yes, I do.
The mitigation ensures that the harm identified to landscape, character and visual amenity can be reasonably mitigated to an acceptable level in order to accord with the guidance set out in EN1 and the PPG. The enhanced mitigation package has also enabled the landscape officer to make objection to the implications subject to conditioning the new planting proposals. It is stated that no objection is on the basis that the increase in areas of structural, woodland and hedgerow planting would assist in integrating the proposed development into the broader wooded landscape in the vicinity of the site, largely mitigating the impact on the character of the area. The landscape officer also concludes that by extending areas of planting in visually sensitive areas is considered a successful proposal, and the soft landscape proposal should over time adequately mitigate any residual visual impacts. Do you see that?
I see that, yeah.
So the recommendation wasn't just that the scheme together with mitigation limits over the line of acceptability, it was in fact regarded as a successful proposal.
I can't see the connection. I know it's put in here in inverted commas as if it's been quoted from somewhere, but it wasn't in the landscape officer comment. So I'm not sure where that successful comes from, because that doesn't seem to relate to what he was saying in his own individual comments. Don't know if that's from some other document.
Well, whether it is or not, we'll try and find the source, but I'm sure that Mr. Duffer can have a look at that as well. But certainly the case officer endorsed that.
Yes.
Yeah, and that endorsement is a material consideration for this inspector.
It is, but as is the committee's decision to refuse the application on landscape grounds.
I understand that, but all of these things are going to be taken into account by the inspector, but it is a material consideration for this inspector that a qualified landscape officer on behalf of the council and a case officer, an expert in planning on behalf of the council, arrived at a decision that this scheme was acceptable and permission.
Yeah, I'm not disputing that it was recommended for approval.
Yeah, no, the question was not whether you disputed it, but the fact that it's a material consideration for this inspector.
I've already asked that and said yeah.
Yeah, and it's a consideration that weighs in favour of the scheme.
I think it has to be weighed up with all the evidence in front of the inspector. Yes.
If something's a material consideration, and goes into the decision taking, it's a consideration that has a bearing on the decision, right?
Yes.
So you've got to give it a weight.
Yes.
And that weight is either in favour of or against the scheme.
Yes.
Yeah. The fact that this has the recommendation of the council's landscape officer and the case officer in this case is a material consideration in favour of the scheme.
From those officers, yeah.
Yeah. And it also means that the council hasn't been able to rely in this process on its own landscape officers to give evidence.
No.
Because they found it was acceptable. When were you first instructed on this scheme?
I believe about October of this year,
So was it shortly before the CMC?
a few weeks before that, yeah.
Do you remember the date, or at least the week in October?
I can't remember the exact date. I can come back to that. I can come back to you if that's important.
Yeah, and how long after that instruction did you visit site?
Relatively quickly, because I needed to put a proof of evidence together, so I needed to come to site to assess whether I need to come in and assess the proposal in more detail.
Yeah, so if I can put it this way, you had accepted the instruction to act on behalf of the council, objecting to the scheme to inquiry before you visited the site. That's fair, isn't it?
In this case, that is the case. It's a long distance from where I live, but I did review all the evidence. I did go on to Street View. I did have a look at the landscape character areas. I did have a look at all the evidence in front of me. And in the past, if I've come to a site and I don't think I can defend the landscape grounds, I have said immediately, having done the site visit, that I can't defend this. And that was not the case on this site. So when I had come to site, I confirmed to the Basingstoke and the team that I was happy that the decision to defend the case was clear. And if I hadn't been, I wouldn't have continued the process.
Yeah, but after which time you'd already accepted the instruction.
Yes, but I have turned down instructions in the past where I got to site and found that it's not.
Sorry, I'll just interject at this point.
My apologies, I must have misunderstood the length of the. I do apologize.
Oh, sorry. I before around. Yeah. Last. Okay.
I do apologize.
Remember it. Your colleagues have taken notes of what's been said so far. So if you're wanting your questions for like a Palace landscape witness, in due course. And I think there's been 2 or 3 questions of notes.
Thank you very much, sir. And those to my right have very helpfully provided me with the reference called document 48. The landscape officer's consultation response. And it's on the second page of that response in the box headed comments. Tell me when you get there.
Document 48.
Yes.
Comment.
Yes. It's the second page of the comments, and it's the second bullet point. It says this, that the reduction in scale of the proposal and increase in areas of structural woodland and hedgerow planting would assist in integrating the proposed development into the broader wooded landscape in the vicinity of the site, largely mitigating the impact on character of the area, increasing the distances between areas of panel and public vantage points, and extending areas of planting in visually sensitive areas is considered a successful proposal, and subject to the detailed stock landscape proposal should over time adequately mitigate any residual visual impacts. You see that? Yeah. So that makes good the point about the fact that this is a successful scheme in the opinion of the landscape officer.
Yes.
Go back into the committee report then, please. Page 95. And you should see there the heading, just after halfway down, impact on the landscape character and visual amenity.
Yeah.
And what we're told in the very first sentence of this part of the officer's assessment is, it is nationally recognised that energy projects will have an inevitable impact upon the landscape. Therefore, the acceptability of a project has to have regard to the quality of that landscape and its capacity to accommodate change.
Yeah.
And you accept that's the case. It's the case set out in national policy that there is an inevitability
Yes.
to large-scale solar.
Yes.
And nonetheless, large-scale solar in the open countryside is supported as part of national policy.
Yes.
And you don't take an issue with all solar being, if I can put it this way, unacceptably industrial.
Sorry, can you put that question again?
Yeah, it's not your case that all solar farm development is unattractively or unacceptably industrial in nature.
I mean, I think it has got an industrial character and nature to it, in terms of the materials that are being used. I think the point that glass and steel and the structures are quite industrial in feeling, and I do also think that even though there is the need for solar, that where possible we should be looking to reduce the visual and landscape effects, and whether that be on brownfield sites or whether that be in locations which aren't adjacent to public rights of way. I think there can be a combination of providing large scale solar and having less impact than this proposal has, both in terms of landscape effects and visual.
And there can be places where the impacts would be far greater. Must be.
Yeah. I mean,
This is not the most sensitive landscape, is it?
Well, I think it has got a sensitivity to it. I'm not saying it's an AONB or anything of that nature, but what I'm saying is that on that scale, there is other locations which are less sensitive than this on a scale of sensitivity. There is sites which are higher sensitivity and other sites which are less sensitivity. So,
well, I mean,
on sensitivity, hopefully.
Yes, I mean, well, that's as trite as anything.
Yes.
Waitrose car park is less sensitive than the appeal site. It's a spectrum.
Yes.
Landscape sensitivity, yes. And there are much more sensitive landscapes.
And less as well.
And less.
Yeah.
It's about the ability of this particular site, not just to accommodate development, but to accommodate this development that is proposed with all of its constituent elements and mitigation planting.
Yeah, I think the point I'm making is that there's certain parts of this site which are less sensitive than others where you can have reduced impacts. I think that doesn't seem to have been taken into consideration as part of the proposal. I think the proposal has been, well, how do we hide, how do we mitigate, how do we screen, rather than thinking about those wider landscape sensitivities.
Well, I can ask Mr. Crash about that, because you haven't developed the scheme, have you? So he's the person to answer that question, and I'm sure we'll put you in due course. I want to just take this back and be very clear, because otherwise we are literally going to be going all day tomorrow. So we go with the questions that I'm asking.
Yes.
Point one, there is an inevitability to landscape and visual impacts that arises from large-scale solar.
Yes.
This is a government that supports large-scale solar, not just on previously development land, but in open countryside as well.
Yeah, I think I've said yes to these points already.
Yeah. And large-scale solar development is often located in the countryside.
Yes.
And in landscape and visual terms only, we can agree that it must be better to locate solar farms in areas that are not designated for their landscape beauty than those which are.
Yes, there's a scale that we've talked about.
And we know that there are no designations relating to landscape beauty or value covering the appeal site.
Yes, agreed.
And that's important because your own methodology places importance on those designations, doesn't it?
Yes.
And if we look at page 49 of your methodology, which is in Appendix 7, thank you for providing this at the end of last week. So page 49.
Yes.
You have there a landscape value table.
Yes.
And what we can see there is that you've ascribed good to this particular landscape.
That's correct.
Albeit, I think you fairly make the point that there are variations across the appeal site.
Yes.
And good, which you give the appeal site, we can see from your table, is of a type that is locally designated.
Yeah.
Obviously, this is not locally designated.
Yeah.
And in any event, we see in characteristics, it's a medium value landscape. That's the sort of landscape we're talking about when we look at good.
Yeah.
So despite not having a local designation, presumably, and I'm going to assume now, because its characteristics fall within the range set out there, this is a medium value landscape.
Yeah.
Forgive me, so that's where it goes. So medium value landscape is what we are dealing with when we consider the appeal site in totality. We agree, as you set out in evidence in chief, that this is not a value landscape for the purposes of the framework. And those are all factors that make this site more appropriate for large-scale solar development than a landscape that is of high value.
Yeah, if you're comparing it with a, A and B or a, and it's a difference, isn't there?
Yeah, or region landscapes with local designations for particular landscape reasons, they would have a meaning then or value ascribed to it by the framework.
Yeah,
This site doesn't have that.
There's a certain level of landscape designations, but I think also to take into consideration is those factors that set out in Glivia box 5.1 in terms of assessing landscape value. And this site has got some things which other sites haven't got as many of, for instance, the recreational value and that public rights of way that pass through the site, and some of the other aspects which I went through previously, which raise that. So it's not just one. It's not just one or the other. It doesn't have to have a local designation to establish it being good and not being good. It's a factor of has it got any local designations? What are the factors that went through in my evidence originally, and that gets you to the conclusion of a good landscape value.
Yeah, I appreciate all of that. I've read your evidence a few times. But when all of that brings us to is a medium value landscape, that's where we arrive at. Is we recognise there isn't a designation, we recognise it's not a valued landscape for the purpose of the framework.
Yeah, I mean, I think, and I use the term, I've used the term good rather than medium in terms of the overall landscape category value.
I understand that, but I'm trying to understand your methodology.
Yeah, sure.
This is what you've used.
Yes.
And that tells us when we're looking at characteristics that good is a medium value landscape. We're all used to using different descriptive terms, and perhaps medium, high, and low are the most common use, but there is certainly a synergy between what you have said is good and what we can understand to be a medium value.
Yes. Yeah.
Page 99 then of the committee report, please. You'll see the heading conclusion in relation to impacts on landscape character and visual amenity. You see the first, sorry, you then forget me.
On page 99, which bit?
Yeah, halfway down, conclusions in relation to impacts on landscape character and visual amenity. And it says this: it's inevitable that in this countryside location, a solar farm of this scale would impact on the landscape character and visual amenity, particularly at an early stage prior to the maturing of mitigation planting. In these instances, it is notable that planning inspectors have held that adverse harm or visibility in the public domain does not necessarily mean that a development would be unacceptable in planning terms.
Yeah.
And that's something you agree with, that simply being able to see a solar farm doesn't mean it's unacceptable in visual terms.
Yeah, that's fine, yeah.
And there is nothing anywhere in policy that I can see or that you pointed to that says all landscape and visual impact should be avoided.
No, but I think you've got to consider the landscape visual impacts in relation to the landscape character type, for instance. It's important to ascertain what the harms that are coming out of the proposal.
Yes.
Yeah.
Appreciate that. But we know, going back to this point of inevitability, if national policy or guidance had wanted to say that in all cases, solar farms must avoid all adverse landscape visual impacts, then it could have said so, and it doesn't, does it?
No, it doesn't.
No. National policy takes a far more balanced approach, which is about mitigating any harm that arises from schemes of this sort.
Yes, and that's where the probably the difference is the level of mitigation and what the impacts of that mitigation are, I think.
Well, one of the best and most common ways to mitigate the effects of solar schemes, as set out again in national guidance and policy, is through new planting. That's recommended.
Yes, that is one way to reduce impacts, but it's, as I made clear, it has unintended consequences of how you appreciate the landscape.
And we're going to come in look at those in due course, because again, you've dwelt on that extensively in your evidence in chief, and I think the inspector has your decision clear. I say that because you don't have to keep repeating your evidence. It's probably not helpful, and we've all got the point, and we'll make a bit more progress if you don't. But if we can turn please to page 100, and just look at the second paragraph there in the committee report, where she says this, that for this development at Bramley and in concluding on landscape impact, the effects of the development have been assessed to be at most of medium significance and of an adverse effect with mitigation. Equally, there has been significant local concern about, for instance, the impact on the local landscape character from the introduction of an industrial structure, the perception and enjoyment of the countryside and the length of time that mitigation would take to become effective. However, the site does not lie within any designated or valued landscape in framework terms, and the effects are localised given visual containment attributed to the topography and existing woodlands, such that the entire site is not singly visible from any one vantage point. So we can see that the officer had regard to local concerns, yes,
Yes.
but was satisfied that this was an appropriate place for new development.
I mean, it's not surprising, is it, if you've got something with a recommendation for approval that the committee report is going to set out why they think it's acceptable. I think my point is that I don't think that when the officer made the decision that they had enough information to, well, they had information, but I feel personally, from my perspective, that it didn't pick up some key aspects which I brought out within my proof. If they had taken into consideration, they may have taken a different point of view. And at the end of the day, the councillors who are considering decision making disagreed with the officer, and it's not for the applicant to convince the case officer, it's the applicant to convince members that it is an appropriate decision, which they were unable to do so as part of this planning application. So even though the officer thinks it was okay, councillors and members thought it wasn't okay, as does the local community. So I'm not disagreeing with the case officer and the landscape officer thought this was appropriate, but through the decision-making process, it was thought that it was inappropriate.
I don't know if there was an answer to my question somewhere in there.
I answered it at the start by saying,
The best way we can approach this is the questions asked. It's a fairly straightforward response to it.
Yeah, sure.
Give that response. If you wish to qualify,
yeah, sure.
What you say, then by all means, do so.
Sorry, I apologize. I thought I'd said yes.
We've gone back over things.
Yeah. I think why
will take up a lot of.
Yeah, sure. But the point I'm trying to make is that I agree that the officer and the landscape officer came to the conclusion that they thought the scheme was acceptable, and it's not surprising because they recommended for approval. The point I was making is that not everybody agreed with the officer and the landscape officer. Members, local community, myself in terms of my own assessment. So I've agreed with the point that you make about the officer. I'm just clarifying that by it's not unilaterally everybody agrees that this proposal is acceptable.
Yeah, we all understand how that
sure.
process works, and we know that officers' recommendation was overturned by the committee in this instance, but we've agreed that this is a material consideration.
Yes.
And what we have here is a detailed report to committee, correct?
Yes.
Yeah, it's not dealing with landscape in a cursory way. It's going not just through the landscape officer's comments,
Yes.
but it goes through local concerns and deals with them as well.
Yes.
There are pages on landscape and visual impact contained within this committee report.
But it's not going
Yes
to
or no?
Well, there is, yes, but what it doesn't do is doesn't go through the same level of detail as you go through when you're, for instance, writing a proof of evidence or doing your own assessment. So there's a different level of different level of consideration depending on what information is put for you. And I think the case officers relied a great deal on the LBIA to come to their conclusions in terms of their final assessment.
So forgive me. Yes, the LBIA, the scope of which was agreed with the local authority as part of the application process, and for which the authority didn't seek any further information. They were satisfied with the evidence that was provided by the appellant.
That is correct, yes.
And concluding on that, should probably just say as well, the officer is right here, and that in respect of the topography of the existing woodland, that does mean the entire site is not singly visible from one vantage point.
That is true, yes, but to clarify that, there is a number of places where you see more than one field, for instance. So when you're standing on the public right of way, you see into field 1, you can see into field 2. So you do get an appreciation of quite a large scale of development. It's not that you only see small amounts, and also the length of time you're seeing the locations. So you're walking for quite a long time across those fields. So the scale of it, even though you don't see all of it, you do see large parcels of land where they're going to be solar panels.
Yeah, well, we know that this is a 45 megawatt scheme.
Sure.
It's not a small scheme.
Sure.
It's not 25 megawatts. It is going to be a large scheme, a large solar scheme.
Yeah.
But nonetheless, it's absolutely right that the fabric of this landscape helps to break up that scheme so that you can't appreciate the full size of it from any one vantage point.
No, but I think I agree with you, but I think the point is particularly if you're on one of those long distance walking routes, you're passing through the landscape. So you see it in field 1 as you're passing through, you see it in field 2 as you're passing through, you then see it in field 6 as you're passing through. So there is a kind of, even though you don't see it all in one go, you do this kind of continuum. Oh, I'm still seeing solar, I'm still seeing solar, I'm still seeing solar as you pass through the landscape. And that is for a long, we've talked about 1.4 kilometres of route where you're passing. So that appreciation of the quantum within the site is large in scale and appreciation. The fact that it's broken up slightly by family thrift wood doesn't mean that you don't get the appreciation of the size and scale of the proposed development. It's not breaking it down to such an extent that you only appreciate it small elements or small sections of the route.
But there's a difference, isn't there, between, if you imagine a slope site where you've got a long distance view over a valley, you can see the entirety of the solar farm, all in one go, another sort of large 45 megawatt solar scheme. There is a big difference between that and the situation that we have here when someone moving through the landscape might have at points glimpses of the solar farm. They might be aware of it in their peripheral vision, but it's certainly not in their direct view. And then they will come alongside the panels, for example, at field 2 of 1 in the early years, and it will be more visible than it will be later.
Is that something that's best judged on site rather than through
Yeah, I think the only point
should we leave that to? I'm just wondering because that's not the site, is it?
So yes, although obviously the panels aren't there, but the straightforward point is this officer put weight on the fact that you couldn't see the entire solar farm from one vantage point.
I think I would disagree with you on this point because I think I've seen solar farms which are in the distance where you can see the whole lot in one go. But because you're probably, a kilometre away, and I would suggest that there's more visual impact here because of the proximity of the public rights of way as you walk along, and that continuum of seeing bits of solar panels through gateways and routes, and that has greater impact than the kind of mass of seeing something on a whole from a long distance view. I don't think you have to see the whole it's more about the kind of time and the experience of that person and passing through the landscape and how they appreciate that. So I think I don't agree with the point that just because you can't see the whole lot in one go means it's got less impact.
So that has no bearing on your judgment at all.
Not for me. It's more about people and how they experience it. Whereas if you see a big scheme from a kilometre away, you kind of see it, but it doesn't impact as much as if you're standing 5 metres or 20 metres away, and then you go through one field, you see it, go through another field, you see it, you go through a woodland, you see the gaps, and you see it again. That continuous, for me, that's it's not only the size and the scale, it's that continuum of seeing stuff, but also how long you experience that. So the kind of time element as you're walking through the landscape. So if you're walking all the way through from the north through field 1 around field 2 around field 6, it could be that you're experiencing that for 1.4 kilometres. You're probably experiencing that for a relatively long period of time as you're passing through the landscape.
For almost the same period of time that you're experiencing pylons, that you're experiencing the substation.
I think the only place where you really experience the pylons is in field 2. I think the substation is pretty well hidden within Bramley Thrift Wood, and field 1 has got no pylons in it.
When was the last time you went to site?
I've been about a month ago.
Right. So that is something best assessed on site.
Yes, okay.
We'll point the inspector to have a look at how well screened at the moment the substation is for field 2 when travelling south, because that's just not right. Can we go back to page 100, please, of the committee report? And you'll see the heading impact on strategic gaps.
Yeah.
So the paragraph above that I want to have a look at now. Furthermore, the site would not be viewed in combination with any other solar farm in the borough, and is also for a temporary period, with the effects capable of being reversed. A full decommissioning of the site is secured through planning conditions. Now, it is right, isn't it, that the temporary nature of this scheme and its reversibility are important material considerations when considering landscape and visual harm.
That is correct. I think I would echo some of the points that were made earlier today about whether this is going to be temporary and whether actually it will stay in existence longer than the 40 years. And that's
Hang on. Is that any part of the council's case? Or is that just you jumping on the objective bandwagon? Because I want to be very careful about that. If that's a new point in the council's case, then we're going to have to deal with it. But that's certainly not something that arises from your evidence.
it's not something in my evidence, I agree.
Right. Is it anything in the reason for refusal?
No, it's
Is
not.
it in the council's statement of case?
No.
Can you withdraw what you've just said?
That's a personal opinion, not a council opinion.
Are you here to give personal opinions,
No.
Mr. Wakefield?
No.
No. Focus again on this question, please.
Yeah.
The council have imposed or have agreed that conditions should be imposed as to decommissioning under the life planning scheme, correct? And that is a perfectly ordinary way to deal with solar farm decommissioning. You seem to have some experience.
I'm not expert in decommissioning solar farms, but I assume that could be a way of dealing with that.
Yeah. So let's assume that the conditions work, which is part of the council's case. That makes this scheme both temporary and reversible, doesn't it?
Over a 40-year, yes, over a 40-year period, which is not a significant period of time.
Nonetheless, temporary and reversible, and those are important material considerations when considering the landscape and visual harm.
Yes.
And it's one of the factors that supports development like this, apart from permanent development like houses or industrial units.
Yeah.
And that's a material consideration for the inspector.
Yes.
And it's a factor which weighs in favour of the scheme in respect of landscape and visual matters.
Yes.
Where do I find any acknowledgement of that in your proof of evidence?
You don't.
As to landscaping then, please,
Yeah.
page 101 of the commission report. Impact on the natural environment, landscaping. So this is a separate consideration for the officer. And we can see in the bottom paragraph of that page that the officer considered the provision of 6 hectares of new structural planting was a good thing, which he went on to explain would provide enhanced connectivity, biodiversity, green infrastructure and biodiversity benefits.
Yes, I don't disagree with those points.
Yeah, so we can agree that's a reasonable judgment for the officer to have arrived at.
Yeah.
And in landscape terms, new planting, additional biodiversity, green infrastructure, all of those things are generally regarded as good. I'm yet to meet a landscape architect who doesn't like trees.
Yes, I agree. I think, as I've already said, that there is unintended consequences of that, which and impact on landscape character also needs to be factored into that balance.
Yeah, we'll come and have a look at your unintended consequences and just how important the views that you say will be lost are. But the upshot of all of this careful analysis, was that the officer recommended approval in light of all of the application documentation and all of the consultation responses that bore on matters of landscape and visual immediacy. And that included consultation responses from Hampshire County Council on countryside access, having regard to the footpaths. They were content with the green corridors and screening planting, weren't they?
Yes, they were from their perspective, they thought that was acceptable, and I'm not contradicting that. The benefit of community rights of way and benefits of biodiversity are not too important. I think the point I'm trying to make is that they need to be balanced with the other landscape consideration, because great having biodiversity, but then if it has impacts, then they need to be factored into the planning balance effectively.
Yeah, so just so for your reference, it's called document 54, which is Hampshire County Council's countryside access application response. And they were, of course, aware that the public rights of way on site formed part of promoted routes.
Yeah.
And likewise, the British Horse Society, that's called document 52, they had no objection either.
I mean, I think that I'm not surprised there's no objection. If you're providing additional public rights of way, then it's not surprising the rights of way officers can be positive about that. And I think what it does is it will bring more people to use these routes and provide additional connections. So there will be more people. If there's more people, then there's more potential impacts on those people appreciating the landscape as they pass through, particularly in year zero construction when the solar panels are going to be very visible.
The recommendation that the case officer made in this case was on the basis that the scheme complied with policy EM1.
Yes.
And as we've agreed, no further information was requested by the council through the application process, and no issue taken with the methodology used in the environmental statement for the LBIA.
Yes, that's agreed. That's what the officer.
Yeah. And you haven't criticised the LBIA as part of your evidence either. Use a different methodology, but you haven't criticised the LBIA.
To be fair, I have criticised that there was no viewpoints taken within the site, for instance.
Forgive me.
Yeah.
Yeah, but that's to the methodological points. There's no criticism.
Not in terms of the methodology, no.
Now, there have been further amendments as part of the appeal process, and you tell us at paragraph 4.15 of your proof of evidence that that's what you based your evidence on.
Yes.
Now, those amendments have increased the setback of the array within field 1 from the footpath.
Yeah.
They've provided an enhancement of landscape screening between fields 1 and 2.
Yeah.
And additional screening along the southern edge of field 2 and the western edge of field 6.
Yes.
And it is right, isn't it, that those amendments as part of the appeal scheme set out in the council's opening do provide additional benefits over the scheme that the council refused?
Yes. But also they provide some disbenefits in terms of, and they don't overcome all of the impacts.
Now, just going back to the criticism you make of the viewpoints and location of photo montages, did you at any point prior to writing your proof contact the appellant to seek or clarify any of the points on those, or seek further information on further photo montages?
I didn't know.
No. Did anyone else from the council that you're aware of?
No, but the photo montages that I received them yesterday, the one particular one in the site. And so I've only received those at the very last minute. If I'd potentially seen those earlier in the process, I might have said, well, can we see another photo montage from a different location? But I didn't ask for them.
No, well, and you could have asked, couldn't you? Because one of your criticisms is that you don't think the viewpoints or the photo montages are appropriate from the positions that they're taking. You could have asked.
Yes.
Yeah, anyone from the council could have asked at any point and you didn't.
Yes.
Yeah, and the winter viewpoints that have been provided now, of course, they're constrained by the season.
Yes.
Yeah. Now, as we've agreed, viewpoints and photo montages, of course, are no substitute for a site visit. This is meant to be undertaken in due course.
Yes.
And that, together with the information he has been providing with all of the information that he needs to make his decision on his appeal.
Yeah.
Turning then, please, to your Appendix 3, which is your viewpoint location plan.
Yeah.
It probably helps actually to have your proof of evidence handy at this stage as well. on page 40. So just to orientate ourselves in this, page 40 is part of an assessment of all viewpoints that begins on page 38 of your landscape and visual assessment comparison. And that's where you set out this essentially the impacts on all the viewpoints that you come to, both the construction phase, year 0, open year, and year 15, once the mitigation planting has had an opportunity to take hold. Now we can see from your viewpoint plan that all but 4 of the viewpoints you provided are either in or directly adjacent to the site.
Yes.
And the furthest viewpoint away is viewpoint 16, I think.
Yes.
And when we turn to look at the photographs that you provided to support this plan, we can see that's 290 metres away.
I did assess and look at wider viewpoints, but because the wider viewpoints had been already done within the LVIA, and because I wanted to represent viewpoints that hadn't been considered in detail, particularly on the site in close proximity to the site, that's why I concentrated in those locations, because the inspector could already see the assessment and also as part of the statement of common ground, I think agreed that there's only minor adverse negligible impacts from this viewpoints that are over 500 metres from the site. So what I want to do is concentrate on the areas where there was differences, and hence the reason those locations were chosen, and also in relation to Givia's points about maximum effect scenarios being considered as an appropriate methodology. And I felt that there was gaps within the LVIA that needed to be identified, so there was a more truer reflection, and the inspector could then compare the LVIA assessment alongside these additional viewpoints.
To go back to the question, it was a really easy one.
I thought I said it at the start, hadn't I?
No, you didn't. Viewpoint 16 is 290 metres away.
Yes.
Yeah, there you go. 290 metres away, and we can see from page 40 of your proof, viewpoint 16, where we start out. And you can see why I'm going here, because it's the furthest viewpoint away, so it gives us a good idea of what we can see at distance and the impact is.
Yeah.
We start out at construction phase with a moderate adverse impact.
Yeah.
Moderate at year 0, and then that goes down to minor adverse at 15 years. So
yes,
we know that we're left with an impact that is not significant.
That's correct.
So we can agree that the highest visual impacts will occur in close proximity to the site.
Agreed.
And they'll diminish quickly as one moves away from the site.
Yes.
And what that means is that the visual impact of the proposal will be localised.
Yes, I think we agreed in a sense coming around within 500 metres of the site.
Yeah. And I think if we turn to the statement of common ground, it's probably useful just to pick up some areas of agreement between us. That's core document 94. Need to wait for the inspector to find it.
Yes.
I did so much. So just to check, sir, and likewise with you, Mr. Wakefield, if we turn to the back page, page 15, it should be signed both by both Mr. Asquith on behalf of the appellant and Mr. Townsend on behalf of the appellant. Just to check that that's the most up-to-date version, because there are different versions. I can already see the inspectors inside.
I do have a signed copy, however.
Great.
So it stands to defend.
Yes. So it's probably worth getting a copy that you have, sir, because there were different iterations and they're different.
I've got big blank.
That probably signifies that it's been signed then. So
Okay, okay.
yeah,
That one,
you can
that's
say-
version, yeah.
yeah. But see exactly. So this document, or document 94, or wherever anyone has it, that's the LPA statement of common ground with the appellant.
Yeah.
And you'll see section 6 on page 12 is headed matters of agreement.
Yes.
And it's got a number of points of agreement listed out there, 26 in total. Page 12,
Yeah.
Roman numeral 10, please. What that tells us is, it's agreed that as per the case officer report of the planning committee, the proposed development would be relatively contained by the wider landscape.
Yes.
And that's the point that we've just been dealing with.
Yes, it is.
We can look at, we can see uncontroversially, not new, point 8 is that this is not a valued landscape.
Yes.
Point 11, new planting as part of the proposed development is in accordance with management guidelines set out within the Basingstoke and Dean landscape character assessment.
Yes.
12, there is no local or national policy requirement to provide a minimum percentage of biodiversity net gain from this development.
Yes.
Relevant to obviously the conservation value of the landscape, which goes into the overall sensitivity. And point 15, there are no unacceptable cumulative or in combination effects known at this stage in advance of the determination of nearby planning applications and appeals.
Yeah.
So essentially, we're first in the queue.
Yeah.
Good. You can put that to one side. And I want to move on now to think about the nature of the development that's proposed here. Because the nature of what is proposed, this being a solar farm, is relevant to one's judgment on landscape sensitivity, correct?
Yeah.
And that's because when we think about susceptibility as a component of sensitivity, what we're concerned with is the ability of the landscape to accept the particular development without undue consequences for the baseline position. And so the susceptibility, it follows the sensitivity of the landscape, can be different for different types of development.
Yeah.
And a particular landscape might be capable of accommodating a solar farm, but not big VHS, for example. And that's obviously reflected in judgments on landscape sensitivity. So we've already discussed that this is both a temporary and reversible development.
Yes.
And in landscape and visual terms where harm will inevitably arise, that is a positive over a permanent and irreversible development.
Yes. Yes.
Solar panels are relatively low-lying compared to other forms of built development.
Yes, I think I just clarify that by saying there is a certain structures like substation, which I think are they're sort of, I don't know the exact height now, but 4.3 meters. The fencing, the battery storage. So there is aspects of the scheme which are higher than the sort of the 3 meters. The solar panels themselves. So.
The fencing is 2 meters. The other dimensions we can have a look at, but straightforwardly, they're not the size of a house, for example.
No, size of a bungalow probably for a substation.
Yeah, certainly not the size of industrial units or office blocks. And the panels are on frames above the ground. They are not, therefore, solid objects in the same way as those range of buildings that you might have as part of other developments.
Yes, I understand that's how they sit. I think that the only clarification to that point is that when they're seen in combination, they're not. I think there was a point about them being, the actual terminology was for it about them being not solid within proof of evidence. And I think the point I'm making is that when you see them in, if you just looked at the viewpoint of photomontage, for instance, when in mass, they can look very solid because they kind of combine with each other to make a mass.
But your whole point about that is that this is not a static experience. It's one of a person moving through the landscape.
Yes.
So insofar as you will get views, and obviously that will diminish over time as the mitigation planting matures, then you would see different elevations of the panels, and you would appreciate that these are not solid objects.
I don't know. I don't think I agree with that. They're not solid objects. They are solid objects. They're particularly going to be very visible, obviously, when they first go in, and even after 15 years mitigation, you only have to look at the visual you've provided, looking down the public right of way. Even after mitigation, you still see an array of solar panels en masse, which appear solid within the landscape.
The way Mr. Crack puts it is that they tread lightly within the landscape, by which you mean that solar development, unlike other, I can push it in this way, conventional developments that we're all used to dealing with, can be put in place and continue to respect the fabric of the landscape, that is the trees, the hedgerows, the soil even, because they're not built into the landscape, they're on the landscape.
Yeah, I mean, I think that's true. That unlike, you've got some deep foundations for a building, they're not the same as that. But I think there is a certain amount of compaction when vehicles are going onto the soil to construct them, and there is there is a certain amount of impact on the surface of the landscape in terms of being able to, and that whether that changes over time because of the mitigation and what I'm saying is it doesn't have even though it's what we call in treading lightly, it still has impact on the landscape.
Well, we wouldn't be here if it didn't.
No, okay.
But landscape and landscape character is made up of a number of different elements. It has a good deal of physical features. Part of that is the soil, the land use, the land cover, the hedgerows, the trees, the water courses.
Yes.
Most of those landscape features will be entirely unaffected physically by this solar scheme.
Yeah, I'm not saying that you are.
The ground disturbance, I think, would be about 4% of the overall site area.
I don't know if that's true or not.
Yeah, well, it's in the evidence. It's in the council's evidence in Mr. Massey's proof of evidence at 7.5. Want to go and check it, but the straightforward point is that it's a very small portion of the site, the ground, that will actually be disturbed by the scheme. Solar farms are not the same character as traditional industrial development. Most closely related, I suppose, power stations. Agreed?
Yes, agreed.
Yeah. Unlike power stations, and taking on board all that you say about the way in which this will be perceived, solar farms are nonetheless visually permeable to an extent.
No, I don't disagree with that. If you just look at your own photo montage looking down that view, that's not, you can't see through it. And there's not in certain locations you don't have any gaps, it overlaps. There may be points where there is you can see through.
Well, I'm confused as to your point, because your whole point is about moving through the landscape.
Yeah.
And you made a big point in your examination in chief about talking about seeing the underside of the panels, the side of the panels. You are going to see panels from different directions and elevations, correct?
That's true, because it means that they're not solid. Because even if you're looking at the back of them, you're still seeing the back of what is quite a big structure of the panel, whether you see it from the front or whether you see it from the back. You might see down a line, for instance. So you've got a panel. There might be some invisibility between the line of the panels, but you look at the relationship between a lot of the views from the right of way. You are seeing them, because particularly if you're walking north and you're looking at panels which are facing south, you're going to get that impression of particularly in field one, as we've already talked about.
Let me be clear about it in this way. One of your points is that this is industrial development.
Yeah.
this is development, of course. We know is supported by the government to go in countryside. It has obviously a very different character to traditional industrial installations, doesn't it?
Depends what you're comparing it against. If you're comparing it to like a retail warehouse, yeah.
Yeah, they don't have moving parts. They're inherently quiet development.
Again, I don't know my knowledge of the noise from, I don't know, the substation, for instance. I'm not sure. I'm not making that point as an issue.
Yeah, this isn't a noisy development, is it?
No.
No, it doesn't have moving parts.
No.
It's not going to have lots of people coming and going to and from the solar farm every day in the same way that you might have employees going to a factory, for example.
Yeah, that's what I say.
And it is fair, isn't it, that not everyone who sees this solar farm will perceive it as an adverse feature in the landscape, because some people might be quite happy to see solar development and what that means for climate change.
That might be the case, and I think sometimes when I see solar panels within the landscape and it's well integrated and it's not right adjacent to public right of way, I might agree with that. Seen a scheme recently in Warwickshire where that's the case, and the reason it feels appropriate is because the distance from public rights of way and that it's seen as part of a wider landscape, and the distance it looks like it looks like a kind of wooden block even in terms of the darkness of the panels in the kind of mosaic of fields across the landscape. Not the case. The proximity is the issue for me, particularly on this side, where you're seeing the underside, where you're seeing the panel very closely, which create that kind of more negative impact of the proposal in relation to whether you're a fan of solar and you see the benefits of the carbon. It's you can still, think.
Yeah, it would be wrong to assume that everyone would feel upset about seeing these panels in the countryside.
Yeah, I think. Yeah. Yes, I agree with that point. I think the point I'm trying to make is that I think you're less likely to think that if they're in a location which is further away from the rights of way, like you're seeing them at a distant viewpoint, they're not. And I think there is appropriate times where that happens, and you go, great, we've got solar, but it's not as impactful.
I mean, some people don't fit into the wind turbine station to the way built. It takes all sorts. But in any event, this is a development which has a dimension that is contributing towards tackling climate change, which might be regarded by some as very positive.
It might. I mean, I haven't done a survey of what the balance is between people that think it's positive and which people think it's negative.
And conjecture here.
So, but potentially, but the reason I raised that is because it was a point made by Inspector Major in Felden Vale at the decision. And there is a difference. The point I'm trying to extract, if I can put it straightforwardly like this, there's a difference between the nature of the development, solar development and the traditional industrial development, and the way in which that might be perceived by receptors, people in the landscape.
Yeah, I mean, I think if this was having warehousing all over these fields, I don't think you'd have got a recommendation for approval as part of a committee report. So, it's a different, it seems a bit bizarre to compare this with that, because that would never be that flood would never be appropriate on these fields.
And that's exactly the point, Stoyfield. That's exactly the point.
So I don't understand that, because why is that the point?
Well, I'm not sure if the witness should be.
Sorry.
So it's also not appropriate to comment on the answers.
Well, indeed. If you want to rephrase a question, I'll have an answer to it.
Well, what I'm going to move on now actually is to look at the receiving landscape of the appeal side, specifically, if I may. And there is generally within the appeal side, within the red line, an absence of development, although there are very large visible pylons in many of the views.
Yeah.
And when there are open views, particularly I want to think about field 2.
Yeah.
When there are open views, you separate that out as one of the views in your proof of evidence. I think it's the longest distance view that you highlight over 700 metres.
Yeah.
the most prominent part of that view is the pylons.
Which viewpoint are you referring to?
Well, let's go within the group. I think it's Appendix 4. Forgive me, it's not. It's Appendix 5, landscape visibility. And I think you've marked it as 5 at 720 metres view line.
Yeah.
So that's a view. Can I say broadly from west to east in field 2? Yeah. Anyway, by the way, the most prominent feature in that view from field 2 is the pylons.
Yes. But you still get that long distance view in those pylons in the field. In that view is what you're appreciating as existing now, isn't it? Those pylons already there. So, yeah. But
yeah,
but if you looked at viewpoint 3 and 4, the focus for me on those was more about the woodland across the other side than necessarily the pylons. So I don't think necessarily the pylons completely dominate that landscape view. I think in certain locations, they've already identified 1 and 2, you don't get a view of any electricity pylons, you get that wider view across the landscape. And that's why I think particularly field 1 is quite sensitive. Discussion.
Well, I think whether something's prominent or dominant, you need an inspector and a site visit to consider the nature of that view.
Yeah.
But even when you're in field 1, I mean, you selected a particular direction to view there. The inspector will note what he can see, but he will also note there is some low-level industrial park development, business park development, certainly to the west of that viewpoint.
Sorry, which viewpoint's that from?
When you're in field 1, you set out 1 and 2, but looking in the other direction, looking west, southwest, we can see Haynes Farm there, and I think that's a business park, isn't it?
Yes.
Yeah, so these are not sort of, the view that one gets walking around this landscape is not bereft of existing development, whether it's turbines or something else.
Yeah.
And going back to the pylons, if we can, obviously field 2 is where they are most prominent, but there are also 2 large pylons that are visible on the western boundary of field 6, right adjacent to the footpath. So when you're walking through the wood,
yes,
you walk under the lines of the pylons alongside field 6, yes?
Yes.
Yeah. And so again, that is something that is characteristic of these journeys, that's characteristic of the red line field sites.
I think my comment there would be, though, on certain parts where you're passing where the pylons are, there is quite a buffer there, isn't there? To think that wasn't the most prominent part of field 6, as I remember, but we can have a look on site.
Yeah, again, the inspector will walk that path, he'll hear the crackling above him, and that should give him an indication as to where the pylons are. But in any event, they are characteristic. Pylons are a characteristic of the red line of field site, are they not?
They are in fields 2 and 6, but not necessarily fields 1 and 4.
Yeah, but in any event, looking around this landscape, you can see pylons.
Yes.
Yeah. Where in your proof does that get a mention at all in respect of the characteristics of the site?
I think if you look at my viewpoints, I put the pylons into a number of the viewpoints and I look at viewpoint 26, there's I pick out existing pylon.
I'm asking for your proof of evidence because there's only one place that I can see it gets a mention, and this is page 23.
Well, my proof of evidence is made up of my proof of evidence and my appendix. That's all part of proof of evidence.
But you're pointing to viewpoints now.
Yes.
Forgive me. Let me be clear. I'm looking at landscape character effects.
Yes.
Okay, so we don't mix the two.
What I'm saying is when I take those viewpoints, and I don't just use those viewpoints, those photo montages to do the visual assessment. I use them when I'm thinking about having been to site, walked the site. I then refer back to those photos to consider the landscape effects. I don't just use them for visual. I use them as an aid to understanding character as well, because they're very useful. And that's why I've identified, viewpoint 19, existing pylon in field 2. I then talk about it in the description. And then obviously refer to it within the proof to a certain extent. You pointed, where did you want to take me in my
Page 23.
Yeah.
You'll see at 6.2, you say some intrusion caused by electricity pylons and lines in field 2.
Yeah.
That is not the only part of the field site that pylons affect, is it?
I think for me, it's the field that they mostly affect, because I think you've got that open character within that field. And that's where you see the most from. I think field 6, you don't appreciate them much because you're walking along the track to the south, and then majority of field 6, you're walking through a woodland. So your predominance is you're walking through that wooded character. So you're not as aware of the pylons as you would be in field 2. So I would say, field 2 is where they're most dominant.
Again, I think you're possibly conflating visual and landscape character impacts. I'm dealing with the character of the site.
Yes.
And looking at the elements that fall within the red line.
Yes.
Pylons is obviously a very clear characteristic of this site. Agreed?
Yes, and I think I've accepted that there's pylons in field 2 and field 6.
And if people moving around this area as well, depending on which part of the footpath they're on, will be aware of where all these pylons are going to with their wires. They very obviously converge on the substation.
Yes.
And of course, as we pointed out, the inspector will see moving southwards there's been some woodland clearance on site, something to observe on site visit, which makes the substation a bit more visible. But certainly it's something that people will be aware of as they're moving around these footpaths.
Yes.
This is a landscape that already contains energy infrastructure, isn't it?
Yes, but that's the same as quite a lot of landscapes.
Well, it contains energy infrastructure, and energy infrastructure is a part of the character of the appeal site.
Historically, it wouldn't have been. That's obviously been an intrusion within the landscape over time. So when you're considering landscape character, there's obviously landscape character of how it's evolved over time. The character assessment. But yeah, it's part of the character now. But again, it doesn't mean that it's a positive element of the character. So that needs to be factored into your decision on impact, just because there's something large and obtrusive doesn't mean then by adding more of that, then improving landscape character. Was that
the point I put to you, Mr. Wakefield?
Sorry, repeat the question.
I think what you said roundabout way was that yes, and that's part of the character.
Yeah.
That was the answer to the question.
Yeah.
Did go on.
Sorry.
So we
just
just need to be careful about
Yeah, the energy infrastructure is part of the character of the appeal site. Now, no one's suggesting that means that if you put solar panels here, it will improve that position.
Yeah.
Albeit there will be increased screening and mitigation planting, which is absent at the moment, meaning that those pylons are prominent from top to bottom. But the straightforward point is this: compare and contrast this site with its existing characteristic of energy infrastructure to a site, a remote rural site with absolutely no characteristic of energy infrastructure, no lines, no pylons.
Yeah, but that's
forgive me, I have an additional question. That site would have a greater susceptibility to new energy development than this one.
It's very hypothetical. What site that theoretically, yes, but
I want to finish off before we break for the day on some other elements of the site that combine to give it its overall character. The site you described as undulating, that is relatively flat. It's certainly not hilly, is it?
No, I'm not saying it's hilly, no.
And flatter sites are something that favour solar development because it makes it easier to screen.
In some instances, yes. I think sometimes you can use topography as a positive aspect where, for instance, I think in field 6, particularly to the north end of that field, because the topography dips, you lose a lot of, you lose some of the solar within the landscape. So topography can work both ways. It can be a positive and it can be a negative.
Depends where the viewers are.
Depends where the viewers are, yeah.
And can I put it this way, that if this was a scheme of just fields 3, 5 and 6, you could be taking an issue with it?
Field 3, sorry, which fields to say again?
3, 5 and 6.
6. Yeah, providing there was additional buffer planting to the public right of way to the left of field 6. I think they're least sensitive of the fields, as I said, I'm not approving of it.
Yeah. This is a well-wooded landscape.
No, I don't think it is. I think if you look at the local landscape character area, it is an open landscape with a series of woodland spinneys as part of the landscape character. But the general character, particularly if you look at the historic plans within my Appendix 1, you'll see it's been an open landscape, not a wooded landscape, for a long time.
Just help me with this.
Okay.
We've got landscape character areas which cover often very large areas.
Yeah.
This inspector will obviously have regard to that as part of the overall evidence, but what we're most concerned with is the appeal site and its appearance.
Yes.
And of course, it's immediate context over which the development will have a bearing.
Yeah.
And there is a ubiquity of medium to large woodland blocks in this area. That's correct, isn't it?
There is some woodland blocks in the area, but if you look at if I could take the inspector to the historical plans, to the historical plans in my group, which is Appendix. Yeah, I think. Particularly, you take me to. If I took you to figure 1.2 to start off with, you can see on that plan that the forest to the left, you can see Bramley, Walnut Bramley, you can see Bramley, effectively where Bramley Driftwood is. But in between that three ashes, a landscape, and this was in 1902, the landscape was very open, rural, the lack of woodland character, very much an open landscape. And if you then go on to look at plan 1.3,
yeah,
and 1961, you can see the Roman settlements above, spot the landscape. You can see Bradley Driftwood to the south. You can see a series of spins that, when you actually look at the site itself, it's very open. All the fields are open. They haven't got any woods on them. The only woods are outside of the site, and particularly the character area is defining this kind of open landscape with a series of woodland copses which exist. And I think that's one of my fundamental points about mitigation and this kind of creation of this woodland character across the site, not necessarily being appropriate in terms of this continuum of landscape character, which over many years has been open and agricultural in nature, being then enclosed by belts of woodland.
Well, it's not 1902, it's not 1961, 2022.
Well, we can look at a plan of 2022 and the same will be the case. I'm happy to look at the site location plan. The woodlands hardly changed since 1961.
Well, we have in the immediate vicinity of the site, Bramley Driftwood.
Yes, that still existed in 1961.
We've got Davenage Copse,
Which existed in 1961.
Winnie Copse,
Existed in 1961.
Little Hollands Copse.
Whereabouts is that actually? That's the Liverpool one. Yeah, that's that existed in 1961.
Yeah. And we've got tree belts, tree lines, hedgerow planting all around this area. There is an ever-present characteristic of trees and hedgerow.
There is outside of the site a series of woodland, ancient woodland that's been around for hundreds of years that is visible within the landscape, denying that woodland isn't part of the character. But the actual site has been very much open in character for hundreds of years.
Well, you say that actually, but just take a minute on the 1961 plan.
Yeah.
Many of those field boundaries have been lost.
Yes.
That would have given the appeal site a more closed or wooded character than it has today.
No, I wouldn't say it's a wooded character or enclosed character. The character of those hedgerows is the landscape character area says is very much well trimmed, mature.
Well, that's today. That's not 1961, is it? That's looking at hedgerows today.
Yeah,
whether that applies to the appeal site or not is something.
I don't think you can equate a hedgerow, a lost hedgerow, as a woodland within the landscape in the site. You know, there wasn't. It's not as if in 1961 there was lots of woodland belts across the site that have been lost, and now you're putting them back. These things are new proposal, and the reason these woodland belts are being put in is because you need the screening proposal, not to reinforce the existing landscape character.
This appeal site is reinstating two historic hedgerow boundaries, isn't it?
In field 1, I believe that's proposed. I don't think in field 2 that's happening. I don't know. I don't think in field 6 it's happening.
Look at field 2 again.
Yeah.
Hedgerow planting, where that boundary's been lost.
Yeah, but it's not in the same. It's not historically replicating. It's basically got the V-shaped hedge.
Different line.
It's a different line. It's not. You're not putting back what was. So
but field 1, that certainly is the case.
But that's quite alien, isn't it? Having a V-shaped hedgerow within the landscape. You know, it would have been probably preferable to follow the kind of historical pattern of the landscape in that location.
What it means with the woodland today, and I'm going to leave it to the inspector to consider whether or not she regards this as a well-wooded landscape. I certainly know what this practically is. But the effect of that hedgerow and tree planting that we see in the landscape today is to prevent longer distance views, and that's why we know that the visual effects of this scheme are localised, because those views are cut off by existing hedge and tree planting.
No, I don't agree with that. I think the point I'm making is that the woodland that you see, the visibility across the landscape, is of these ancient woodlands like Bramley Driftwood, like with the corner of the other ones that you can hardly read on the plan. So by introducing additional woodland, it changes that character.
Again, I'm, as a visual point, I'm going to leave that to the inspector to have a look at that. But in any event, the reason why we don't have big, open, long-distance panoramas in this landscape character area within the red line and immediately adjacent to it is because of the level of planting in the landscape, because of the trees, because of the hedgerows.
Because I think if you look across the site, the intervisibility across the landscape, where you're getting views of 750 metres, 3/4 of a kilometre, half a kilometre, I think the landscape character assessment talks about moderate intervisibility across the landscape. So some of that moderate intervisibility will be lost as part of this proposal, and you are reducing it to short, as I've expressed already, short visibility across the landscape by putting in mitigation which then screens views.
Just help me with this. When I stand on the appeal site and I look outside the red line into the wider landscape, what is it that tells my view?
You see,
what is it that curtails my view? Is it buildings? Is it hillsides? What curtails my view?
It's a mixture of things. It's woodland that runs along the Silchester Brook. It's particular copses of trees which are distinctive within the landscape. It's the undulating. It's the what we'd expect to see in the countryside. Farmsteads, a whole series of elements. You see individual dwellings. There's a mixture of elements within the landscape that you appreciate. It's not just, you don't just see woodland.
Woodland and trees is the primary means of enclosure in this landscape, isn't it? It's the main factor which curtails long distance views.
Well, it's probably a mixture of topography and hedgerows with some woodland. I wouldn't necessarily just focus on woodland as being in the
Okay, trees and hedgerow are the main forms of enclosure in this landscape.
Yeah, that's probably fair.
And a good place to stop. Thank you.
Just while it's in my head to ask, do I understand you to say that? No, okay, sorry. Do I understand you to say that, as far as you're concerned, the greatest value the landscape has is its recreational value, and the greatest impact of the proposal would be upon the visual receptors using that, the recreational aspects of the landscape? That's fair.
I would say that is one of the key aspects, I think, that's coming out of the proposal. But I think the other aspect for me is this shortening of views across the landscape, appreciation of where the ancient woodland is and how you understand the landscape.
It's just gone 5:10. Thank you all for taking me the course. We agreed to start back tomorrow at 9. We're also allowed to leave things within the which should be secure. On day one, I don't think I'm expecting anything to come forward this evening, but there will be some work done in the provision. Also, did you get a chance to take into consideration amendments to the site visit itinerary?
So I've got the list of points that were raised this morning, and we will try and compile a new plan. I don't know if there will be more points coming out from representation we might hear on Thursday from other members of the public, so it may be worth waiting until that's been, we've got through that session to know exactly where everyone else wants us to see, but I've got a running list going.
I think you're right. I think there will be more suggestions. It's just at the moment it occurs to me that because several people have come forward saying, please come view from my property, it might be best to get the list up sooner rather than later, so they can make sure their request has been taken into consideration. Can that go onto the council website, and can the timetable as agreed to go onto the council website?
I'm sure that both of those things are possible, and what we can do is put on the document we had this morning, which I'll hand in, and being clear for anyone who's listening to the webcast that that's subject to a few further updates, but it's an idea of what's being proposed at the moment. And in terms of the timetable, yes, of course, that can go up as well. I think we will catch up tomorrow what we've lost this afternoon.
Okay, that being the case, it's just coming up to 5:15. Let's adjourn for the evening and resume tomorrow at 9:30.